Court discussed with counsel this morning the final draft of the jury instructions, and that final draft with correction should be made to counsel after the arguments today. Are we ready to proceed?
Yes, sir.
We can bring the jury in, please. Would counsel stipulate, please?
Yes, Your Honor.
Yes, Your Honor.
Good morning, ladies and gentlemen. The court will explain how the proceeding will be scheduled today. Today is scheduled for closing arguments. Each side will have 1 hour to present their closing arguments. The state will have 1 hour. However, the state will have an opportunity to divide its argument into two parts. So the state will argue first, then the defense. The defense will have no second opportunity to argue, and the state may then close its argument. Are the parties ready to proceed?
Yes, Your Honor.
Attorney Manning.
Thank you. Good morning, ladies and gentlemen. I just want to start by saying thank you. Thank you for your time and attention over the past 6 weeks. I have an opportunity to speak to you now, and then the defense will go, and then Attorney McGinnis will speak with you one last time. Then our job is done and yours begins. I'm going to start by talking about one thing that the evidence shows. Jennifer is dead. Let's be very clear. She was murdered on May 24th, 2019. There's blood spatter throughout the garage, throughout the undercarriage of 2 cars, footprints and swipes of blood. Her blood-soaked shirt and bra thrown out in the garbage on the streets of Albany Avenue, along with zip ties, sponges, and duct tape. Make no mistake, this was a deliberate, intentional murder. The evidence of Fotis Dulos taking his employee's car at 5:35 in the morning, driving down the parkway, secreting it at Waveney Park, and riding a bike to lay in wait for Jennifer. He did those acts because he planned to hurt, assault, to restrain her movements, and to kill her. Jennifer did not run away from her family, her friends, her 5 children, as the defense would like you to believe. She did not run away from her family, leaving her blood-soaked bra and shirt. She didn't hide in Waveney, head towards the train tracks. You heard the defense questions throughout the trial about that. Or try to make a call or get service with an old phone at Waveney Park in the afternoon on the 24th. The defense would have you believe she ran away from her kids, but she did not. Jennifer is dead, and Fotis and Michelle Traconis intended that to happen. They agreed to work together to make it happen, and unfortunately, they were successful in making it happen, but they got caught. This trial is very simple. It's about a conspiracy and about a cover-up. It's about Michelle Traconis' actions and about how she and Fotis Dulos conspired together to murder the woman who was standing in their way. It's about the frustration of Fotis Dulos not seeing his kids for over 1.5 years, about not seeing his kids and having a supervisor present for 1.5 years. And every time those kids came around, Michelle Traconis had to leave her home. She had to take her daughter somewhere else. And we know she was sick of it. The frustration turned to anger and hatred. Listen to her own words in the interviews. How she describes Jennifer, someone she has never met. She describes her as manipulating, angry, toxic. And we all remember the comment to Pavel, that bitch should be buried next to the dog. As you heard Mike Mean and Mike Rose's testimony, each attorney tried to tell her there's a light at the end of the tunnel. Because we know what she thought about the 2 years of the custody case, about the 2 years of court hearings. She described it as 2 years of torture, that it was a nightmare, and that she was going to leave. But that light at the end of the tunnel, I submit to you, wasn't another court hearing, because there was a court hearing, and nothing changed. As of Wednesday, May 22nd, Fotis Dulos still had to have a supervisor present. Nothing changed. So they were going to make it change. After all, why would they be toasting at a dinner party on May 23rd? Why were they happy, excited, if nothing had changed? Because they were going to make it change the next morning. The defendant and Fotis Dulos conspired together to commit the crime of murder of Jennifer Dulos. That is count 1. The elements that comprise the charge of murder are an agreement, that the defendant specifically intended to agree with Fotis Dulos, and that agreement was to engage in conduct that constituted the crime of murder. That's intent to kill and do kill. That there was an overt act in furtherance of the conspiracy. Why did we spend so much time on Fotis Dulos the past 6 weeks? Because that's an overt act. And there's an intent requirement. The defendant had the intent to commit the crime of murder. So how do you know somebody's intentions? How do you know their motive? You look at what they do. You infer their motive, their intentions from their behavior. Look at what she did. Look at what Michelle Troconis did. Her acts, her behavior during the time of the murder. Look at what she did, her acts and behavior before and after the murder. Look at when she did these acts. Look at what she said. Look at what she didn't say. And look at what she lied about. Now, the plan started on that Wednesday, May 22nd, when Fotis Dulos arrived an hour early. This is the person who Stefan Reich said had his own Fotis time. And then on Thursday, May 22nd, 2019, before the dinner party, remember when is important as well. Remember Pavel Gulmini's testimony that Fotis Dulos told him he had to drop the car off at 80 Mountain Spring Road, the Toyota Tacoma. Right? This, I submit to you, was in order for him to be able to leave early the next morning, and nobody would know. After drop off, Fotis goes to the grocery store to get more meat. Remember that testimony? But what does he do while he's there? He sets up the alibi call. His good friend, Andreas Tucciardis, his good friend who coincidentally does not cooperate with the police. Why do you think he doesn't cooperate? Look at the timing. The text message that was set up. It was done at 5:53 after he had already moved the car. And it says, call me. The defendant and Fotis Dulos have their dinner party. Hutch Haynes, his wife, the Reichs, there's a celebration, a toast to the light at the end of the tunnel, but they had already moved the car and they had already set up the text message. So what were they toasting? Well, they were toasting what they were going to do the next morning. After the Reichs left and the Haynes left, what happened? The defendant and Fotis Dulos solidified their plan. At around 10 o'clock in the evening, they texted again. Fotis Dulos texted his good friend from Greece, specifying the time, 3:30 yours, which is 8:30 in Connecticut time. Just enough time for Michelle Traconis to drop her daughter off at school and return to 4 Jefferson Crossing to answer the call the next day. A call she knew what time it was coming. Is it just coincidence that she happened to be in the office at the exact moment that Fotis Dulos told Andreas Gutierrez to call him? Or is it reasonable, based on the motive and based on the evidence, that she knew what time that call was coming and she made sure to answer it? Now, early the next morning at 5:35 in the Fotis Dulos leaves 80 Mountain Road, and he drives to New Canaan in his employee's Toyota Tacoma with a bike in the back of the truck. And he leaves his phone with Michelle Traconis. This is all evidence of Fotis Dulos and the defendant's intent to murder Jennifer. And that murder is the overt act in furtherance of the conspiracy. But Fotis Dulos needed help to commit that murder. He needed an alibi. He needed the defendant. So what is the defendant doing while Fotis Dulos is driving down to New Canaan? When he's southbound on the Merritt Parkway at the Fairfield Rest Area at 6:36, or at the New Canaan Rest Area at 7:03? What about when he's riding a bike up Weed Street, the direct path between Waveney Park and 69 Wells Lane? Or at 7:57, when the school bus camera captures that Toyota Tacoma secreted in a cutout across from Waveney Park? Or at 8:05, when Jennifer returns home after dropping her children off, the last time they will see their mother? What is the defendant doing while Jennifer is being assaulted and killed in the garage of 69 Wells Lane? Fotis Dulos' overt act. Remember, Michelle Traconis doesn't have to be at 69 Wells Lane. She is not charged with the murder. She is charged with conspiracy to commit the murder. It's Fotis Dulos who committed that overt act. Remember Mark Davison's testimony? There were a minimum of 2 impacts. This wasn't a fall where she hit her head. We saw the blood splatter on the car, on the undercarriage of 2 cars, the garage floor, the garbage cans. You can make the reasonable inference that this was an anger-driven assault on Jennifer, and she died as a result. Then there's the cover-up, the cleanup in the garage, the swipes, the paper towels that were missing that Lauren Almeida put out the day before, the bucket that was missing from the garage. And don't forget the DNA on the faucet. Recall Matt Riley and Kristen Medell's testimony. Matt Riley took a swab off of that faucet because there was a blood-like stain that in his training experience he determined was evidentiary, and he took a swab from that blood-like stain, and it contained Jennifer and Fotis Dulos' DNA 4.3 billion times more likely to occur. Recall Kristen Medell's testimony on that. Did that blood-like stain, well, let me ask you this. Did that blood-like stain with Fotis Dulos' DNA come from a cake 2 days before? Or is it more likely that he missed the spot? After he is done cleaning up the garage at 10:25, Fotis drives the Suburban away from 69 Wells Lane. At 10:30, it's in the same direction en route back to Waveney Park, where it is later found by New Canaan PD with the battery dead and the car in reverse. Drives back the Merritt Parkway. Remember Trooper LeBeau's testimony? You make the call. It's your opinion, your memory that controls. But I submit to you, this is a bike in the back of his truck. And don't forget the Tour de France imprint on the tape that was found out of Hartford. During this entire morning, Fotis Dulos doesn't have his phone on him. Why wouldn't he want his phone on him? Well, there's 2 reasons. 1, he doesn't want his location tracked. I think that's a reasonable inference you can make. But 2, he needs somebody to manipulate it. He needs somebody to manipulate it at 4 Jefferson Crossing so it looks like he is home. So it looks like he's taking a shower. So it looks like he is in the office. So it looks like he is answering calls. We all know who that someone is. Michelle Traconis. Look at all the text messages that were not answered that morning and all the phone calls that were not answered except for one, the planned one. Make no mistake, she knew exactly what she was doing when she answered that phone. How do you know? It was planned, the timing, but also she doesn't talk about the call at all in her first two interviews. After all, the call is not on her alibi script, and make no mistake, we call them timelines, but they are alibi scripts. That call is not on her alibi script. A lot of other calls are, but conveniently that one's not on. It's on Fotis's. After all, it was supposed to be his alibi. Are all those things consistent with the defense's theory that she didn't know anything? I submit to you, they're consistent with one thing, her guilt. By the way, at 10:25, when Farber Dulos is driving Jennifer's Suburban to Waveney Park, Fotis's good friend, the one who called at 8:26, coincidentally sends this meme.
Good choices. A, you can spend the rest of your life with your wife.
Why is he sending that meme at that time? Coincidence? Or does that just show the intent behind that 8:26 phone call? User manipulation. Mike Clark testified that when somebody manipulates the phone, they turn it, they unlock it, it gets recorded. Now, the only person who could have reasonably manipulated Farber Dulos' phone that morning is Michelle Traconis. There's some evidence of Kent Mawhinney. He came to the office at 7:21 and 8:41, but the phone was manipulated before 7:21, before he arrives, and it was manipulated after he leaves. The defendant is the only person who could have reasonably manipulated that phone, and the only person who had reason to manipulate that phone. At 6:44, the phone is unlocked. 6:45, 6:46, it's turned. Orientation change, 7:01. 7:01, the phone is unlocked again. 8:07, unlocked again. All this while he is en route in the Toyota Tacoma and on the bike and in the garage. At 8:26, she answers the call and puts it on speakerphone. At 8:31, it's unlocked again. And at 9:03, after Kent Mawhinney leaves, it's unlocked again. This is the conspiracy. Now I want to talk about the cover-up. There are multiple charges, but as I said, this is simple. It is all connected because the acts and behaviors of what she did, what Michelle Traconis does before, during, after, and the statements, the omissions, and the lies are all what we call circumstantial evidence. And they're all circumstantial evidence for each and every charge. After all, you don't shake hands and plan to murder somebody at a dinner party. Look at the cleanup between 12:22, when the Toyota Tacoma returns, and 7:10 prior to driving to Albany Avenue. These acts go hand in hand with counts 1, 2, and 3. The Toyota returns at 12:22. And then the defendant and Farber Dulos both go to 80 Mountain Spring at approximately 1:35. And from 1:35 until 4:58, when Pavel Gomini shows up, Farber Dulos never leaves 80 Mountain Spring Road. For 3.5 hours, he never leaves an empty property. It is reasonable to assume that he needs that amount of time to clean the Tacoma and to prepare the garbage bags for Hartford. Michelle Traconis admits in her own interviews that she went back and forth to 80 Mountain from Fort Jefferson Crossing that afternoon, but she says she only did it 2 to 3 times, depending on which interview you watch. So look at her interviews. She omits and lies about things only when they're incriminating. There were 5 trips that day, not 2 to 3. Trip 1, 1:36 to 1:41. She stays at 80 Mountain Spring Road for 5 minutes. before returning to 4 Jefferson Crossing. Trip number 2, 2:01 to 2:24, she returns to 80 Mountain Road, stays for 23 minutes before returning to 4 Jefferson Crossing. And trip number 3, at 3:55 to 4:04, she stays for 9 minutes. What is she doing between trips 2 and 3? Between 2:24 and 3:55, when she is alone at 4 Jefferson Crossing, she's burning something. Then she's not burning something. And then she's burning something again. Remember, there were 3 separate fire events, ladies and gentlemen, this is 2 of them. And she is alone at 4 Jefferson Crossing while the fire is going on. How do we know that she's alone? We don't see any other cars leave 80 Mountain Spring Road. Her own admission in her interviews for driving the Jeep in the Suburban, and Fotis Dulos' phone location. Mike Clark's testimony, it stays at 80 Mountain Spring Road during the time of those fires. Now we go to trip 4. Michelle Traconis goes back to 80 Mountain Road. She stays for 35 minutes between 4:23 and 4:58 when Pavel Gomini shows up. Then Pavel Gomini leaves, Michelle Traconis backs out of the driveway, and Fotis Dulos leave. They all leave together. And at this moment, she takes the keys to the Toyota Tacoma to prevent Pavel from taking the car for the weekend. After all, they need more time. They haven't gone to the car wash yet. Look at her alibi script. Look at her interviews about what she says and doesn't say about the keys. But Pavel's insistent. He wants his truck for the weekend. He wants that motorbike. So she has to return the keys. And she stays for 4 minutes to return the keys. And she goes back to 4 Jefferson Crossing, and we have a fire event. These acts, including her statements, are all circumstantial evidence of her agreement to conspire with Fotis Dulos to murder Jennifer and to tamper with evidence and being an accessory to tampering with evidence. When I talk about tampering, I'm going to combine counts 2, 3, 4, and 5. Counts 2 and 3 have to do with May 24th and the events at Albany Avenue, and counts 4 and 5 have to do with the Tacoma and Russell Speeders on May 29th. The elements the state has to prove for conspiracy to commit tampering is the agreement with Fotis Dulos to commit the crime of tampering. Tampering itself is knowing a criminal investigation is pending, and I submit to you that it is a reasonable inference a criminal investigation is going to commence when you commit a crime like murder. And that evidence was tampered with. In counts 2 and 3, that is very simple. That's all the items that came out of Albany Avenue. Jennifer's bra, her shirt, the zip ties. And for counts 3, 4, and 5, that's the Toyota Tacoma. There has to be an intent to deceive, and there is a clear intent to deceive, to destroy evidence when you throw it in a garbage can on Albany Avenue, or when you take the vehicle you use to commit the crime to a car wash and ask for 2 extra details on the interior. The overact, well, here, straightforward, the defendant traveled with Fotis Dulos to Hartford to dispose of the evidence, and you specifically intend to enter that agreement and commit the crime of tampering. She's also charged with being an accessory to tampering. Accessory requires simply that you intentionally aid Fotis Dulos in tampering with the evidence. This is both for Hartford and Russell Speeders. And what did the defendant and Fotis Dulos do next? It's all very clear. It's on video as C4. Please watch the C4 videos again. I'm not giving enough time to show them to you, but I am going to draw your attention to one of those videos, specifically the Albany and Blue Hills camera. It's also on Adams Street at around 7:48. When you watch this video, noticed the simultaneous actions of Fotis Dulos and Michelle Troconis. The coordination that after they have been sitting there a while, they open the door at the exact same time, conveniently at the right time to block the view from the tan car waiting to exit the parking lot. After all, we know what's in that suit. It's the license plates, the altered license plates. And it is reasonable to assume that the defendant, Michelle Troconis, did not want anyone from that tan car to see what they were doing. They didn't want a witness. What does she do next? At this exact moment, she opens her door. Well, she says it in her interviews. She wipes gum off of her hands onto the city sidewalk. Is that reasonable? Or is it more reasonable that they didn't want anybody in the tan car to see Fotis Dulos dispose of those altered license plates in the sewer? Coordination, conspiracy, and intentionally aiding. After all, who uses the city sidewalk to wipe their hands? As for the evidence that was tampered with, you have them. The license plate, the bloody ponchos, the gloves, the tool, the bloody towel, the mop, the zip ties that were cut, and her shirt and her bra sliced down the middle. Don't forget the bag that contained the defendant's DNA on the opening. That bag also contained blood-like stains and duct tape. And that duct tape had Jennifer's DNA on the sticky side of it. The defendant's DNA on that bag shows her knowledge and her lies. It proves she's an accessory to tampering. Now, the defendant would have you believe she knew nothing of Fotis Dulos' acts, but look at the context. The police knock on her door that night, May 24th, 2019, when her daughter is not home. The police want to talk about her boyfriend being missing, and her boyfriend's wife being missing. And they are in the middle of a contentious divorce and custody battle. If she didn't know anything, why would she hide in the bedroom? She wasn't hiding from the police that night. She was hiding from the truth. Is it more reasonable the next day at the hairdresser when she was happy and excited, that she was happy and excited because she thought for a brief moment they got away with it? Or is it, well, then what happens? Fotis Dulos' phone gets taken. He can't get the kids that weekend. The plans they set in place, they start to crumble. She knew what was going on, ladies and gentlemen. Do you remember her joke in the interview? She made a joke about the fact that she said maybe she can have sex with Fotis while she's in jail, or he's in jail. Watch the interviews again. Now, this is all before May 29th, before Russell Speeders. And this is the last count hindering prosecution, where the state must prove, and we have proven, that she provided assistance to Fotis Dulos with intent to prevent, hinder, and delay and discover the crime or charge of murder. She assisted by providing transportation to him and other means. This is all about the Toyota Tacoma. Remember Pavel's testimony, how he hasn't spoken to Jennifer Dulos in years, and yet her DNA was on a blood-like stain that Matt Riley found on the seats. And remember Kristen Medell's testimony on how easily DNA can be destroyed with just wiping, let alone the cleaning solutions that they use at Russell Speeders. The defendant provided assistance and aid to Fotis Dulos on May 29, 2019. She followed him to Russell Speeders that day in her rented Yukon. Fotis Dulos put down her phone number and they left the car wash together. The defendant got the call that the car was ready, and she went back and went to the bank with him to pick up cash to pay for it. And she was with him to pick up the car. The evidence proves beyond a reasonable doubt that the defendant intended to end her and Fotis Dulos' 2 years of torture by murdering Jennifer Farber Dulos. She acted as his alibi during the murder. She conspired to tamper with the physical evidence of the murder, intentionally aided in covering it up at 80 Mountain Spring Road, at Albany Avenue in Hartford, and at Russell Speeders in Avon. The evidence shows the defendant is guilty beyond a reasonable doubt of each and every count. Thank you.
Good morning, ladies and gentlemen. This is the one and only time, except during voir dire, that I get to speak to you during this trial. It's been a long trial, and I will just echo what Ms. Manning said about your dedication and your attention to this case over what has been, at least in recent years, one of the longer trials that has taken place in the state of Connecticut. I am going to refer to notes while I'm talking. Usually I just try to talk and I have pointers, but because there are so many things that happen in this case, there's just been so much over the course of the last six and a half weeks, I may refer more to the notes than I normally would, and I apologize in advance if it looks like I'm reading from a paper rather than just talking to you. What I want to start off by pointing out is that what really happened on May 24th, 2019, because whatever was going on that day, whatever Fotis Dulos' role was in the disappearance, and I'll say the likely death of Jennifer Dulos, Michelle Traconis did not know. She did not know that Fotis Dulos planned to harm her. Everything suggested that things were going well, and it was to the contrary. In fact, she didn't know that Fotis was capable of doing something like this. A man who was dedicated to his 5 children, had been in court for years trying to get custody back. The state has made what I would suggest are unfounded and unfair assumptions and has speculated that Michelle Traconis had to know what was going on, that she was, because she was romantically linked with Fotis, that she was somehow involved in this nefarious, murderous plot. But that's not reality. That's more like one of these cable TV movies, scripted movies. It's not based on the facts that you heard during this trial. It is, and I will say this multiple times, speculation. It's conjecture. It's guesswork, which is not the standard of evidence in a criminal case here. We also concede that something bad did in fact happen at 69 Wells Lane in New Canaan that morning. It's clear, and we will also concede that Fotis Dulos is ultimately responsible for what happened to Jennifer Dulos, whether he did it himself or he had a compatriot who was involved in it down there, because we know someone else was down at 16, or at least down in New Canaan that day, and we know that wasn't Michelle Traconis. The state has not proven where Fotis Dulos was that morning. There's some suggestions. We see the vehicles driving. There is a tiny amount, I emphasize a tiny amount of DNA found on a faucet inside the home, which I'll talk about in a minute. But whether or not Fotis was in Farmington, whether it was in New Canaan or somewhere in between, it is conjecture as to where he actually was and what he personally did with his own hands. Now, we're looking at evidence that's been going on for 5 years, collection of evidence, and taking statements as recently as last month from Mr. Gumieni, new statements from Mr. Gumieni. But there's been forensics, there was surveillance cameras, there were multiple interviews, there were family court pleadings, there were the interrogations. You heard 8-9 hours of interrogations of Michelle Traconis. Even in hindsight, even now, major questions remain about what happened. It's still unclear. It's still unclear what happened. And unfortunately, this trial will not solve that puzzle. It will remain a mystery, an unfinished puzzle. But again, this is not Fotis Dulos' trial. This is Michelle Traconis' trial. And because it's Michelle Traconis' trial, you must find beyond a reasonable doubt that Michelle conspired with Fotis Dulos, not just to cause harm to Jennifer Dulos, but to murder her. That was the plot, that was the intent of Michelle Traconis on or before May 24th, 2019. Then you have to find beyond a reasonable doubt various elements that Michelle was part of a plot to get rid of evidence, some microscopic, some in opaque garbage bags, but that she knew what was in it, knew its purpose, and what she did was the same exact intent that Fotis Dulos had planned. But again, part of what you have to prove here, what the state has to prove, what you have to find is that Fotis Dulos murdered his wife. The criminal information, which you will have, states specifically that Fotis Dulos assaulted his wife and restrained her and intended to kill her. Again, there's no evidence of that. It's speculation as to who actually did that, as to any of that, for that matter. No matter how you view this evidence, even in hindsight, 5 years later, there is nothing to suggest that Michelle had any clue about what was going to happen in New Canaan on May 24th, 2019. More importantly, there's nothing to suggest that Michelle would even think that Fotis was capable of doing anything like that. Again, Michelle simply did not know. Now, we can talk about what Michelle did know about Fotis Dulos. We can talk about his life before June 2nd, 2019, when Michelle was, after her arrest and being brought before the police and being interrogated for that first time. This is the Fotis Dulos that Michelle had met down in Miami. It was very different than the one that the police were describing to him and what the police had learned from Jennifer's family and what they knew about Fotis Dulos. Michelle met Fotis in 2016 at the Miami Water Skiing Club. Both were members, both were competitive water skiers. They both had children about the same age, and the children became friends. You heard from Warren Almeida about that. Fotis introduced the babysitter. He introduced his children. And at some point, Michelle fell in love with that man. He was an outgoing, fun-loving father, successful businessman with a high-end construction of homes business, a competitive athlete with similar interests to her. Obviously more similar interests than has been testified to that Jennifer Dulos had with Fotis. But she was also told, and you heard this from many people, that they were working towards an amicable friendly divorce, that everything was going to be fine, there was going to be legal separation and an amicable divorce and custody. In September of 2017, Michelle did move to Connecticut with her young daughter. She enrolled her daughter in local schools, made her own friends, engaged in her passion for water skiing. She traveled. She helped work on her daughter's athletic interests and her sports training. But more importantly, she also had her own business. You heard from several people she had an import rug business that she was selling in local Farmington Valley stores and to individuals. But Fotis always showed the side of him that he wanted her and others to see. He hid things from Michelle, just like he did from his friends and from his employees, including Pavel Gumieni. He did that for years. Even Lauren Almeida, who used to work for him, who considered him a mentor, didn't believe it when Jennifer suggested to her that Fotis was having an affair. He was good at hiding what he was really up to. Now, in 2019, and we just heard that from the prosecution, there were some strains in the relationship between Fotis and Michelle. Just like Fotis, you heard, was lying to her, he was storing other women's phone numbers in his phone. He put some of those names in the Greek language, which she didn't understand. And she was upset, thinking that he was communicating with other women, but using men's names to hide that fact. They were written in Greek, and Michelle didn't know any Greek. She had already talked about moving to Colorado with her daughter after the end of the school year. And it also looked like at the end of April, the custody fight was about to end. It was a favorable report. Everyone said that report was favorable to Fotis Dulos and that he was going to look forward to spending the whole summer with his children. That was discussed not just with the lawyers who talked to Michelle, but it was also discussed with his friends and those that knew him well. They were, quote, moving in a positive direction, unquote, starting at the end of April. And according to Michelle's interviews with the police, she also thought everything seemed good by May. Everything was consistent with the testimony by friends, co-workers, his employees and former employees, and especially the lawyers that you heard from, Mr. Meehan and Mr. Rose. This nefarious plot under those circumstances makes no sense. Why then? Why at that moment is he going to then plot with his girlfriend to kill Jennifer? Even in hindsight, that doesn't make sense to any of the people that you heard from. None of them. Let's talk a little bit about Pavel Gumieni. His name came up very briefly in the state's argument. Mr. Gumieni saw Fotis every day practically during the week for years, for a decade even before he worked for him. He came into that business, worked with him, talked to him, knew and liked Jennifer Dulos, helped her move down to Fairfield County without Fotis knowing it. He didn't want to upset Fotis, so he was actually helping Jennifer move her belongings out of the house without tipping off Fotis that she was doing that. But what else do we know about Pavel? Even after Fotis Dulos was seen or believed to be cleaning his Tacoma, he had told Michelle that Pavel intended to sell it, and he told Pavel to find a replacement for it. He also told him to replace the car seats in that Tacoma. Remember, Pavel Gumieni was combing junkyards up in the between Waterbury and Hartford, looking for new seats. Fotis told him to call seats, if he called him on the phone, hardware. What is this, some kind of spy code? Why would Fotis tell Mr. Gumieni to not refer to it as seats, but hardware? Who would be present at that point? Michelle or perhaps other employees? He didn't want them to know. Then you saw the picture. He took the Porsche seats, took them out of the Porsche, put them in his vehicle, but in such a haphazard way. You saw that picture. They're being propped up with a bucket. He's driving now his Tacoma with a bucket holding a sports car seat in his pickup truck. Despite all these red flags, doing all these things, after Fotis told him he wants him to do this because there may be some of DNA of Jennifer in his vehicle. He does it anyway, even with full immunity from prosecution, which the judge will talk to you about. He still insisted to you in questioning that he did not believe that Fotis would harm Jennifer. Even after, as long as a reasonable explanation was given to him as to why he should do these things, he believed that. And he went along with it. He knew more than Michelle did, and he still did his bidding. There are those people that came to the house the night before, May 23rd, 2019. You have Stephan and Beth Wright, you have Hutch Haynes. All of them talked about what a wonderful evening, happy evening it was. They talked about there was no bad mouthing of Jennifer at all. If you remember, Beth Wright, who is a domestic violence counselor, that's part of her job. It's one of her jobs. Went so far as to say that everything seemed to make sense. Everything was working out. They basically toasted the happy outcome that it was going to end very soon in a happy way. Hutch Haynes, who had known Fotis for years, didn't think he could do anything like this. You heard that from him. That was even during the investigation, even after the police came and they had divers going through his water skiing time. I already talked about what the babysitter, Miss Almeida, said. She thought Michelle was nice. And there are also, even through her, no prior examples or incidents of violence. There was a discussion about him wanting her to sign a piece of paper, yelling at her, but there was never any violence in that relationship. The professionals, Attorney Meehan, the guardian ad litem, the social worker, Sidney Streeter, they both were involved. Meehan was involved for years. He also said everything seemed to be working out. It was a favorable report. And Ms. Streeter, a professional whose job it was to keep an eye on Fotis Dulos, described how amicable and friendly that was on the Wednesday, I guess, naming day for one of the daughters, where they were talking together, they were being civil. He gave her a chocolate bunny, and she took it from him and ate it. He handed her a cake. She took that and brought it into the house. She invited him to come out and sit out on the picnic table and have the children since the park closed early. You heard Attorney Mike Rose, the divorce lawyer for Fotis Dulos, say that Fotis didn't want to talk about the divorce case in front of Michelle. Said, please call me later. I'm sorry, I can't talk while Michelle is around. But he's the one who said there was now light at the end of the tunnel. Everything was going to be fine. Things were looking good. Why at that moment would Michelle agree to risk her life, risk her daughter's entire family life to at that point say, I think we now want to get rid of Jennifer Dulos? It doesn't make sense. It's pure speculation. You heard a little bit about Anna Curry during the questioning of Mr. Kimball. You remember Anna Curry was the woman who moved in with Fotis Dulos right after she had moved out and had been arrested. Her picture was shown to Michelle, and you remember, I can't remember if it was Clabby or Kimball referred to her as Michelle 2.0. Remember that? That was a woman who had moved in with this man within a month or so of him being accused of destroying evidence on Albany Avenue with bloody shirt and a bloody bra connected to Jennifer Dulos at that point. Then you remember from Petu Duparan, Clara, she was a friend of both Michelle and Fotis, had been to the house many, many times. She never suspected that Fotis would harm Jennifer, not even after June 1st, 2019, when she never spoke to him again. She did speak to Michelle. She continues to speak to Michelle. She's here in the courtroom even today. Let me just talk in general about something that I think that maybe we can all agree on. The people that we trust and believe in are our friends and loved ones. And people usually are who they say they are. We don't immediately go and distrust them, even when certain red flags arise. Even if you think they're doing something, I wonder why he's doing that. You don't suddenly think this is a bad person. Our default in our human interrelations is to believe people. We all do that. We also never think that we're going to be manipulated by someone we care about. This could never happen to us. But with the benefit of hindsight, we can't even believe that we were fooled and tricked in that way. I believe I asked most of you during voir dire if you think that you need to share everything that you're thinking and doing with your significant other or spouse. All of you at least acknowledge that they should do that, but I also recall saying that you don't believe that they always do. But that doesn't mean we stop caring about that person. It doesn't mean we immediately decide they're what? About to murder somebody? That's not how we think. We also know that Fotis Dulos committed suicide in 2020. You have that death certificate in evidence. You can see he died from the complications of acute carbon monoxide intoxication. It specifically says intentional inhalation of motor vehicle exhaust inside a garage, and you'll see the yellow box, suicide is checked. Whatever Fotis Dulos did, it was not for or because of Michelle, and it was not with her. Fotis put up a facade until his last poisoned breath, and he died without ever acknowledging his actions or admitting his role even to his own children. He never gave answers, and he can't be held to answer. Everyone wants closure. Michelle is not the remaining half of a scheming plot. She was never part of the equation. That is pure speculation. She didn't know. Most of this trial has been about Fotis Dulos in absentia. You heard about the fingerprints, you heard about the blood, you heard about the DNA. You also remember that the biologist Anna Valonis said that these KM tests, these so-called screening tests, they only suggest the possibility of human blood. It's a place for them to swap. And the suggestion by the prosecutor that, well, there's some DNA on the faucet, and we should assume that means that Fotis Dulos was in the house. Remember, it was a mixture between Jennifer Dulos's DNA and Fotis Dulos's DNA. It's the only place in the house. Why would his DNA be there other than she took chocolate from him, she took a cake from him, the children all had touched his hair, they were playing basketball with him, and where else would they wash their hands before dinner but on the faucet in the kitchen? So a small amount of DNA appeared there, and it just stays there. It doesn't go away. In the same way, you heard Mr. Gumieni admit that Jennifer Dulos had been in his truck before. You want to know how a tiny bit of DNA gets, remember, on the underside, not on the seat, but on the underside? It's because someone had sat in that seat. It was not blood. Those were sponge rubber seats. The state is asking you to speculate that there is evidence where there is none, but the absence of evidence is not evidence. You can't infer facts in a vacuum. 0 times 0 equals 0, basic math. You wonder how much blood would have been there if only Fotis had not taken out a car mat that was never found in the Suburban. How much blood would have been in the Tacoma if it hadn't been brought to the car wash? How come there was nothing in the Cherokee that maybe Michelle was driving and not Mr. Gumieni? There was nothing in the Cherokee because there was nothing to find in the Cherokee. What might have been discovered at 80 Mountain Spring Road if Michelle and Fotis hadn't done a little cleanup for a showing that we have proven happened the next day of that house? Let's speculate. The state would have you speculate about a smoke coming out of a chimney in the fireplace in the house. Unfortunately, it's in black and white. The original is in color, but that's the best we could do for today. You were shown a couple of videos. Two of them are within minutes of each other. Remember, that's a motion-activated camera. So to suggest there were just 2 times when there's smoke coming out of that chimney is unreasonable. It's unfair and it's misleading in many ways. Police continue to investigate. They continue to assemble evidence. They went to Albany Avenue after learning that Mr. Dulos's phone had pinged on a cell tower on Albany Avenue, and they got the C4 cameras that showed him, not Michelle, putting garbage in black opaque bags in various receptacles. 3 receptacles, not 6, not 30. Now, the state is asking you to evaluate in hindsight that she must have known what was in those bags. They were on Albany Avenue. She had told her they were going to Starbucks, but they went past Starbucks. Now, I believe the maps show it's about 1.5 miles past where the Starbucks is. But he told her, well, I just have to get rid of a few bags here. She told the police that he had done that before. Contractors, think about it. When you build a spec house, you heard that from Mr. Wright. You build this house, you hope to sell it. It's not for a particular customer. But if you have to buy another dumpster, if you have to rent another dumpster, that comes right off the profit, comes right off the bottom line. So how many builders drive around and go to public locations and dump trash in receptacles that aren't their own? Especially since Friday morning, you already now know, was garbage pickup in that part of Farmington. But what do we know today that we didn't know then? We know that Jennifer Dulos missed her appointment with a Dr. Geronimus that morning. We know that she was supposed to be in New York, that her children and the babysitter had already gone to New York. The call came in at 7 p.m. to the New Canaan Police Department that Jennifer was missing. They went to the house. They noticed something that looked like blood, and that's when the investigation began. Teams of investigators from multiple agencies took part in this investigation. They went through every point and every part of the garage at 69 Wells Lane. They found obvious signs of violence, and they're working against the clock. Now at 8 p.m. approximately, they found the Suburban parked on the side of Waveney Park. It had not been seen since 10:30 in the morning. Where was it? You saw school bus videos from Lapham Road. You don't see any time when that Suburban is sitting there or parked there. Now, law enforcement learned about Fotis from Jennifer's friends, that he was manipulative, that he was volatile. He had a years-long custody battle going on. Michelle, yes, was in the Raptor when he dumped those garbage bags on Albany Avenue. And the police thought Michelle knew what was in them, but she didn't know. And there's no way you could see without X-ray vision what was in those bags. Incidentally, they found nothing at 80 Mountain Spring Road. There was a coffee cup that was noted in the recycling bin in the garage. The one thing that might have had evidentiary value, and remember what Detective Sergeant Pearson said, they found nothing of evidentiary value. She noted the coffee cup, but she didn't take it. Would that not at least be consistent with what Michelle said? Fotis told her he dropped coffee, spilled coffee, and that's why he was cleaning up and he needed some paper towels. But see, that doesn't fit the prosecution's narrative, so they didn't even collect that as evidence. So Michelle was handcuffed. She was taken down to New Canaan, 80 miles away from where she was after she gets kicked out of her house. The police accused Fotis at that time of doing something that she thought was impossible. And they accused her of helping him without proof. They repeatedly said that to her. You saw she was tired. She'd been arrested in the middle of the night. She was cold. She had a blanket wrapped around her during the questioning. But they told her that Michelle didn't know the real Fotis. They knew things about him that she did not, and that he used her. They told her she needed to tell them multiple times where Jennifer was. They threatened her. They scared her. They lied to her. All permitted under Connecticut law. They told her she was going to lose her daughter, her family, that if they found the body, she was going to get charged with accessory to murder. She kept saying she didn't know, a dozen times, maybe more, but they didn't let up. There's no evidence to suggest that Michelle, who had traveled the world, had competed nationally and internationally in sports, and suddenly wanted to be a full-time mom to an additional 5 children who had just loving family. She had her good relationship with her daughter. Even the police admit in those interrogations that she was on the phone and listening. There was family discussions going on with her mom, with her sisters, all while supposedly helping dispose of evidence of a murder. Michelle wasn't trying to replace anybody. She didn't want to be these children's mother. She loved these children. She liked these children, but that's a far cry from wanting to replace their mother. Yes, there was a toxic custody battle, but she thought things were working out in her favor. I'm going to talk about the timeline very briefly. You remember that Jacob Pytranker is the one who suggested to Fotis in Michelle's presence that he write a timeline. That's when she found out that he'd even been at Jennifer's house that previous Wednesday, a couple of days earlier. She was mad that he had lied to her about that. She was mad that he didn't tell her that he had been to that house. And she was angry because she thought everything was working out through the court process. But he was lying to her even about that. If you give any credit at all to Mr. Gumieni's revelation that Michelle made a disparaging comment about Jennifer about a month earlier, I remind you that this is a man who was given written immunity and he was given verbal immunity before that. He was a non-citizen, told that he could be deported. There is one takeaway, however, from what he said. If you'll recall, what he said was that when they were bringing wood up to the house, she was upset that her 12-year-old daughter's picture was being plastered all over the internet in connection with the disappearance of Jennifer Dulos. And what did she say? According to Mr. Gumieni, that when she shows up, I'm going to kill her. And you remember, Gumieni himself said that's what he thought too, that she was going to show up. So if she's already deceased, why would anybody say that? Why would Gumieni make that his response? Listen to the judge when he talks about Gumieni. There's a special instruction to be very careful before you consider the credibility of someone in his position. Both his timing and the circumstances of that statement 5 years later that it suddenly became a revelation should give you some hesitation. Why? We put on Detective Allegro last week. Remember what he said, that he's the one who suggested, is it possible to Pavel? He said, is it possible that Fotis used that kind of language in describing his wife? This is in the July 8-hour interview, if you recall. He used those exact words, effing bitch, okay? Pavel said, nope, never heard that. But that would have been the time. But I remember Michelle Traconis saying something like that. That didn't even jog his memory about that. So I suggest to you that that part, the part about that he referred to her in derogatory terms, was made up after he got a signed immunity agreement to sort of ingratiate himself. Remember, it's not just he's been given immunity for his testimony. He's been given a get out of jail pass for anything that he may have done in connection with hiding evidence. And he knew why he was taking the seats out of his car at Dulos's request. Now, Michelle was overwhelmed. She was exhausted. She was in shock. She still talked to the police multiple times on June 2nd with a lawyer, on June 6th with a lawyer, and again on August 13th. She answered every one of their questions. Even when they accused her of lying, did she ever say, I'm out of here, I'm not answering any of her questions? No, she kept answering their questions. It got to the point where whatever they said, she started agreeing with them, whether it was true or not. I put one of the interview points up on the wall there so you can see the way it played out, right? This is not just that they want her to be honest with her. They're saying there's no way he could have been home because of through science. But we've already explained how that works with transfer of DNA, skin DNA, how much can easily be transferred from one person to another. And here is evidence of actual physical transfer of items barehanded between Fotis, his wife, and all of his children. When Michelle gave information that was not within their narrative, that the puzzle pieces did not fit, they kept accusing her of lying. They told her she was wrong. They told her Fotis Dulos had to be at 69 Wells Lane. But the state hasn't been able to prove beyond a reasonable doubt that he was down there. Even now, they suggest he's there. They've thrown out this darkened figure on a bicycle riding along in the area. There's no connection to any of that to the disappearance or harm that likely occurred to Jennifer Dulos. And you remember, you also will have the report by Ms. Streeter. We put it in, this is the part I already mentioned. She specifically described some of the things. I mean, she's talking about detail. She put every detail that she observed. That's her job. But it was about as exact, line by line, minute by minute of what happened in that house. And that easily explains why a small amount of DNA would be found nowhere other than on a faucet in the kitchen. You remember Kristen Medell, the DNA person, because she talked about how transferred DNA, they called it touch DNA, if you remember, occurs. And I submit that that's the reason, that's the more likely reason that that's the place where the DNA was found. Otherwise, what are we supposing here, that if it was Fotis Dulos, he took off his gloves, touched the faucet, and then put his gloves back on, his now maybe bloody gloves back on, walked out the door so it wouldn't be anywhere else? That's what doesn't make sense. That's what's pure speculation on the part of the state. And it's also clear that Fotis can't be in two places at once. There's also the fact, what are we going to do about getting a body or an injured woman? What are they going to transport her on a bicycle? Remember, where they saw the red pickup truck was about 300 yards, if I recall the testimony. It's up to you, not my memory, from where they found the Suburban on a busy road, Lapham Road, in front of, near the entrance to one of the biggest parks in this area, a public park on Memorial Day weekend on a nice day, that nobody would notice anything, that there are no other cameras from any school buses that use that route showing any transfer, or for that matter, showing that the Suburban is even parked there. That also doesn't make sense. Where do you get the cleaning up supplies? How do you carry all these things? How do you get them from one vehicle to another outside that park on a busy double yellow laned road? Now, there's no evidence as to when Jennifer's Suburban ended up on Lapham Road. What you do have, and I put these up, this is exhibit CC and CCC, and you'll have these documents in paper form. But there was a question raised about whether or not that Bluetooth connection of the phone belonged to Jennifer Dulos, or maybe it was the kids, maybe it was Lauren Almeida. But at this time, at 2:56 p.m. in the afternoon, when that Bluetooth connected to her Suburban, they were long away in New York City. So we know it's not them. But we have more than that. We have the Stratford police research that shows, if you look to the right there, that there were two numbers associated with Jennifer one being the 604 number and the other being the 499 number. And you will see that it's the number down at the bottom is that 5C number connects to the 499 number. You see, it was a MAC, I think they called it the MAC number. If you look at number 2 on the right, the unique number is the same as the unique number on the left there at 2:56 p.m. There's also the report, remember, by Mr. Nuth, the forensic guy from the lab, who talked about this as well in a letter to Detective Kimball. So they knew this all along. They just didn't pursue that. Incidentally, in just response to something that the prosecution said, I'm not claiming that Jennifer went through the woods and got on a train. I'm suggesting that when they followed the scent, somebody followed the scent with a dog, and it ended at the train platform at Talmadge Hill Road, the Metro North. So they didn't follow up with that. Did you hear anything at all about checking the train schedule, or maybe looking at, cameras from the trains, whether somebody ran off that way after being in the presence of Jennifer? Now, Michelle did not push back when the police told her she was wrong. She asked them what they wanted her to say, and maybe she was wrong. Even when she wasn't, even when she was helping and trying to be truthful, they told her she was wrong if that didn't fit their narrative. And eventually, for example, the FedEx envelope, she told them she knew nothing about these license plates. They told her that doesn't matter. They cut her off and said, we don't need to know, that's not important. Well, it wasn't important until what? Today, when you hear the state again talk about 2024, how important that was. They didn't even let her say what she wanted to say about that. Sometimes they were mistaken, sort of like the 30 stops when it was only 3. You heard Kimball admit that was a mistake. He admitted a few times in answering questions, especially by Mr. McGinnis, those were mistakes. But the difference is those mistakes were under oath. He swore to some of these things. He couldn't remember who told him that. He didn't have any documentation. But when he swears to something under oath, if a private person does that, they'd probably get arrested and charged with perjury or false statement. For him, it's just a mistake. For Michelle, if she makes a mistake or misspeaks, it's a crime. That's the distinction that they're trying to make here. Deception, could I just have a time? 20. Deception is an interrogation tactic in Connecticut, and you heard police are allowed to lie, they're allowed to deceive, but they're threatening, when they're threatening a person to go to prison, maybe for many, many years. She's going to lose her family, she's going to lose her child. If she keeps telling them certain information, if she sticks to what she's telling them, those tactics can take a toll on memory and what you're going to remember or say, whether it's the pressure or you've been fed enough information so it changes your perception. And I'm not going to go into detail. You heard from my 2 experts, Professor Loftus and Professor Marion. One was an expert on memory and how people retrieve and repeat memory. Remember, this is 9 days after May 24th. And for Michelle, it was just a mundane day. She did her routine. The only exception is she told them she picked up the phone. She told them that when it was in the office. She didn't have to tell them that. Why bring that up at all? Kent Mawhinney was there. You saw the video of him driving in and him driving out later. Why would she admit she's the one who picked up the phone for 16 seconds, bad connection, and she hung up? You also, and I want to just say one thing about Professor Loftus. The prosecution suggested by naming a bunch of other cases that she was involved in, that somehow she's connected to the defendants on those cases, that you should tar her with the people those lawyers represent, rather than that it was about science and what people remember and don't remember. That has nothing to do with how you should judge the facts in this case. Same thing with, I would say, about Professor Marion, the linguistics expert. She told you about things that maybe you don't know about if you're not bilingual or multilingual. One of those things is something called influency. And we talk about things like, you listen to parts of those videos, maybe the prosecution would have you think, well, you're stalling for time. But she said that's a typical response for somebody who only has mid-level proficiency. And when you're hammering at somebody, they're under stress. They confuse tenses. They speak in the present when they mean to speak in the past. Because in English, the present tense is the easy default. That and in the infinitive are the easiest way to speak if you're not fully 100% proficient in a second language. And things like stress and certain concepts, throwing in Spanish words in the middle of your sentence, that's all signs that you're just not proficient enough. You're just not proficient enough to handle these questions, especially when people are throwing them at you from different directions. Remember what was said in a report, which you will have, authority figures, you believe, I think it was Professor Loftus that said that. If authority figure tells you something, you're more apt to believe it, that maybe you're just wrong. So maybe she was just wrong, but maybe Fotis Dulos was there. That was his phone, not her phone. And they would have to prove to you beyond reasonable doubt they couldn't even be there. Because that's how they've charged us. She told them about her weekend. She told them about everything she did that Friday that she could remember. And keep in mind, we'll put up the, we'll get to it in a minute, but she told them about the socializing the night before. She told them that during that time, you'll remember, Fotis stepped out. He went and got steaks. And during that time, he went out to get steaks. He had a conversation on the phone with Kent Mawhinney. You haven't heard a lot about Kent Mawhinney, other than he's been charged with conspiracy to commit murder in this case. But he seems to be like an afterthought here. He may be the and others that you'll see are in the criminal information, conspired with Fotis Dulos and others. But there's been no evidence about her involvement with Kent Mawhinney. So I suggest you can immediately discard that as something to consider in this case. But, you know, we're talking about the fact that Fotis and Pavel took the Tacoma down to 80 Mountain Spring Road the night before, right at the beginning of when Stefan Reich arrived with his wife to look at carpets and then to have dinner. But there's nothing that Michelle knew about that. She didn't know that Fotis had stopped at 80 Mountain Spring and or made a phone call to Kent Mawhinney when he stepped out to buy some more steaks. And she didn't know, there was nothing, in fact, to suggest that she knew that. On the early morning of May 24th, the thunderstorms, remember, Kimball said there were no thunderstorms, we checked. He finally admitted that there were that night, and you have that map showing the red, where it's all coming right down towards their house in Farmington. And that's why when her daughter called her right before 1 a.m., she went to her room and slept in that room that night because the daughter asked her to. You have seen also surveillance cameras from Eli Road, from Jefferson Crossing and Mountain Spring Road, that between the time that Michelle went upstairs to her daughter's room and you see the Tacoma leave 80 Mountain Spring at 5:30 in the morning, there's nobody traveling on those, or there's no pedestrians, there's no bicyclist, there's no other car, nobody, not a taxi, nobody dropping somebody off. The state would have you think he must have been sneaking through people's backyards in the middle of the night. But remember, we were on top of a mountain. That's why we put in that drone video. You see, it's way, way up on the top of Avon Mountain, at the pinnacle of that mountain, with views, at least from their house, facing towards Harvey, you see 100 miles. The topography was why that video was shown to you. There's no evidence he was walking, running, riding a bike, or anything between the time of Thursday night and Friday morning. We do know somebody else was in Buchanan, and that was Pavel Gumieni. You'll have that Burla report, and you'll have the pictures that show that between 12:30 p.m. and 4:21 on the Plainville-Farmington line, he's nowhere to be seen. He's disappeared. He claimed he was there all day. But first of all, you'll remember what Mr. Newt said. That dot on the lower left-hand side means that the truck was parked behind the house. He had told you he always parks in the driveway, except that day. And I showed you the video from across the street. You don't see any vehicle at all. But Newt testified that the truck started up at 12:30 and then is not seen again till 4:21. Coincidentally, that's exactly in the middle of the time when the blue tooth shows up and attaches to Jennifer Dulos's Suburban at 2:56 in the afternoon. Just enough time to travel the 80 miles up from New Canaan back to the Plainville area, which is right next to Farmington. Then you see him at the gas station. They put in the receipt to show he's getting gas and how many gallons he got that day. Another point, why are we not seeing any pictures of a Raptor? They spent hours, they claim, looking for Tacomas, red trucks, Raptors. Is it, first of all, credible that there are no other red trucks that are seen on the Merritt Parkway in the entire hours that they're looking? Or did they just take a clip that said, this could be it, and we'll just put that into evidence to create a narrative that doesn't exist? No Raptors, no black Raptors at all. So how did Mr. Gumieni get, first of all, down to New Canaan or back? Where's the evidence that he didn't make a side trip? Talks about his Chinese restaurant that he went to, can't remember where it is, what he ate, or even if he was alone. We talked about the car seats. He said he replaced these car seats. There's nothing wrong with these seats. He ripped it apart, he said, and you'll notice, especially the one on the right, that's foam rubber. If there was blood, as the prosecution just suggested, wouldn't it stain foam rubber? How do you get that out? How do you get blood out of foam rubber? Remember, it was just a small amount of DNA that was found. DNA, it could have been touch DNA. And remember, she had been in that car. Jennifer had ridden in that truck before on those seats. You also have the evidence of Pavel's phone. And you know that he searched during the month of May a whole bunch of other Toyota Tacomas. And he deleted all of his searches before the police got his phone. He deleted that he had been looking at flights to Poland. He deleted that he was looking up about the disappearance of Jennifer Dulos. And he deleted all of his search history and messages from Memorial Day weekend. Michelle didn't do any of those things. Michelle told the police, even when they insisted, and they told her that science proved that Fotis couldn't be home, that she did think he was there. She knew he had an appointment with Kent Mawhinney, and sure enough, Kent Mawhinney was there that morning. And she kept telling the police she thought he was there, and they told her they would walk out and charge her with accessory to murder. She continued to maintain that story. Fotis could have been there. Again, we don't represent Fotis, but he could have been there. The state must prove the contrary beyond a reasonable doubt. We do know from the time that Kent Mawhinney arrived just around 7:20 after Michelle left to bring her daughter to school. The timing is not a coincidence. Kent Mawhinney was there for a reason that morning, but it wasn't to practice law. He's charged with conspiracy too, but there's no evidence that he conspired with Michelle. Is he that other named co-conspirator with Fotis Dulos? There's no evidence. We don't know. And here's a different question for you to ponder. If Kent Mawhinney was a co-conspirator and he was there, why not have him pick up the phone? Or better yet, if Michelle was the co-conspirator, why have Mawhinney there in the first place? Why couldn't she be the one to pick up the phone? Why need Mawhinney there? What was his purpose? To direct her to pick up the phone? Same thing with Andreas Tutsiartis. Remember, you were just shown a translation created by the police and the prosecutors to show you about Andreas's messages. They were in Greek. They were not in Greek letters. They were not in English like we were just shown. Michelle doesn't speak Greek. And so then the question becomes, what person would then send 2 hours later a meme that you were shown again to remind you what it was, a jokey meme, if that person believed that this was all a setup so that Fotis could have an alibi while murdering his wife? And it wasn't just to him, it was to 2 other friends as well. Again, in Greek letters, not English. You also know what Michelle did that day. You heard from Hutch Haynes about his wife, Erin, forgetting her purse at the house. Was that part of a plan to forget her purse? You remember the state asked, well, is that when you were discussing the plan to murder Jennifer Dulos? And Mr. Haynes shockingly, well, what? But that's the way the question was asked of him, as if maybe he's part of this too. I submit there is absolutely no basis for any of that. It's as pure speculative that he had anything to do with it. The idea that his wife would leave a purse there just to create a reason for Michelle to be walking over there or driving over there the next morning to return it is as speculative as everything else that the state has presented. She had lunch with Fotis. She then went over to 80 Mountain Spring. You also have the Stop and Shop and going to Petu shop and all that stuff. I put this up here because you can see there was a plan by Renia Minutis, the realtor. We wanted to show the house. We want to see it on Saturday. Can we arrange it? And he goes, sure. Now, why would he agree to let a house be shown to strangers on Saturday morning early if he's using that house as a staging ground for destroying of evidence? I don't know, getting rid of clothing, getting rid of body, whatever the state is claiming is going on at 80 Mountain Spring Road. That makes no sense. It makes no sense at all. There are 4 trips that Michelle told the police she made going back and forth. The first time she brought the wrong kind of vacuum because it didn't have a central vacuuming system. So yeah, 4 or 5 minutes, she goes back. She told them in the timeline she prepared for the lawyer, which you have, that she went back and forth. Why put that in if this is part of some nefarious scheme? Why list that? I realize I'm getting close to my time here, so I'm going to have to skip over some of this stuff. The police quizzed Michelle over and over again. These were things that it's a test she just couldn't pass. They insisted she lied. They had a big chart of what they said she had said on other occasions, and then tried to trick her when she said something that was different than what she had said months before. She told people that she had a fire in the fireplace, and Petu, if you remember, said she did that all the time. These are little clips from a motion-activated camera, and that's what you see. What was she burning in that fireplace? Firewood. Just like Gumieni said when he helped her bring wood up to that house. You also, if you looked at those videos, see how windy it is. It was very, very windy. Those trees are blowing all over the place, and you're on top of the mountain. So it is not unreasonable, even in May, to have a fire going in your fireplace. Now, if you go to the garbage bags on Albany Avenue, you look at those, you also can speculate what could not have been burned. You could burn garbage bags, you can burn ponchos, you can burn cloth, you can even burn sponges. Why not do that? Those are the items that would be, quote, incriminating. Police had that house for Jefferson seized for over a week, that the evidence shows, and they found nothing. They went in there with cadaver dogs, other canines. They found no trace of any evidence that connected that house to the disappearance of Jennifer Dulos. Briefly, I'm just going to mention a few other items since I'm running out of time. There's the Tacoma key issue that was brought up. The key was sticking out of the side of the truck when everyone was leaving. And as soon as Fotis called her to bring it back, she brought it back to suggest, as the police have, that there was something nefarious or evil about it. Why didn't she just say she didn't have the key? Why not come back in the 7 minutes that she came back? When it comes to the issue of the gum, and I'm going to end with that, and with one other thing. I'm going to end, actually, there's the gum. You will see that she's wiping her hands. She's not picking something up. So when the police told that to Colangelo, they were giving him false information. And I just want to play, that's going to be the last thing. I'm going to play that clip from Colangelo.
So looks like we're at 2:20.
I mean, I don't know if it's very close, but I just don't think she, I think she's still in back, you know, on issues. I don't think she knows. No. She writes, she's very happy with Starbucks, so what's hard. Why, if I was gonna dump, meaning, if I was gonna go around the city with Richie Clay to one make sure that all of our trash over the city, I remember that was, it would have just slipped my mind. We're doing it. Yeah.
Unless,
the trash, but she,
unless she's legitimately on the phone, talking in that stage and she's not paying attention.
right?
And then
She went outside the car, yeah, but she told me, she knows, yeah.
She's outside the
She
house.
was opened her clothes open and she got outside, she had a car. She swear it is, she dropped gum and she realized it was sticky and she, yeah, she had a broken, yeah, I felt the gum, she dropped, that was one person.
One person in the world who picks up, one person in the world who picks up gum. She never said that she picked up gum. Here's the state's attorney, the chief law enforcement officer for this judicial district saying she doesn't know. Maybe she doesn't know, and you've got the 3 detectives telling him something that's false to get him to come off the notion that she doesn't go. And I submit to you, ladies and gentlemen, if he thought she didn't know, then that's reasonable doubt right there. This trial is a tragedy, no question about it. It is a tragedy for many people, including people that are sitting here in this audience, in this courtroom right now. But this case here is not about sympathy. It's not about antipathy and revenge. There is only speculation and no facts. We are all sitting here in hindsight, deciding what happened after the fact, what one should have known versus did know. What we can do when Michelle, for example,
Counsel, you've got 1 minute.
thank you. When Michelle picked up Fotis from the car wash, she didn't go in there. She had nothing to do with what Fotis Dulos planned to do with that vehicle on that occasion. Now, I don't get another opportunity. You may speak. You may think that the state has a second bite of the apple. That's not fair, but it's important for you to understand the reason for this is they have the burden of proof on everything. We don't. So they do get to speak last, but I want you just to remember that they have a burden of proving beyond a reasonable doubt for each element of each of the crimes the judge is going to read to you. And I ask that you reach the correct verdict, which is not guilty. Thank you. Thank you, Your Honor.
Sure. Yes.
Good morning. Before you proceed, Attorney McGinnis, the jury would like a brief break.
Yes, sir.
We will continue with the closing arguments at 12 noon.
All right. Okay, so we've got a 13-minute break here. So let's go over to the Rust trial here. Let me just find the point at which they start here. Okay, here we go. Oh.
Go ahead, counsel.
Good morning, Your Honor. The state calls Dr. Heather Gerald.
All right.
Face the judge and raise your right hand.
Do you swear affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Have a seat. Talk into the microphone.
Good morning, Doctor.
Good morning.
Would you please state your name for the record and spell your last name, please?
Dr. Heather Gerald,
And what's your current occupation?
Jarrell.
There we go.
I'm the Chief Medical Investigator at the Office of the Medical Investigator.
Great. And what are your primary responsibilities as the Chief Medical Examiner at OMI?
I oversee the operations of the OMI, including approximately 200 employees and the forensic pathologists who are there. In addition, I also perform autopsies to determine the cause and the manner of death.
Great. Can you give us a brief explanation about your educational background?
Sure. I have a bachelor's degree from Valdosta State University in Valdosta, Georgia. Then I went to medical school at Mercer University School of Medicine in Macon, Georgia, where I graduated with a medical degree. Then I completed a residency in anatomic pathology at the University of Virginia, and I'm board certified in anatomic pathology. Then I completed a fellowship, which was a 2-year fellowship in neuropathology at the same institution, and I'm board certified in neuropathology. And then lastly, I completed a forensic pathology fellowship at the Virginia Commonwealth University, and I'm board certified in forensic pathology.
Can you explain to the jury what forensic pathology is?
A forensic pathologist performs autopsies to determine the cause and the manner of death.
And what about anatomical pathology?
A person who is an anatomic pathologist can perform autopsies usually in a hospital setting to determine what caused death, but they also can determine, like, for example, if you have surgery and have something removed, let's say a cancerous lesion, the pathologist is the one who determines what type of cancer it is or disease it is.
And approximately how many autopsies have you performed in your career?
I have performed and supervised over 3,500 or 3,500 examinations, plus about 500 neuropathology consultations.
And have you had any training specific to injury analysis?
Can you be more specific?
Just training in terms of determining how an injury may have affected an individual's body and how that may have contributed to the person's death?
Yes, that would be included in my forensic pathology fellowship.
Great. And have you ever testified in court as an expert witness in the fields of forensic and anatomical pathology?
Yes,
Approximately how many times?
more than 50 times.
Great. And have you rendered opinions in prior cases regarding homicides that involved guns?
Yes,
All right. And does this include testifying to the entry and exit of gunshot wounds?
Yes.
All right. Your Honor, at this time, I'd move the court to recognize Dr. Gerald as an expert witness in the fields of forensic and anatomical pathology.
Yes.
Thank you. Dr. Gerald, would you explain to the jury exactly what is an autopsy?
An autopsy examination consists ultimately of two parts, both an external examination and an internal examination. In the external examination, we document, features of the decedent, such as hair color, eye color, weight, and stature. But we also document any injuries that we see externally. We take measurements of those injuries and we classify those injuries. The second part of the autopsy is the internal examination. I also neglected to mention that during the external examination, we collect trace evidence in suspicious cases. That might include fingernail clippings and hair samples. The internal examination consists of blood collection for toxicology when applicable, and looking at every internal organ individually to look for injury, and again, classifying that type of injury, and also looking for natural disease findings. We also make microscopic slides as a result of that internal examination, which we analyze by looking through a microscope, and we form a final report with the ultimate goal of determining the cause and the manner of death.
Thank you. And does every person who dies receive an autopsy?
No.
So how do you determine whether or not you're going to perform an autopsy?
An autopsy, I'll back up and explain that a little bit more. Within the state of New Mexico, the OMI is notified of all sudden and unexpected deaths. And for cases that are non-natural, there are certain circumstances where the OMI will take jurisdiction. And so in the case of deaths resulting from gunshot wounds, this is an example where the OMI, or the Office of the Medical Investigator, will take jurisdiction. And in possible homicides, the OMI will perform an autopsy.
Thank you. Can you explain to us what is the intake process when a body arrives at OMI? What is that intake process like?
When a body arrives at the OMI, the body is received in a sealed body bag, so that chain of custody is maintained from the scene to the OMI to ensure that no one's tampered with anything inside the body bag. We break the seal, and we have a machine at the OMI called a CT scanner, just like in a hospital if you have to get a CAT scan. And the body at the OMI receives a full body CT scan. This allows us to have a look inside the body before we actually open the body. For gunshot wound cases, it lets us know if there's a gunshot wound track and if there is a retained projectile. And so that is the beginning of the intake process.
Thanks. And I'm going to get into some greater detail about the CT scan in this case and further questions. But right now, describe to us as part of the intake process, is it typical for sometimes for items to arrive along with the decedent's body?
Yes.
So what might arrive?
Per our state statute, anything present on the body should come with the body. In this case, there were personal belongings that included clothing that came present with Ms. Hutchins' body.
Great. Do you gather any statements prior to conducting an autopsy?
If law enforcement is present to view an autopsy, which is not uncommon, I will usually ask if they have any questions before I start. And I will communicate autopsy findings to anyone who is there to view autopsy. We also, before I issue cause and manner of death, when relevant, will review law enforcement reports.
So you mentioned kind of the external examination. Is there another step to the autopsy process?
There is the internal examination.
Right. And can you explain what that is briefly?
During the internal examination, we make an incision on the chest and the abdomen to look at the internal organs. We also make an incision on the head and remove part of the skull to look at the brain.
As part of the external examination, what sort of things are you looking for on the outside of the decedent's body?
On the external examination, again, we're looking at certain physiological characteristics or physical characteristics of the decedent, but we're also looking for any injuries that might be present. And again, we take measurements of those and we classify what type of injury they are.
And how do you document the external examination?
The external examination is documented. I typically use a body diagram and I make notes. If there's any tattoos, I'll document where those are. And then if there's any injuries, I'll document on a body diagram what type of injuries they are.
And do you take photographs as part of this?
Yes.
Thank you. And let's talk now a little bit more detail about the internal examination. How do you proceed about conducting an internal examination?
How much detail do you want?
Just give me an idea in terms of, are you looking for whether the death was caused by an injury versus a natural disease? Just kind of a high level description of what you're looking for.
Yes, the combination of the external examination and the internal examination are looking at any documented natural disease or injuries. If there are injuries, do they account for death? Is there any natural disease that accounts for death? And again, when we perform toxicology, is there any toxicological cause of death or contributory factors to death?
And as part of that, do you ever collect samples of tissue or fluids?
Yes.
And can you explain that process?
Yes, we typically will collect blood to perform toxicology in certain cases to determine if that caused death or contributed to death. As I mentioned before, we also collect hair samples, other blood samples that could be used for DNA testing if needed later. And we collect fingernails, clippings for what we call a so-called homicide workup.
Perfect. And was an autopsy performed on Halyna Hutchins in this case?
Yes.
And who conducted that autopsy?
I did.
Great.
Bring the jury in, please. Counsel stipulate, please.
Yes, Judge. Yes, Your Honor.
Attorney McGinnis.
Last night, when I was thinking about what I was going to say to you this morning, it occurred to me what this case is really about. It is about a mother's worst nightmare. It is about a mother being taken away from her children in life or in death.
Hi, this is Mark Barton at Sandy Hook Promise in Newtown, Connecticut.
And hi, this is Nicole Hockley, also from Sandy Hook Promise.
And she has still not arrived. That's what this case is about. And so the question becomes, who is responsible for Jennifer Dulos' death? Now, the defense in their closing argument suggested a couple of different things to you. On the one hand, they said it's likely that she's dead, thus leaving the possibility open that she's still alive. Do any of you really believe that? The other possibility is that Fotis Dulos is this monstrous murderer And still a third possibility that Fotis Dulos wasn't responsible, but Jennifer Dulos is dead nonetheless. But what you didn't hear a lot about in the closing argument from the defense was about Hartford Run and the dump of the evidence. You didn't hear much about that. Very tangentially, they addressed it. I pose this question to you. Do any of you doubt that Fotis Dulos is responsible for the death of his wife? Do any of you doubt that he was in New Canaan on May 24th, 2019, murdering his wife? How else would he have had her bloody bra, her bloody shirt, blood all over the bags, his DNA in a glove found inside the trash? How? And so when the defense suggests that to you, I suggest that's not reasonable. And so once you conclude that Mr. Dulos is responsible for the death of his wife, you then go to the next questions, which are, is this defendant legally responsible for her death? Is this defendant legally responsible for conspiring to tamper with evidence, for acting as an accessory to tamper with evidence? Was the defendant motivated to harm Jennifer Dulos? I want you to make no mistake about this. This defendant hated Jennifer Dulos. She referred to her as a bitch who should be buried next to the dog. Now, I'm just going to say this because we're going to talk about Mr. Gumieni in a few moments. The defense is trying to have it both ways. Disbelieve Mr. Gumieni about that, but believe him about the remark the following week. We'll talk about that. She had animus towards Jennifer Dulos. Even in her interviews, you heard it. And by the way, you're going to have the interviews, so you don't have to take my word for it. She referred to Jennifer Dulos as a manipulator. She said, "You people are toxic," referring to Fotis Dulos and Jennifer Dulos. She said that since she moved to Connecticut, it had been 2 years of torture. She even admitted, if you caught it, that she demanded that Fotis Dulos go to therapy with her because of Jennifer Dulos. Everything was not okay. And when the defense gets up here and they say to you, well, the report, everything was going so well, there was no motive, Fotis didn't have a motive, Michelle didn't have a motive. Think about what she actually said about that report for a second. Jennifer is trying to manipulate you, Fotis. Stick with the courts. She has borderline personality disorder. So even after the report came out, this defendant didn't buy it. This defendant didn't think everything was going to be okay. This defendant needed to go to therapy to see how Jennifer Dulos being in her life was going to impact her future. And so when they say that there was no motive, when they say that there's no evidence that Michelle was motivated to commit this crime, I submit to you that is completely contrary to the evidence. And I also just want to say this, and I don't quite know where this fits in. That's for you guys as the fact finders to decide. There's something unsettling about the defendant and Mr. Dulos fooling around on the passenger side of that Tacoma on May 24th, 2019. And you'll recall that from the third interview. And where that fits into all this, I'm going to leave it up to you to decide. The defendant in this case repeatedly lied to investigators. Repeatedly lied to investigators. What does that say about her culpability? What does that say about what she knew in advance? What does that say about what she knew was going to happen to Jennifer Dulos and what she knew they did after the fact? So let's run through some of the things the defendant said to investigators. I showered with Fotis Dulos on May 24th, 2019.
When I go to the bathroom, I brush my teeth, I get into the shower. I don't wet my head, usually because usually I take a fast shower to take one. Fotis jumps into the shower with me.
Now, here's what's interesting about that. She is giving the investigators an awful lot of detail, isn't she? I didn't wet my hair. Fotis jumped in the shower with me. And of course, we know where that came from. This is what she told investigators about where Farber Dulos was on the morning of May 24, 2019. I saw Fotis talking to Kent in the office.
I walked Kent, the lawyers there. They're talking, but further, I don't in the house now.
Just explain it. Just explain.
They're in the table, not the office.
They can't do.
And Fotis.
Can't do photos.
I grabbed my computer.
All these details. He's talking to Kent at the table in the office. I grabbed my computer. You know he's in New Canaan murdering his wife. You know that because of all the evidence, the DNA evidence, the trash in Hartford. So what is she talking about? I didn't see Fotis' phone in the morning on the 24th.
He's calling on that morning. Morning that Jennifer went missing. Is that straight because of usual?
I didn't see her phone, but yes, probably it's weird.
She told investigators she didn't see the phone. She told investigators she saw Fotis in the shower. She told investigators she saw Fotis talking to Kent and Winnie. Until she didn't. Wait, I actually didn't see him.
Or in the shower or in the room.
Did you see him in the house at all?
I did not see him in the morning in the house.
There's a phone or something. When was?
Didn't see him. As the investigators get more evidence and she sits down for a third and final interview. Now all of a sudden she didn't see him. Wait, I actually did see his phone. And incidentally, I just happened to answer the one phone call that he had in his timeline, the phone call that he set up the night before.
The day of the phone. You see Ken.
Yes.
What was his phone?
Yes.
On the last table in
Yes.
the office.
Yes.
Where Ken was looking.
Yes.
Now, I am just going to say this. Her lies were so profound that the defense brought in 2 experts to try to explain them away to you. So what I suggest to you about those experts is, number one, Dr. Loftus couldn't point to a single thing, not one thing in this record that the police officers fed her, not one. So when the defense attorney gets up and says, you'll see in the report authority figures, I asked her on cross-examination, did the officer suggest that? I don't recall. Did the officer suggest that? No. Not one thing. And it's interesting too, we talk about language proficiency, we talk about why she may have said the things that she said. I'm going to tell you exactly why, members of the jury, you should reject that. If that's really the case, she has memory lapses, she has false implanted memories, she doesn't speak the language. If that's really what's going on, why is she so good on details that don't matter? And so bad on details that incriminate her? Why? How does she know she bought parsley at Stop and Shop? She even language gap, memory gap. You exercise your common sense. You're smart people. Here's the thing about the lies also. She doubled down on it, didn't she? When Detective Clabby told her during that first interview that Farber Dulos had murdered his wife, after that, she went back to, I saw him in the house. She doubled down on these lies. In her second interview, she said she never read Fotis Dulos' timeline. That's interesting, isn't it? Because his timeline, you'll recall, notes the call from Greece, notes the call from Andreas. Because it was designed to be an alibi for him, just like she was. And as you know, that phone call was arranged the night before. This defendant was undoubtedly part of this plan to kill Jennifer Dulos. There's no ifs, ands, or buts about it. The cops asked her, why wasn't Hartford in your timeline? Oh, I was gonna write that, but I got interrupted. Isn't that a coincidence? Isn't that convenient? Speaking of that, you heard the defense talk about Kent Mawhinney. The evidence is that when that phone call came in, what did Kent Mawhinney say to the defendant in her own words? Does anyone remember? Is this the call? The call. Isn't that strange? Freudian slip. You only have to find that the defendant conspired with one other person to find him guilty of conspiracy to commit murder. And it's obvious here that she conspired with Mr. Dulos. She was part of his alibi while he was in McCain and murdering his wife. In the second interview, she told investigators that Mr. Dulos hadn't told her what to write in her timeline, but by the time we get to the third interview, he told her. So you think about that. Why is someone who is innocent lying so much? That's a question for you to answer. Now, I want you to also think about 80 Mountain Spring Road and the timing of everything. Why would Mr. Dulos, and again, the evidence is overwhelming that he murdered his wife. So why would Mr. Dulos invite her to 80 Mountain Spring Road to clean the house while he's cleaning the Tacoma that you know was involved in this crime, unless she was involved? Why would she bring cleaning supplies? Think about it for 1 second. I want you to just think about that. Fotis Dulos' head. While I clean blood out of a Tacoma from my estranged wife's death, can you clean the house? Is that reasonable? To say nothing of the fact that she completely omitted the Tacoma from her first two interviews. Why was that? Why wasn't the Tacoma mentioned? Why wasn't that brown stained paper towel mentioned during the first two interviews? Also, think about how the defendant described going to 80 Mountain Spring Road. She says that initially, Fotis Dulos called her to bring cleaning supplies. She kind of is distancing herself from what was going on down there. But you know that they actually went together. And it's not until she's pressed that she admits that they went together. And it's corroborated by the surveillance footage.
They bring cleaning supplies for to clean the house.
Okay,
For Rani.
okay.
That's more or less what I remember. And he called me like at 1:50 something. Then he called me like at 3.
Well, let me just tell you that at 1:33, Fotis is driving Jefferson, or driving to Mount Spring. And by 1:36, you guys are both arriving in Mount Spring.
Okay, so I went with the cleaning stuff.
But you went with him. You guys are both driving into the driveway together, like literally right one right behind
How
the
we
other.
went together.
So you say, well, Attorney McGinnis, that was just an innocent memory lapse, no harm, no foul. Put a pin in that. We're going to come back to that. Why would the defendant go to 80 Mountain when you know that this cleanup is going on? Think about what the defendant brought to 80 Mountain and what was later found in the trash.
Go.
Davis, yellow and green.
And you don't recall the bag for?
So it got cut off, but they were asking her what the color of the sponge was. And she said yellow and green. What color sponge was found in the trash in Hartford with Jennifer Dulos' blood and DNA on it? What type of bags were found in Hartford with Jennifer Dulos's blood and DNA in them? With Jennifer Dulos's bloody bra and shirt in them? Think about the fires. 3 separate fires on the afternoon of May 24th, 2019. None of those made the timeline. Just like Hartford didn't make the timeline. Just like the Keys didn't make the timeline. Who's lighting a fire on Memorial Day weekend? Better question. Who's lighting 3 fires on the Friday before Memorial Day weekend on a day like that? The fact is that she lit 3 separate fires at a time, and you know with certainty that the cleanup of Jennifer Dulos's murder is going on. And the phone data shows that she was at the house by herself. Her admissions show that she was at the house by herself lighting those fires. The surveillance shows her going back and forth repeatedly. 5 minutes at a time, 9 minutes at a time, fire, fire. She's not involved? Pavel Gumieni. One person ran towards the Tacoma, embraced it, and another one avoided the Tacoma. You guys will recall that image that the defense admitted into evidence where Pavel Gumieni is at the police department with oil looking to get his vehicle back. Does that sound like somebody that was involved in this murder? Everything that Mr. Gumieni said to you was corroborated by video surveillance, the infotainment system, the gas receipt. There's even surveillance footage of him leaving with the dirt bike in the back of his vehicle. You guys will recall that. You'll remember that there was only one exhibit, I believe, during the trial that I actually physically handed you. It was the surveillance shot because it was difficult to see with the plank in the back. You guys will recall that. Everything he said was corroborated by the surveillance footage. Everything. And by the way, if you're going to have the temerity in closing argument to accuse someone of being involved in a murder, at least have the brass to ask them when they're here on cross-examination.
Objection, Your Honor.
Well, at this point, the court can appreciate some of this argument, but ad hominem attacks should not be considered by the jury. Neither should they continue.
Mr. Gumieni withstood an entire day of cross-examination. An entire day of cross-examination. And he stood up to it. He even told you little details like he had sold his motorbike to the defendant. She lied about that too, didn't she? She lies about big details and small details. And of course, he told you how the defendant took his keys. Now, up until the third interview, she didn't even admit that vehicle was at Mountain Spring Road. And even she admitted that taking those keys looked bad, didn't she?
So this is where it's problematic. This is where we come back to this. All the things that we talked about in here that were said by you, sometimes twice, as we met times before, that were less than truthful. Now all of a sudden, you're taking the keys. You have to understand how that looks. Okay, it looks very bad.
Why did she avoid bringing up the Tacoma in her first 2 interviews? Why did she not tell investigators that Mr. Dulos was cleaning the Tacoma? And then, of course, there's the coffee-stained paper towel that she doesn't mention until the final and third interview that she threw out in the trash herself. Think about all those trips back and forth, all the calls back and forth. Not only is his vehicle there, his being Mr. Gumieni's, but the defendant admitted it looked bad that she took his keys. Why would she take his keys unless she's trying to keep that vehicle there? Russell Speeder's car wash. Remember I told you to put a pin in that lie earlier about going to 80 Mountain Spring Road? She tried to pull the same lie about Russell Speeder's car wash. She initially said that Mr. Dulos called her to pick him up, and then later had to admit, actually, we went in tandem.
Did he call else to call?
Fotis at some point calls me and says, pick me up at the car wash in the parking lot. So I went to pick him up, and then we went to meet with Andy.
And then, of course, they say, are you sure you didn't go at the same time? Oh, maybe we actually did go at the same time. Members of the jury, that truck was clean. 18-year-old work truck, no profiles on the door. They destroyed the evidence, and she helped him. She picked him up. Her phone number was used. That's hindering. That's accessory to tampering with evidence. I want to just talk to you now, because the evidence in this case has proven the defendant guilty beyond a reasonable doubt. I want to just pose these questions to you as you head into your deliberations. Is it really just a bunch of coincidences? Is it just a coincidence that the defendant answered Dulos' phone at 4 Jefferson Crossing when he was murdering his wife in New Canaan? Is it just a coincidence that Dulos' phone is being moved and manipulated when only the defendant is home? Is it just a coincidence that the defendant brought cleaning supplies to 80 Mountain Spring Road where you know the cleanup of the Tacoma was going on? Is it just a coincidence that the call from Greece is not in the defendant's timeline? Is it just a coincidence that during the cleanup, only hours after Jennifer is murdered, the defendant is shuttling back and forth between 4 Jefferson and 80 Mountain Spring Road? Is it just a coincidence during these trips back and forth, the defendant starts a fire at 4 Jefferson Crossing? Is it just a coincidence that during these trips back and forth, the defendant starts a second fire at 4 Jefferson Crossing? Is it just a coincidence that the defendant eventually lights a third fire at 4 Jefferson Crossing? Is it just a coincidence that while Dulos is cleaning the Tacoma, she takes a brown stained paper towel from him and throws it in the trash? Is it just a coincidence that despite no one telling her to, she took the keys to the Tacoma? Is it just a coincidence that the defendant travels with Dulos to Hartford as he disposes of the evidence on the same day? Is it just a coincidence that the defendant brought black garbage bags to 80 Mountain and Jennifer's shirt and bra were found inside black trash bags? Is it just a coincidence that the defendant brought a green and yellow sponge to 80 Mountain Spring Road and 2 of those were found in the trash in Hartford? Is it just a coincidence that the defendant brought a broom and the police found a mop or a broom handle in the trash at Albany Avenue in Hartford? Is it just a coincidence that the defendant opened the door to the Raptor at the exact moment that Dulos exits the vehicle to dump those license plates in the sewer and block out other vehicles' view? Is it just a coincidence that despite her daughter not being home, the defendant panicked when the police came to the house, went to 3 separate rooms and said, "I don't want to be here"? By the way, if the police come to someone's door while their child is not home, would you expect a reasonable person to immediately go to the door and make sure the child is okay? Unless, of course, that person just knowingly committed a crime. Is it just a coincidence that the defendant followed Fotis Dulos to the car wash and then tried to lie about it? Is it just a coincidence that the defendant's phone number and not Dulos' number was used at the car wash? Is it just a coincidence that the defendant lied and said she showered with Dulos when he was actually en route to murder his wife? Is it just a coincidence that the defendant lied about seeing Dulos in the office again while he was in New Canaan, murdering his wife? Is it just a coincidence that the defendant initially denied seeing Dulos' phone on the morning that Jennifer was murdered? Is it just a coincidence that the defendant said she saw Dulos meeting with Kent Maloney at 4 Jefferson Crossing around the time of Jennifer's murder, the same information that was in Dulos' timeline? Is it just a coincidence that the defendant never mentioned starting a fire to the police until they confronted her in the third and final interview? Is it just a coincidence that the defendant failed to mention that the Tacoma was at 80 Mountain Spring Road during her first 2 interviews? Is it just a coincidence that the defendant never mentioned that Dulos had washed the Tacoma during her first 2 interviews? Is it just a coincidence that the defendant answered the one call mentioned in Dulos' timeline on that morning as having been answered by him on the morning of his wife's murder? Is it just a coincidence that the defendant failed to tell police that Fotis Dulos' bicycle was at 80 Mountain Spring Road until the third and final interview? Is it just a coincidence that the defendant lied about not going back to 80 Mountain Spring Road to return those keys? Is it just a coincidence that Dulos told the Bell Committee to keep the defendant, quote, out of this when the committee brought up the defendant taking his keys? Is it just a coincidence that the defendant's DNA was found on the opening of a garbage bag that also contained bloodstains, tape, and Jennifer Dulos' DNA? Are all these things just coincidences? Or is the defendant guilty? Now, during voir dire, we asked each of you, if the state proved its case beyond a reasonable doubt, would you be able to come out here and find the defendant guilty in a court? And each of you promised us that you could. We've done that. We've met our burden of proof in this case. Now, I want to show you, I have 2 minutes left here, the timelines. One last time, we're going to talk about these timelines. Now, Fotis is to the left, the defendant's timelines are to the right. And they have been referred to as timelines, but they were really just a script, weren't they? And maybe some of you remember from English class in high school, every script has 3 acts, doesn't it? The first act was the premeditation and killing of Jennifer Dulos. The second act was the cover-up through the destruction of evidence and the defendant's lies. And now we've reached the third act, except she doesn't get to write it. You do. You write the third act of this script with your verdict. What's the ending going to be? Thank you.
Ladies and gentlemen, you have heard the closing arguments in the matter of State of Connecticut versus Michelle Traconis. The court will instruct you on the law, but the court will do that after the luncheon recess. That instruction will take about 50 minutes. Because the instruction will take that much time, what the court has decided to do is give each one of you a complete copy of the instruction so that you can follow along. Otherwise, it would be difficult to digest those instructions as the court is reading it and you are trying to listen. We will stand in our luncheon recess. Please do not discuss the case. Please do not talk to anyone about the case. And we plan to see you at 2 o'clock.
Ladies and gentlemen, stay seated in the gallery.
Was performed on October 22nd, 2021.
Great. And how did you identify the decedent as Halyna Hutchins?
I believe she was identified by a visual identification. We can also do comparison to identification, like a driver's license.
Great. And what was your role in this particular autopsy?
I was the person who conducted the full autopsy.
Great.
So I'm the person who did the external examination and the internal examination, wrote the report, and certified cause and manner of death.
Great. So it was you who was ultimately responsible for issuing the findings?
Yes.
Great. Did you review all of the photographs related to the autopsy to form your opinion?
Yes.
Thank you. Were you able to render an opinion regarding the cause and manner of death for Mrs. Hutchins?
Yes.
And what was your conclusion for cause of death?
Death was caused by a gunshot wound to the chest.
And what was the manner of death?
I certified the manner of death as accident.
And can you explain why you classified it as an accident?
Yes. I classified the manner of death as accident. Well, let me back up to go to a homicide is classified as a volitional act caused by another to cause fear, harm, or death. Intent is not always needed. It is a common element, but is not always needed. Conversely, for an accident to be applicable, what must not be present is an intent to cause fear, harm, or death. Looking at the material that was available to me through law enforcement reports, it was apparent to me there was no obvious intent to cause death. It doesn't mean there's no negligence or so on, but it means there was no intent to cause death. Additionally, there are medical examiners across this country that would have certified the manner of death in this case as homicide. However, reviewing the material that was applicable to me, it is clear that there was a belief on the set that the firearm was not loaded with live ammunition. And based on that belief, and this scenario being much different than what we see in other medical examiner cases for firearm-related deaths, I felt that the manner of death was best classified as accident. And thirdly, there has been somewhat of a precedent set in a previous movie set shooting death where the manner of death was classified as accident.
Great, thank you so much. You mentioned earlier when you first started your testimony that you sometimes perform a CT scan on the decedent's body. Did you perform one in this case?
Yes.
And what did that scan reveal?
The scan revealed that there was no significant natural disease for Ms. Hutchins. It also demonstrated a gunshot wound track. It demonstrated that there was medical intervention prior to her death in the form of surgical intervention that was conducted at UNMH or the University of New Mexico Hospital. And it also demonstrated that there was no retained projectile within Ms. Hutchins' body.
Thank you. When Ms. Hutchins first arrived at OMI, do you recall what she was wearing?
She was wearing undergarments and she was wrapped in a hospital blanket.
Okay. Did any clothing arrive with her?
Yes.
And do you recall what that was?
Yes, there was a jacket, or I classified it as being a jacket. And there was also a pair of tights and a pair of pants.
Great. At this time, Your Honor, I'd like to move for admission of States Exhibits 113 and 114, their photographs, and they've been stipulated to by defense counsel.
All right, admitted.
May I publish them?
Yes.
All right. Is there an image on your screen?
Yes.
Okay. Does that appear to be the jacket that arrived with Ms. Hutchins?
Yes.
Did you do any examination of this jacket?
I did a visual inspection.
And why did you do that?
For firearm-related fatalities, we look for defects of the clothing that correspond to any gunshot wounds on the body. In particular, we will look at the defect that corresponds to the gunshot entrance wound, and we look for visible soot or dark particulate material that would help us indicate a range of fire.
And did you find any of that on this jacket?
No.
Okay. And so what kind of conclusion can you draw from the absence of gunpowder or that kind of thing?
The absence of soot, unburned gunpowder particles, and gunpowder stippling on the clothing and or body would indicate a distant or an indeterminate range of fire. Indeterminate range of fire would be applicable if there is an intermediate target, meaning that the projectile went through something else before it struck Ms. Hutchins. There was no indication that the projectile went through anything before it struck Ms. Hutchins, and therefore the range of fire is best classified as distant.
Great. And just to be clear, when you say distant, can you put some actual measurements to that, perhaps in feet?
It's difficult to say, but what we generally say very conservatively is that to get the best idea of the actual distance of the firearm to Ms. Hutchins' body would be to do a examination or, sorry, the word has left me, a firearm test where you test the actual firearm with the actual ammunition to try to get the range of fire. However, generally speaking, in forensic pathology, we can estimate that distance roughly to be about 2 feet or greater.
2 feet or greater. Great,
Yes.
thank you. If you look at your monitor, I put up States Exhibit 114. Do you recognize these?
Yes.
And what are they?
These are the pants that were received along with Ms. Hutchins' body.
And were you able to make any findings or determinations on the basis of these pants?
There were no defects that were significant. The clothing had been partially cut or cut due to resuscitative efforts, but there's nothing significant from my point of view with regard to the gunshot wound.
Great, thank you. And you've mentioned the gunshot wounds, so let's talk about that. How many gunshot wounds were there?
There were 2.
What injuries were you able to observe externally?
There was a gunshot entrance wound in the right armpit region, and there was a gunshot exit wound on Ms. Hutchins' back, just below the left scapula or the left shoulder blade area.
Thank you. Your Honor, at this time, I'd like to move for admission of States Exhibits 115, 116, and 117. These have also been stipulated to by defense counsel.
All right, admitted?
And may I publish those?
Yes.
Dr. Gerald, what are we looking at here?
This is a photograph before Ms. Hutchins' body was cleaned, which I typically do with regard to gunshot wounds. And the reason why I do this is because things like soot can wipe off. And so I like to take photographs before the wound is clean that demonstrates that there is no soot surrounding the entrance wound. But what is depicted in this photograph is a gunshot entrance wound in the right armpit region. Surrounding the entrance wound is an abrasion or a scratch that is likely due to the positioning of Ms. Hutchins' arm when she was shot. And so that's just an abrasion that was caused by the projectile as it entered the armpit area.
Thank you. And you also mentioned an exit wound. Can you explain what this photograph is?
Yes, this is the gunshot exit wound, which was left of the midline, left of Ms. Hutchins' midline on her back, below the left shoulder blade. It does show, and this is again before it has been cleaned, which again is a standard practice. But this is the exit wound. It has some bruising around the exit wound that was probably caused by medical intervention and placement of a plastic device to help render medical aid.
Thank you. I'm going to pull up States Exhibit 117, and this may help you explain. I know you tried to explain where the exit wound was in terms of her back, so this may give the jury a little bit better idea of where that was. But just to be clear, this is the same exit wound as from the previous picture, correct?
Yes.
And do you notice anything different or remarkable in this picture that you didn't already discuss in the previous one?
No, it just gives better orientation.
Great, thank you. All right. Dr. Gerald, based on the examination and your review of the photographs, were you able to track the path of the projectile from where it entered Ms. Hutchins' chest and where it exited?
Yes.
And can you explain that path?
Yes, the projectile entered through the right armpit area. It missed the major blood vessels in the shoulder area and in the arm. It entered the right aspect of the chest into the right chest cavity. It injured some of the blood vessels that travel along the ribs, broke some ribs, or broke one rib, went into the right lung, and exited the right chest cavity just adjacent to the vertebral column. It went through the spinal cord and traveled through the soft tissue of the back before exiting.
And as part of that examination, did you use what's called a trajectory rod?
Yes.
And what does that help you do?
The trajectory rod just simply shows the pathway, the general pathway that the projectile took through the body from the point of entrance to the point of exit. And that trajectory with respect to Ms. Hutchins' body is front to back, right to left, and downward.
And were the injuries that Ms. Hutchins suffered to her internal organs consistent with being shot?
Yes.
And of the injuries that you described, which of those can be lethal?
There was documented in medical record, there was over 1 liter of blood present in the right chest cavity when Ms. Hutchins arrived to UNMH, or the University of New Mexico Hospital. And so that indicates significant blood loss within the chest cavity, and the injury to the right lung was also lethal.
Thank you. And I know you mentioned earlier that you took tissue samples for toxicology testing. Is that correct?
Yes.
And what were the results of those toxicology tests?
The toxicology was negative for alcohol and common drugs of abuse.
Okay. Nothing further?
Question.
Thank you, Hannah.
Thank you.
Good morning, Doctor.
Good morning.
Doctor, I first want to ask you about your classification. Now, you've been doing autopsies, and you said, I think, 33,000 or 3,500?
Yes, 3,500.
3,500. How long, how many years have you done autopsies?
I came to the OMI straight out of fellowship in August of 2014.
Okay, so 10 years.
Yes.
And you are very familiar with the classification system, whether it be a homicide or accident, correct?
Yes.
And in this case, you ruled the cause and manner of death to be accident.
Yes.
And in a homicide, your definition you gave was to rule it a homicide, it has to be a volitional act caused by another to cause death, correct?
Yes.
And volitional means purposeful?
No.
What does volitional mean?
Volitional volitional means a voluntary act. It doesn't mean that there is, it doesn't always mean there's intent. You don't need intent. So something as simple as pulling a trigger could be the volitional act.
Okay, but in this case, you reviewed reports and you got information, and based on that, your determination was that this was an accident.
Yes.
And when you said accident, I think you described that as what must not be present is intent to cause death.
There should not be intent to cause fear, harm, or death.
Okay.
That's correct.
So in the materials you read and the information you reviewed, you did not find an intent to cause death by anybody.
That's correct.
Okay. And with regard to that classification, that is an official state of New Mexico ruling, correct?
Yes.
Okay. And that is an accident.
Yes.
Okay. I know in your notes that you documented the approximate time of the incident was about 13:48. Is that correct?
Yes.
And that is 1:48?
Yes.
Okay. And then you documented that Ms. Hutchins arrived at the hospital approximately 15:20. Is that right?
Yes.
And that is 3:20.
Yes.
Now, that is approximately an hour and a half delay. Is that right?
Yes.
And you knew that she was being attended to by EMT personnel and there was a helicopter waiting to take her to the hospital. Is that right?
Yes.
Do you have any idea why there was a delay in the hospital taking her?
No.
Okay. Now, during your findings, you did a CT scan before your external examination, correct?
Yes.
Did you find evidence of prior medical intervention from Ms. Hutchins?
Yes.
And what was that evidence of medical intervention?
She had been intubated. The intubation was actually in the wrong place. It was in the esophagus. It was removed when she arrived at the hospital, but she was also re-intubated into her esophagus, so not into the airway. She had also had surgical intervention. So they had opened up the chest cavities on both sides due to the presence of a gunshot wound. They had also opened up the protective covering surrounding the heart to try to do what they call manual cardiac massage to restart the heart. It's my understanding that she was pulseless upon arrival and non-responsive and not breathing.
You said that she had an intubation and another intubation. Is that right?
Yes.
And they were both in the esophagus.
Yes.
Now, an esophageal intubation can be a dangerous situation, correct?
It's an ineffective way to respirate someone or to establish air.
And in fact, can that potentially cause an anoxic situation, lack of oxygen to the brain?
Well, the injury itself is what causes the anoxic situation, but the intubation into the esophagus isn't giving adequate airway establishment.
Because, doctor, when you do the intubation, you're trying to get it into the bronchus, correct?
Yes.
And the bronchus, can you tell the jury what the bronchus is?
The bronchus, the main stem bronchus is the main airway that goes to both lungs. It eventually divides into a left and right bronchus. It goes to each lung.
And so by putting it in the esophagus, that is basically sending oxygen into the stomach.
Yes.
And part of your notes, I know you indicated that Ms. Hutchins was complaining of shortness of breath.
Yes.
And so an intubation into her esophagus would not have assisted with that, with helping her to get that oxygen.
That's correct.
Did you also find on your CT examination that there was a chest needle that was tried to put in?
They attempted to put in a central line, which means you're trying to get fluid to in the most effective way possible. Because of her situation, they had to put blood products directly into her heart.
And did that, based on your review of that CT exam, it looked like it did not go in properly?
And it was.
Okay.
I couldn't tell that based on the autopsy or the CT.
Okay. So the esophageal intubation, do you know who performed that? Do you know who did that?
I do not.
The CPR efforts you observed, do you know who performed those?
Not off the top of my head, no. I would have to review the medical records.
Based on everything that you saw as a medical doctor, had this not taken an hour and a half, had Ms. Hutchins received more timely medical intervention, could she have possibly survived these wounds?
That's difficult for me to answer that question because I'm not a doctor who treats gunshot wounds in the chest, and I have a very skewed view regarding the lethality of gunshot wounds. So that's outside my purview.
When you were interviewed, didn't you say she possibly could have survived?
Potentially, but I'm not the best person to ask for that question because I don't treat patients.
Okay, but you previously had said that. You
Yes.
acknowledge that. Okay. Thank you, Heather. I have nothing further.
Council Clerk, real quick.
Dr. Gerald, what was your determination as to the cause of death of Halyna Hutchins?
Her death was caused by a gunshot wound to the chest.
Thank you. And you said that you performed this autopsy on October 22nd, is that correct?
Yes.
And your date of death was October 21st, is that correct?
Yes.
So you had approximately 1 day's worth of investigative materials available for you to review, is that correct?
Yes.
Okay, thank you.
All right, thank you. You're excused. By court order, the photographer is not allowed to publish any of the OMI pictures. Those are the autopsy photos, the 3 exhibits of the autopsy, and that the order is either direct or picking up it indirectly. All right, next witness.
The state calls Stephen Moore.
Do you swear or affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. Have a seat. Talk into the microphone.
I'm not gonna show the photo immediately, but we're gonna need to put it up there shortly. Sir, go ahead and state your name for the record.
My name is Stephen Orr.
How are you currently employed?
I'm with the Santa Fe County Sheriff's Office.
And what position do you hold at the Santa Fe County Sheriff's Office?
I'm currently assigned to the Civil Division.
How long have you been employed there?
In the Civil Division or with the Sheriff's Office?
With the Sheriff's Office.
Just over 15 years.
And do you have law enforcement experience prior to going to the Santa Fe County Sheriff's Office?
Yes, I'm retired from the Albuquerque Police Department.
How long were you with the Albuquerque Police Department?
From 1990 to 2004.
And did you become involved in this case somehow?
Yes.
How did you become involved in this case?
On October 28th, 2021 at about 3:01 p.m., Sergeant Chris, for whatever reason, I was at the office. I don't recall the reason why I was at the office that day, but Sergeant Chris Zook found me in the office. He knows my firearms background and asked me to take a look at a rifle that they were having trouble clearing.
What's your firearms background?
I became a firearms instructor in 1991. I'm currently a master firearms instructor in law enforcement with handgun, rifle, patrol rifle, and shotgun. I'm a master hunter education instructor. I became a hunter education instructor in 2000, currently a master instructor for hunter education. I'm an armor and Glock pistol, AR-15 platform rifle, bolt action rifle, and police shotgun.
You know a little bit about guns.
A little bit.
I think it was maybe October 27th. On October 27th, were you asked to assist with this case?
I thought it was the 28th, but it could have been the 27th.
It might have been the 28th that you got involved.
I got involved, yes, because at the scene of this incident, I was not involved. I just, once again, happened to be at the office that day. And Sergeant Zook, knowing my background, just simply asked for some assistance.
Okay, I'm going to show you what has been previously entered into evidence as State's Exhibit 10. Do your 10-step process.
Okay.
I'm not seeing it on the other monitors. Oh, I'm sorry. It's already been entered in evidence, so I think we can publish it. Let's go ahead and do that. Do you recognize that?
It didn't come up, but it flashed for a moment before, but yes.
You don't have it in front of you?
No, ma'am.
Ten.
I do now, yes. Okay, yes, yes, ma'am.
Do you recognize
I
that?
do.
Where did that come from, and how did you end up in possession of it?
Once again, I was at the office. I don't recall the reason for the third time. I don't recall the reason why I was at the office that day. Sergeant Zook, who was at the time the sergeant of the Criminal Investigation Division, asked me to take a look at this rifle. Apparently, there were some cartridges that were stuck in the gun, and he didn't know how to clear it, so he asked me to clear it for him. So to answer your question, what I'm looking at here is a Henry Patton Allen Arms 4440 lever action rifle.
So let me ask you, was the gun jammed?
It was jammed, yes.
Why was the gun jammed?
Well, first of all, let me explain the difference between a jam and a malfunction. Okay, a malfunction is something that can be readily cleared by the operator of the firearm. A jam is something that's going to take an armor, possibly even a gunsmith, to take it apart. What happened with this particular firearm here? There was a cartridge of the wrong size, the wrong diameter, entered into the tubular magazine of the gun. And as Sergeant Zook was trying to eject the rounds, probably by, I'm only guessing because I wasn't there, by moving the lever action back and forth to eject the rounds from the gun, the round of the wrong caliber wouldn't chamber into the firearm, so then it couldn't be ejected.
So did the gun jam because Sergeant Zook was manipulating the lever action, or did it jam because there was a wrong caliber bullet in there, or cartridge rather? Well,
The cartridge wouldn't properly chamber, so since it couldn't properly chamber, it couldn't properly eject. So that's what caused the jam.
So can you explain to the jurors how that gun would have been able to receive a cartridge of the wrong caliber to begin with?
Yes. Do they have a picture of this gun in front of them?
They do.
Okay.
And your monitor has arrows and all kinds of stuff. I'm not an expert at using that, but.
Okay, this right here, you'll see, I don't know how to use the arrow here. Okay. Okay. There's a lever right here that you can see, and you move this lever forward, all right, to the front portion.
Yes.
Proceed, sir.
Okay, the way this gun is loaded, all right, you can see right here, this little tab. Okay, it's held back by spring tension. You overcome spring tension by moving it forward. And the front of this gun here has about the last 3 or 4 inches will rotate sideways, opening up what's called a tubular magazine. All right, a tubular magazine, for lack of a better term, is like a fat metal straw. Okay, and the cartridges can be dropped down into that tubular magazine. Now, the diameter of slightly larger than caliber ammunition. And that is what happened in this case. Once the tubular magazine is loaded, then the fore portion of the muzzle is closed up, and the rifle can be cycled by lever action. And what you have down here is the lever action, which basically is the action of the.
So the 45 caliber cartridge was fit in that, did you call it a loading? 45, because it was the wrong caliber, was too large to cycle through.
Correct.
Okay. And were you brought in to fix this gun and make it safe?
Yes.
And were you able to do that?
Yes.
How can this gun be unloaded once cartridges are put in the tubular magazine?
Well, there are 2 ways to unload this gun. Okay, the first one is what I'm guessing that Sergeant Zook did. Okay, and all he did was this lever action right here that I have pointed to. Okay, you work it back and forth in a lever action type motion. All right, and I can go through the mechanics of the gun, but the simple answer is through mechanical linkage, the cartridge is removed from the tubular magazine, entered into the chamber, and then the extractor will pull the round out of the chamber and kick it out of the gun. So depending on the number of rounds you have in the tubular magazine, if you have 5 rounds, in theory, you run the action 5 times and all 5 rounds will kick out of the gun, will be ejected from the gun. The other way to unload this gun, and the way I ended up unloading this gun, is once again, I showed you this little lever right here, pulled it forward, the front barrel of the gun will rotate to the side and exposing the top part of this metal fat straw that I explained to you. All right, you turn the gun upside down, for lack of a better term, and gravity is your friend, the rounds fall out.
Thank you, sir. I'll pass the witness.
Cross-examine.
Good morning, sir.
Good morning.
So the round that was actually in this gun, do you know if this was actually a dummy round that was inside?
I don't know.
Would there be any danger if it was a dummy round that was inside?
If it were, if you describe the 2 differences between a dummy round and say a blank.
Okay, but you didn't know one way or the other?
I did not.
It could have been a dummy round that was.
Could have been a dummy round, yes.
And it sounds like Zook didn't properly unload this gun. Would you agree with that?
I have no idea because I don't know what happened to the gun prior to me putting my hands on it. And I can only describe the configuration of the gun is when I got it. What happened with Sergeant Zook prior to me taking possession of the gun for that brief period of time, I can't tell you. I just don't know.
Well, Zook came to you because he couldn't figure out it himself, right?
Yes.
So he wasn't properly unloading it. Agreed?
I think he was trying, but I would agree. Mm-hmm.
Okay. So he was trying, he couldn't do it. But isn't this rifle, the way you just described this to the jury, it's pretty easy to unload, isn't it?
If you're familiar with the firearm, sure. I mean, anything's easy if you know about it, and you don't know until you do.
So you just open the rifle and the rounds fall out the bottom, right?
Well, it fall out the front.
Or they fall out of it once you open it, right?
Yes.
And you said your involvement in this case was, or in that limited role was because nobody really knew how to take this gun apart, right?
Correct.
And you told us that in a pretrial interview as well, right?
Correct.
Now, you don't know who loaded that rifle with that round.
I did not.
Cleared, do you? And you didn't interview any of the multiple people in this case who reportedly loaded firearms?
I did not.
No further questions.
Redirect.
So hypothetically, if Sergeant Zook attempted to unload the gun by manipulating the lever action, as you demonstrated, is that an incorrect way of unloading the gun?
No, it's not.
That's a perfectly legitimate way of unloading that gun, correct?
Yes, until the incorrect round was attempted to be loaded into the chamber. Up to that point, yes, that was the correct way of unloading the gun.
Okay. Nothing further, thank you.
All right, thank you, you're excused. Next witness.
State calls Byron French.
Just raise your hand.
Do you swear or affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right, thank you. Have a seat, talking to the microphone.
Good morning, sir. Go ahead and state your name for the record.
Good morning. My name is Byron French. I am employed by the Rio Rancho Police Department, but I am signed to the FBI's New Mexico Regional Computer Forensics Lab as a task force.
Can you give us some indication of your background and training with regard to cellular phone extractions?
Yes, ma'am. I'll start when I first became a law enforcement officer. I graduated the academy in January of 2011 from the New Mexico Law Enforcement Academy here in Santa Fe. The first 4 years I was on patrol, and then the opportunity arose to become a digital forensic examiner at the New Mexico Regional Computer Forensics Laboratory. I got assigned that position, and it's a 2-year certification process approximately. Every examiner starts out working Windows computers, doing forensics, digital forensics on Windows computers, and there is the opportunity from there to do digital forensics with cell phones as well. During the initial process, there's just the pipelines of training, and then I went through what's called the basic cell phone course with the FBI in Huntsville, Alabama, back in, I want to say 2017, July of 2017. From there, I've taken a couple of other different specialty classes when it comes to digital forensics and cell phones. Black Bag offers a Macintosh forensics class, and part of Macintosh is the Apple operating system. From there, I've taken another handful of other courses such as Celebrate. They offer what's called CCO, CCPA, and they are a forensic tool. And what CCO stands for is Celebrate Certified Operator. That is just one portion of the course, and it familiarizes you with the best practices to extract data off of mobile devices. The second part of that is CCPA. It is Celebrate Certified Physical Analyst. And that teaches you best practices and how to actually go through the data that has been extracted. From there, I have taken other courses such as a basic cell phone repair class. Sometimes we get these phones in as evidence and they're destroyed. I have the ability to repair them. I've been through advanced training, ISP and JTAG, and ISP and chip-off. ISP stands for in-system programming, and chip-off is just like it sounds. You take the chip off the device. I've also taken what's called SANS 585, Advanced Cell Phone Forensics. And just recently, I've been invited out to become an instructor for Celebrate themselves, to instruct those courses.
How did you become involved in this case, if you recall?
I believe it was back in 2019. Was it 2019 or 2020? I'm sorry.
2021.
2021. Sorry, not enough coffee this morning. Back in 2021, I was contacted by Detective Alex Hancock from the Santa Fe County Sheriff's Office to assist with phone extractions.
And did you perform a phone extraction on the cell phone belonging to Hannah Gutierrez?
I did.
And did you tell us a little bit about the extraction that you did, and what are you extracting? Are you extracting text messages, photos, everything? Give the jurors an idea of what's going on.
Sure. So in this instance, I did use the Celebrate program to perform an extraction, and there was 2 extractions involved. One is called a logical, and the other one is a file system. And generally, with those 2 extractions, you try and extract.
Counsel, can you approach? Sorry.
Sorry for the interruption, sir.
That's okay.
Pursuant to defense counsel stipulation, will the court recognize Mr. French as an expert in what areas are you usually qualified in?
Digital forensics.
Thank you.
Yes, digital forensic examinations. You're an expert.
Thank you.
Have you been qualified as an expert in that area previously?
Yes, ma'am, I have.
How many times?
Twice, once in the Honorable Martha Vasquez courtroom, not too far from here, and then the other in the Honorable Judge Johnson in Albuquerque, both United States District Courts.
Federal courts.
Federal courts.
Okay, thank you, sir. And at my request, did you review a particular photo?
I did.
And pursuant to defense counsel stipulation, I would like to enter into evidence and publish State's Exhibit 118.
Yes. Admitted and you may publish.
He's got it. Do you see that photograph on your screen?
I do, ma'am.
Is this a photograph that was on Ms. Gutierrez's cell phone?
Yes, it was.
And can you tell the jurors the day and time that this was taken?
Without looking exactly at the EXIF data, do we have a picture of that by chance, or?
I probably do.
That would help.
I wouldn't want to put it up on that screen. Let me ask you this. Do you remember the date that it was taken?
If memory serves correctly, I want to say it was around December 21st. Then that might not be correct because I was,
Right.
okay.
All right, sir. Let's take a,
I think the year could inform the jury. You just said December 20th.
but that's not the correct date. So
Oh.
I've looked at the exit data, so I know the correct date. So let's just take it. Give us just a moment here to clear this up. So I need to disconnect. Maybe.
All right, we're going to take our morning break. Please don't talk among yourselves or anyone else about the evidence received here in court, and we'll be back about, 10:10, okay? Thank you.
All right.
All right, you may be seated. We're in recess. See you back here then.
10:10 a.m. Mountain. That's strange because it's 11:13 Mountain here in Utah. Do they do daylight savings time early? That's bizarre. Let me Google that. It says it's 11:14. Oh, I know what's going on. We're on a delay here. Okay. All right. Let me skip over this.
All All right, you may be seated. Let's continue.
All right, thank you, Mr. French. Can you please tell the jurors the date that that photo was taken?
Yes, October 10th, 2021 at 9:50 in the morning.
Thank you. Elma, please. The state is going to move for the admission of States Exhibits 119 through 129. I don't believe there's an objection. No. Okay,
Sorry,
sorry.
states 119, 129 through 129 are admitted without objection. You may publish.
All right, thank you. Sir, prior to your testimony, did I send you some text messages?
You did.
Are those text messages from the extraction that you performed
Yes, ma'am.
on Ms. Gutierrez's phone?
Yes, ma'am.
Thank you. I'm going to show you what's marked as States Exhibit 19. Let's see. If you can just give us the date and time and whether or not those messages are incoming or outgoing, who they're going from and who they're going to.
Sure. So both of these messages appear to be outgoing from the what's identified as the owner of the device, Hannah Reed, to a contact named Becca Santa Fe. The first message has the timestamp at the bottom right of October 23rd, 2021, 12:28 p.m. And it says, "Hey, comma, I might be coming to Albuquerque tonight and was wondering if I can get that stuff." The next message has a timestamp of October 23rd, 2021 at 5:09 p.m. And it says, "Becca, call me when you get a chance."
And States Exhibit 120. Can you see that, or is it too small?
I believe I can see it.
Can you guys see it? Can the jurors see it?
Yeah.
You bet. We'll zoom in and we'll just move it around a little bit.
So the first message is an outgoing from the same contact, Hannah Reed owner, to Courtney Santa Fe. The message states, "He gets in 30 mins or so. Becca hasn't texted me back at all, and I'm trying to get my things from her tomorrow." This message was sent at on October 23rd, 2021 at 6:20 p.m. The next message is from Courtney Santa Fe to Hannah Reed, the owner of the device, and it just says "okay" with the timestamp of October 23rd, 2021 at 6:24 p.m. The next one is from Hannah Reed to Courtney Santa Fe. It says, "Kay, know if," excuse me, let me start over. "Kay, let me know if you hear from her at all. Thanks for checking on me again. Miss you already." And that is timestamped October 23rd, 2021 at 6:25 p.m.
So counsel has asked me to let you know that some of this would ordinarily be hearsay, but they've agreed to let the entire portion in, and it's for context, effect on listener. Okay, thank you.
States Exhibit 121.
Another message from Hannah Reed to Courtney Santa Fe.
Oh, I'm sorry. We just looked at that one. It was part of the previous group. We'll take 121 out. States Exhibit 122.
This one, the top message is from Hannah Reed, owner, to Courtney Santa Fe. And the message says, "Could Becca maybe drop off my things to y'all, since I haven't been able to catch her?" That is November 13th, 2021 at 7:02 p.m. The next message shown in there is from Courtney Santa Fe to Hannah Reed, owner. "I asked her to, hopefully she will." And that is the same time, or the same day of November 13th, 2021 at 7:06 p.m.
States Exhibit 123.
The top message is from Hannah Reed, owner, to Becca Santa Fe. "Hey, coming to Albuquerque tomorrow." That is timestamped November, it looks like 7th, 2021 at 2:52 p.m. And the next message is from Hannah Reed, owner, to Becca Santa Fe. "Gonna be there for a week or so." November 7th, 2021 at 2:52 p.m.
States Exhibit 124.
The top one is from Becca Santa Fe. From Becca Santa Fe to Hannah Reed, owner. "I'm in Roswell working on Barron and Toluca." And that is timestamped November 8th, 2021 at 9:20 a.m. The next message is from Hannah Reed, owner, to Becca Santa Fe. "Aw, is that far? Bummer, I wanted to see you." and that is November 10th, 2021 at 2:39 p.m.
State's Exhibit 125.
This one is from Hannah Reed, owner, to Becca Santa Fe. And it says, "Hey, Becca, mind if my brother-in-law picks up my things from you after Thanksgiving? He lives in Albuquerque." That is timestamped November 22nd, 2021 at 5:53 p.m.
State's Exhibit 126. I know these are a little out of order. We'll pull them together with another witness in terms of their chronology. Go ahead, sir.
This one is from Hannah Reed, owner, to Courtney Santa Fe. "Hey, do you have Becca's number?" And that is October 23rd, 2021 at 5:17 p.m.
State's Exhibit 128.
A message from Hannah Reed, owner, to Becca Santa Fe. Becca with the question mark, on October 24th, 2021 at 11:31 a.m.
And for context, 129.
This one, the first one, is from Becca Santa Fe to Hannah Reed, owner, and it says, "Hey, ... I am in Hamas working on Big Sky Splinter Unit." That is October 24th, 2021 at 11:33 a.m. The next message is from Becca Santa Fe to Hannah Reed, owner. "How are you doing, lady?" And that is October 24th, 2021 at 11:34 a.m.
Thank you, sir. I'll pass the witness.
Cross-exam.
Good morning, Mr. French.
Good morning, ma'am.
So you looked at phones, and I'm going to focus on Sarah Zachary and Dave Halls. You looked at those two phones, didn't you?
I did.
And for Sarah Zachary and Dave Halls, you bookmarked very limited data that you extracted, right?
Yes, ma'am.
So you didn't extract all the data on Sarah Zachary's phone, right?
I did full extractions on all phones that were given to me, ma'am.
And then you bookmarked the limited data and passed that on to Detective Hancock, right?
Yes, ma'am, that is correct.
And the same for Dave Halls. You bookmarked limited data and passed that on to Detective Hancock, right?
Yes, ma'am.
But isn't it true that you don't know the significance of any of the items you bookmarked and what they have to do pertaining to the shooting event, do you?
Can you phrase the question differently, please?
Sure, and you talked about this a little bit in your pretrial interview. The significance of the items from the phones of Sarah Zachary and Dave Halls. You bookmarked those, but you don't have any information. You don't know the significance of what you bookmarked in relation to the shooting event.
I don't know if I would word it as significance. I generally do what is requested of me within the request form.
Okay, so do you remember giving a pretrial interview in this case, November 29th of 2023? I
do.
Okay, and counsel, I'm referring to page 19 through 24. Okay. Do you remember being asked, specifically with respect to the examination of Dave Hall's phones, so of these items from his phone, do any of them have any significance to this event, this shooting? And answering, I don't know. I just bookmark it for the case agent. That way she could make her determination.
That's correct. I did say that.
Okay. So then you'd agree with me that the items that you bookmarked and gave and passed on that we're talking about here today pertaining to Dave Halls and Sarah, you don't know the significance of those items pertaining to the shooting.
Well, ma'am, it is not my job to determine significance.
Exactly.
I just determine, or I don't even determine, I just find what is asked of me within the request form, and I leave it up to the case and to continue her investigation with it.
Okay, and you also don't have any texts between Sarah Zachary and Sarah.
Yeah.
is it fair to say you don't remember any text messages in your review between Sarah Zachary and Seth Kinney
I don't.
before October 21st of 2021?
I don't, ma'am.
Okay. And you weren't asked to examine Seth Kinney's phone, were you?
I don't believe so. That was not one of the phones that was given to me.
And you weren't asked to examine Alec Baldwin's phones, were you?
No, ma'am, I was not.
Is that unusual to you that in a shooting case, not to be looking at the shooter's phone right away?
Not always.
Okay. But regardless, the work you did in this case was limited to what Detective Hancock specifically directed you to do. Fair?
Yes, ma'am.
Okay. Just a moment here.
Redirect.
Mr. French, are you aware that Mr. Baldwin submitted his phone for extraction in the state of New York?
Yes, I am.
Thank you. I have
This
nothing further.
witness is excused. Thank you.
Thank you.
All right, next witness.
He calls Luke Hayes. And just for the record, I'm going to reserve Mr. French just in case.
All right. So please don't talk to any other witnesses, sir. And also, as a reminder, no witnesses that have not been called yet should not be on the watch live stream or the reserved ones. Other than next, please.
You know, just let's hang on and do it when we get there. We've got to go through his background.
Okay, case the judge, raise your right hand.
Do you swear affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Have a seat, talking to the microphone.
Your Honor, pursuant to our agreement with security in terms of firearm safety, Mr. Rice is going to provide Mr. Haig with a box that has a firearm in it.
It has been cleared.
Yes. I suspect Mr. Haig will clear it again.
It is cleared.
Sir, can you go ahead and state your full name for the record?
Lucian C. Haig, spelled H-A-A-G,
How do you spell your first name?
Lucien.
How are you currently employed?
I have my own consulting firm in Carefree, Arizona, Forensic Science Services.
What does Forensic Science Services do?
I'm involved in firearms evidence examination, primarily the reconstructive aspects of shootings, distance determinations, long-range shootings, is it a ricocheted bullet, how close was the gun when it was discharged. Those are all reconstructive issues beyond the usual identifying a bullet or cartridges having been fired from a gun. That's something I also do, but my main focus is the reconstructive aspects of shootings.
What were you asked to do in this case?
Well, a number of things to determine
And let me stop you real quick. Were you asked to do reconstruction or were you asked to do more examination and identification?
Identification was a small part of what I did. I did do that with the evidence cartridge case, but primarily reconstruction.
In this case?
That's correct.
Okay. And can you give the jurors an idea of your background and experience, please?
Yes, most criminalists, which is my professional title, have a degree in one of the physical sciences. Mine is in chemistry with some minor in physics. That was obtained in 1963 from the University of California at Berkeley. I then went to California State College at Long Beach, taking 2 more years of study, which included 2 semesters of criminalistics. That course was taught by the primary firearms examiner for the city of Los Angeles. Other courses were mathematics, clinical chemistry, documents examination. That takes me to 1965, when I gained employment with the City of Phoenix Police Crime Laboratory as an entry-level criminalist. I was sent on to Arizona State University, local university, for additional coursework. I started attending meetings of professional organizations that deal with firearms evidence, because that became my main focus in the crime lab. Although I worked in all sections, I later supervised them. My real interest and passion was the ballistics or firearms unit of the laboratory. I left there being the City of Phoenix Crime Lab in 1982, so I was there about 18 years. I've been doing some private consulting
some teaching at that time. I was an instructor in criminalistics, which included firearms evidence. I started my own company when I left the city of Phoenix. My company became my full-time employer, and I've been working there ever since.
Sir, do you have any professional memberships?
Yes, there are a number of them. The most important one is an organization called AFTE, AFTE, the Association of Firearm and Tool Mark Examiners. I'm a longtime member. I became president in 1985 and 86, served on a number of committees. Other organizations include the California Association of Criminalists. That's the nearest regional area. I'm a distinguished member of that organization. I'm a member and fellow in the American Academy of Forensic Sciences, which has a criminalistic section. I'm an associate member in a European organization. That's most of them.
Okay. Can you summarize for us your presentations and publications?
Yes, I'm very passionate about presenting evidence among our peers in the AFTE group. So to date, I've presented, and most of them have been published, about 200 publications over the last 50 years or so. I've authored with my younger son, who you'll probably hear about, a textbook on shooting incident reconstruction, which is now in its third edition, with the unimaginative title, Shooting Incident Reconstruction.
Have you received any citations or awards?
Yes, the AFTE group I mentioned before has voted me Key Member of the Year award several times, distinguished member status. Likewise, the California Association of Criminalists, and they have a fairly uncommon award called the Roger Green Award. That's for historical work, and I'm very interested in history, especially cases that involve the use or misuse of firearms. So I received that award from the CAC.
And have you been qualified as an expert in the areas of firearm examination and or reconstruction?
Many times.
Approximately how many times?
Well, over the last more than half a century, 57 years, several hundred times, I'm sure.
Have you been qualified in both state and federal courts?
Yes, I have.
Have you been qualified in numerous states in the United States?
About half of the states in the United States and several foreign countries.
What foreign countries?
Northern Ireland, and Guam, I think, and in Canada.
Okay.
Several times.
Sir, do you have any particular interest or expertise in single action revolvers or old Western style revolvers?
Yes, I'm interested in all types of firearms and their mechanisms, but single action guns are, of course, what we see in Western movies. They're fairly straightforward. They're historic. Sam Colt is a well-known name, and he was an inventive genius, and his firearms to this day are still prized as collector item if you're so lucky as to have an original.
And how did you become involved in this case?
I think it started with a phone call in March of last year, where I was well aware of the case. I'd heard about it. I didn't know much about it other than there'd been some sort of a misadventure on a set with a death and an injury. So after that, documents were received. That's where I start every case. I want to read what's known about the case, what the issues are. Interviews were sent to me, a lot of photographs, and ultimately, in July of last year, I went to the local property room with the custodian there, and along with my younger son, Mike, we received, well, I think an inventory over 50 some items, but some of these had sub items in them. So that was the beginning.
As a part of the document review that you did in this case, did you review the ballistics report and the case notes from the FBI?
Yes, I did.
Okay, so expert?
Okay, is there any objection to tendering I'll ask the court to accept Mr. Hague as an expert in firearms examination and reconstruction.
All right, no objection. Yes, he's such an expert. Thank you.
Sir, so in addition to reviewing the FBI examination report and the case notes, you also took numerous items of evidence into your own possession and performed testing on those items. Is that right?
That's correct.
And was the evidence revolver in this case that I'll refer to as the Baldwin revolver, was that one of the items that you took into your possession and tested?
Yes, it was.
Let's start with the FBI report. Let's go ahead and give me a screen. Mr. Bowles, is Mr. Hague your witness?
Yes.
Do you want to look at these real quick?
Yeah.
Your Honor, I'm going to move for the admission of States Exhibits 130 through 146 and permission to publish with the witness as we move through his testimony.
Any objection?
No objection, Your
All
Honor.
right, states 130 through 146 are admitted and you may publish.
Sir, so we have on your screen States Exhibit 130, but before we speak directly to this, ultimately, did you form an opinion, and I know we haven't gotten there yet, but we're going to, did you form an opinion about how the damage to this firearm occurred?
Yes, I did.
And did you also form an opinion as to the working condition of the firearm when it was received by the FBI?
I did.
Let's start there. What was your opinion with regard to the working condition of this firearm when it was initially received by the FBI?
By various means, I could see that it was in proper working order as designed by the original inventor.
And tell us what you took into consideration in coming to that opinion.
Well, there's several ways. One of them is on my screen. I don't know if it's on your screen or not, but it's from the FBI examiner's report, a man named Bruce Ziegler, I believe.
Bryce, yeah.
But I looked at all of his photographs and notes. And on the left side are the 4 positions that the hammer can have with this gun when it's working properly and undamaged. The top one shows the hammer fully forward and down. That's the way it would appear if you had just fired it or even dry fired it. The next picture down looks pretty much the same, but it's not. The hammer is about 1/8 of an inch rearward. And now it has engaged an internal mechanism, a safety notch. So now the hammer and firing pin cannot reach a live cartridge. The third picture down is the loading position, also known as half cock. The previous position could be called, and it's often called, quarter cock. At that half cock position, the third picture down, the cylinder, which capable of holding 6 cartridges, is now free to rotate. Prior to this, in the upper 2 pictures, it was locked and secured by a small latch that we can't see in these pictures. Final picture, and the most important one, the hammer is at the full cocked, ready to fire position. You can now see the firing pin in the hammer, that it's fully rearward, and it's staying there. That will be important later.
And if you would, describe for us what the firearm is that you have in front of you. Is that this exact gun?
It's the brother to the evidence gun, same make, model, caliber. It's just not the evidence gun.
And would you demonstrate for the ladies and gentlemen of the jury the different positions and also specifically the half cock position and the rotation of the cylinder?
Sure. Well, I checked it, but again, just so everyone feels as comfortable as they're going to be around a firearm.
Hang on just a second.
You should probably stand in the middle.
Yeah, do you want to stand? And
Sure.
That would be great.
I'm left-hand dominant, so I have to explain that. The hammer is fully down. If there were a live cartridge in this gun, the firing pin would be resting right against it. So this is an unsafe carry position if it were a loaded gun. It would also be the position if I had just fired it. There would be a spent cartridge. The firing pin would be deep into the primer of that cartridge. You can also see if the trigger is back. Now when I pull it, there, that's the safety position. Very little movement, but the hammer is now about 1/8 of an inch rearward. The trigger is just popped forward, so it's got an internal spring that is resetting. Cylinder is still locked up, cannot rotate. Now when I pull it to the load position, you may have seen the cylinder rotate already. It's free to rotate now. The little latch that I mentioned, which we can't see, has been pulled down by that motion. There's a loading gate here on the side that's opened, and this is where I would either remove fired cartridges or place live cartridges up to a total of 6. After loading it, fully loading it, I close that gate. I have 2 choices. If I'm ready to shoot, I'm going to cock it. And if I've decided what I'm going to shoot at is to be shot at, pull the trigger. Hammer falls off of a ledge, a little notch. Actually, it's more of a step on the hammer. So now we're back to where we were a moment ago. If I'm going to fire it again, it back, hammer stays in position, which we saw in the photographs, which again is important because when we get to the damage that occurred with the gun, the hammer won't stay there. If I'm going to let it down, if I'm going to render this gun safe, I say, I'm not going to shoot. I do have to pull the trigger, but I get my thumb firmly on this spur, pull the trigger, let it down. Once I get past the halfway point, I can let go of the trigger and it engages the safety notch again. So there's all the steps. It's called a single action. Probably heard that term a couple of times because pulling the trigger accomplishes one single thing. It fires the gun.
In terms of, sorry. In terms of that loading gate and the loading of the gun, if you were to show me the primers and the head stamps of the rounds that you have in the gun, and we know that there are none, but this is, we're just gonna play pretend. Show me how you would show me what's in that gun.
Well, I bring it up, no one downrange.
Here, maybe we go this way, so that.
I bring the hammer to half cock.
Okay, we want to show the jury.
Let's go over here. So they can see
Oh,
behind
okay.
us. There we go.
She used the terms, the industry term, the head stamp. It's what's written on the cartridge. And in the middle of which is a primer. So if she wanted to see, or any of you wanted to see, are there fired cartridges in here? Live cartridges, all 6? I just rotate the cylinder. And we go a couple of times around, see if there are any empty chambers or fired cartridges or live rounds. If we wanted to take them out, if they're live, you just dump them out. If they're fired, you need this ejection rod here to knock a spent cartridge out because it's expanded.
So if you were to show me the rounds that you have in the gun in this manner, I can only see the head stamp and primer of one cartridge at a time.
That's right. In this view from behind the gun with the gate open.
Okay, thank you, sir.
I can take my seat.
Yes. So when you, oh, thank you. Is there anything else that you can think of from the documents that you reviewed that went into, that contributed to your opinion that the gun was in proper working order when it was received at the FBI?
Yes, the examiner was able to fire at least 12 live cartridges for comparison purposes to recover bullets in fired cartridge cases. The gun had to be in working order to do that. Had it been in the condition I later found it, you wouldn't have been able to do that.
And the condition that you later found it, can you just kind of describe what was wrong with it when you took it into evidence? And I'm going to pull an 8 up. This is going to be an exhibit that's already entered into evidence, Exhibit 97A.
It had been partially disassembled. It was in a gun box with some ties.
I'm working on it. Hang on. Pardon me, where's my? Okay, if you can use this as an aid and sir, your screen, you can, use it to draw lines and all kinds of stuff.
So it's a touch screen.
It is, if you need some assistance.
This is one of the FBI, of the many FBI pictures, and you're looking at 3 parts of the gun. The obvious one's the hammer.
I'm going to show you how to mark it and get rid of it.
How do I erase it? Okay. The hammer's pretty obvious. Here's the firing pin. I really wanted to make a circle. It's making arrows. Okay. You tricked me. Okay. We're looking at the hammer, and I'm really pressing hard. The hammer, the important part of the hammer are these notches you can see here. There's 2 clear notches, something goes in them. Well, one of them is the safety position. The next one is the load position. The one that's very difficult to see, and I almost obliterated it, is down at the bottom of my circle. That's where the full cock step would be, but it's been peened, P-E-E-N-E-D. It's been knocked off, rounded off, and it's full of very rough tool marks. The piece that would fit into each one of those is the trigger. And the trigger is the black piece here, but the tip of the trigger, in the industry is called the sear, S-E-A-R. That's the piece that goes in those 3 locations. And it really rests on this step when it's in the full cock position. So that's somewhat tenuous, and the pulling of the trigger causes it to slide off, the hammer to fall. There's a little piece in that circle I just drew. That's the broken off sear of the trigger. It's 2 names. The company that makes this reproduction gun calls it the Bolt, B-O-L-T. I've always called it a cylinder stop latch. It was the thing that was securing the cylinder in the safety position, in the full cock position, but not in the loading position. The left side of that goes up into the notches in the cylinder for those previous positions and drops down and allows the cylinder to rotate in the load position. So looking at those both photographically and in person, I could see that the full cock step or notch on the hammer was broken away, beaten away, or knocked away. Kind of hard to describe it if you don't see it under the microscope. And the sear was broken off. And the stop latch, the little wings, there's 2 pieces that protrude out. That also was broken. And the gun can't work in the normal fashion if it had been that way on the movie set.
And based on your document review, do you have an opinion about how the bolt, the trigger sear, and the hammer were damaged? What took place that caused that damage?
The hammer had to be in the full cock position and 1 or more substantial blows, impacts to the hammer, because it's just sitting, the sear and the trigger and the full cock notch are just sitting there engaged with each other, and it's a small area. So if you give a substantial blow, 1 or more, to the back of the hammer, it is stressing that area, and it will finally, and did, finally fail. And I can see under the microscope a lot of very rough tool marks where it's just rolled over and rounded off. It's no longer a step. It's a rounded area which cannot retain the trigger even if it was intact.
What's your understanding of the circumstances of the blows you're talking about?
As I understood reading the examiner's notes and report, it was an evaluation of whether this gun was prone to accidental discharge by an impact to the hammer.
Okay, we're gonna look at a few other photos here. Before I take this photo down, I'm gonna pause. Yeah.
Council President.
Mr. Haig, let's shift gears for just a moment. Based on everything that you reviewed and also the examination and firing of this gun that you yourself participated in, have you seen any evidence that the full cock hammer notch was filed or modified to allow faster shooting?
No.
Thank you, sir. I'm showing you what has been marked as State's Exhibit 134. Can you explain to the jury what we're looking at here?
Yes, you're looking at 2 triggers from a Colt reproduction single action revolver. The lower one is from probably the very pistol that's here today. It was a new Pieta Colt single action that my younger son owns. So that's the way it should look. The one above is the broken damaged trigger, and the tip of the sear is not even present in this picture. So that area is missing. Just trying to get the hang of this. It's right there.
Okay. And I'm going to show you what's been marked as State's Exhibit 137. Can you tell us what that is?
Yes, this is a view through an instrument called a stereo microscope, to which a camera's been attached, and you're looking at a putting back together, so to speak, like a broken teacup, where I'm putting the two parts together, and all that roughness you see there are manufacturing marks. Those aren't breakage marks, but just when they made the part on the one side of it, it's been machined, and under the microscope, you can see those lines. So if you look at that, you can sort of see the contour agrees, and if we put them, my son and I put them right back together, you just see a faint line. So we deliberately pulled them apart a little bit so you can see they're two pieces, not just a crack in a piece.
So just to be clear, what we're looking at here in State's Exhibit 137 is the trigger with the top part of the, or part of the sear, and then the part of the sear that was broken off. Is that right?
Yes, two pictures back. If you remember, there was a little piece of metal off to one side and the trigger with a piece missing. That's what you're looking at here. Those have been put back together, are brought close together under the microscope.
And this is just a demonstration that the piece of the sear that broke off fits back on to the trigger sear mechanism, sort of like pieces of a puzzle.
Yes.
Okay.
But it's not ground off or rounded off. It's snapped off. It's broken off.
State's Exhibit 138. Can you tell us what we're looking at here?
Again, you're looking through the microscope at the evidence hammer as I saw it. And this area, try to do this a little better. That's where there should be a nice right angle step, and there isn't. It's just rounded off toward the right. The other two are the load notch, and they truly are notches, and the quarter cock or safety notch. But the circled area should not look like that. There's no step there. At this point.
And it's here.
Yes.
State's Exhibit 139. Can you tell us what we've got here?
Council, may I ask, were these introduced? Were they admitted
Yes,
earlier?
I believe so. I asked to admit.
Oh, 130 through 146. Okay, thank you.
Got it. Okay. Go ahead, sir.
You're looking at four hammers in sort of an oblique view. Three of them, my younger son and I provided. I bought two. He took one out of the revolver you saw here today. But the one here is the evidence hammer. And if you look across at the other three, you can see that they're visually quite different. And again, the evidence hammer has very little left for the sear of even an unbroken trigger to rest on. So that was a purpose, just to show what do these things look like, and does the manufacturer make them in a reproducible way? And of course they do.
Okay, thank you. State's Exhibit 135.
Yes, this is the, again, company calls it the bolt. I know it as the cylinder stop latch. You, as a user, would only see that part. Comes up and down inside the frame of the gun to lock the cylinder up once you release it. The rest of it's well within the gun, and it's being operated when you pull the hammer back, and it's broken. One of the little ears or tabs is broken off.
Can you hold up your exemplar revolver and just show the ladies and gentlemen of the jury the area of that bolt that you have circled? Can you just show the ladies and gentlemen of the jury the notches on the cylinder where that engages?
Sure. You might be able to see the notches here. They come around. That's where the latch goes in. You can't see the latch unless we disassemble the gun. If you were to have this in the jury room and you were to look through here, there's a little bit of daylight. I can see it pop up and I can hear it go into the battery, so to speak. But otherwise, you will not see it. You just know if it's working or not.
And show me, I'm sorry, can you show me the notches on the cylinder where?
Sure. Let's bring it to the load position.
Let's walk around so that they can see it just a little bit better, especially since it's a dark metal, it's hard to see.
I'll just walk down the line. My finger's right at one of them. Okay.
Thank you, sir. I'm going to shift gears real quick because then we're going to have to move to another machine. Were you also asked to examine some 131. Do you recognize that?
I do.
What's that?
It's a disassembled 45 Colt cartridge with a type of bullet known to the shooting community as a semi-wad cutter bullet. The red material is just a lubricant that can be any color. So it's not the red color that's important, it's the shape.
The source of this cartridge, and when I say source, I mean in terms of the relevant location.
Supplier,
Okay.
props, dummy cartridges, so on.
Do you know if that was PDQ props?
Yes, I recognize the name.
Okay, 33. What's this?
This is one of 5 live cartridges that were appearance. And this is pretty much like a traditional bullet from the late 1800s, early 1900s. And again, a cartridge case, 45 Colt cartridge case is on the left. So if we have a live primer in that cartridge and put it all back together, it's a live cartridge, not a dummy.
A box of ammunition. Would, let's say I'm buying 45 Colt caliber ammunition. Would that box perhaps include what we're seeing in 133 and also what we're seeing in 132?
From professionally made purchased ammunition, you're not going to see an M&M situation or mixed bullets. They're all going to be the same weight, style, same kind of propellant, same head stamps, and of course the same kind of primer. They can come either nickel plated or plain brass.
And the live ammunition that was taken from the set of the movie Rust, can you describe the characteristics of that live ammunition in terms of the head stamp, the primer, those sort of exterior identifying?
Yes, you can't see the primer, of course, because the cartridge is turned sideways, but it's a nickel-plated primer. It looks like chrome, shiny nickel-plated. If it were back-loaded, you would only see the top, basically half of the bullet. The part with the blue lubricant would be inside the cartridge case, and the powder, the gunpowder, in the little vial would, of course, be inside that cartridge. So putting it all back together, you'd have a complete round of ammunition. For these cartridges was Starline. It's a very well-known manufacturer of cartridge brass. They do not manufacture loaded ammunition, at least not as I sit here today. So Starline's well-known. I use it myself. I'm a hand loader. That's what you would see if we turned that cartridge up so you could see it.
And what color was the primer on the live ammunition?
I think I said it, but I'll repeat it. Nickel-plated, shiny.
I apologize. Thank you. And let me ask you, do you know exactly like this be purchased at local gun stores?
In the gun stores I go to, yes.
And at my request, did you obtain some and send me some pictures?
Both my son and I bought boxes of commercial 45 Colt ammunition with lead round nose bullets with a flat spot on the nose. The powders weren't necessarily identical to what we see here, but they're a type of pistol powder.
States Exhibit 141, what's this?
This is the outer box of one of those, which I believe my younger son Mike bought this one. HSM is a small ammunition company. And you can probably read, it's meant for cowboy action shooting. It's a popular contest with traditional single action shooters. Those cartridges have the Starline head stamp. and lead bullets, flat nose.
let's go to exhibit.
Well, you can fold the card head stamp in the view. Going between, and then of course the addition and nickel primers, shiny nickel colored metal.
And State's Exhibit 143.
This their weights in the United States, bullets are weighed in an archaic term, frankly, called grains. 7,000 of them in a pound, but 250 grain is the traditional classic weight of the Colt bullet. So this company, HSM, now tells us you can expect if you were to shoot one of these bullets and collect it and put it on a balance that weighs in grains, it's going to be around 250 grains, plus or minus a grain or two from the shooting and impact process.
So the grain comes from weighing the bullet.
That's right, just the bullet, not the cartridge or the powder.
And just as an aside, did you examine? I had it in the time that you had it.
No, it had lost some weight. It started out life, in my opinion, as a 250 grain bullet, but it suffered reduction from and it gets some rubbed off. Plus it went through 2 people and it struck bone. If you've seen pictures of it, or if you do later, it's got a lot of impact damage from striking bone. So for those 2 reasons, it weighed about 240 grains, as I recall. 10 grains is not much. And it was now reduced in diameter to about 44 instead of 45.
But in your opinion, that projectile started out as a 45 Colt 250 grain bullet.
Yes.
And let me go to State's Exhibit 144. What's this?
One of the cartridges from that box of ammunition that you saw earlier has now been removed. So you see it's nice and shiny and new in the brass. And the bullet is, again, not too unlike the one with the blue lubricant in it. It's round nose and it's truncated, so it has that flat front called a meplet.
And just for completeness, State's Exhibit 146.
Yes, it's just a closer view of one of the cartridges from that HSM.
And so this cartridge has the same physical characteristics in terms of the shape of the bullet. Is that right? And we're comparing them to the live rounds found on set.
Yes.
And they both have brass casings. Is that correct?
Yes.
They both have the Starline brass head stamp.
That's right.
And they both have nickel plated primers.
Yes. Yes, they do.
Thank you. That's fine. Okay, thanks. We'll just need to make a note of it like you did. I appreciate that. Let's connect over here. Sorry, guys. At my request, did you meet me in August at the Santa Fe County Sheriff's Department? August of 2023.
Yes.
And can you summarize for the ladies and gentlemen of the jury? Also, I think your son was assisting us.
Yes, he was. We had been requested to reassemble the evidence revolver with the broken parts, mainly the hammer and the trigger, with just the broken hammer with the knocked off full cock step, to see if it even could be cocked and would retain the cocked position.
And while we were there, did we take some videos?
I'm sorry?
Did you record some videos while we were there?
Yes, we actually did it a number of times after we reassembled it, with and without the cylinder in the revolver, and videotaped, I think, 6 runs in one session and 3 or 6 in the other.
We're only going to watch 2.
Okay.
Okay. Let's do it. I'm going to get them started once you give me the screen. What's that? Thank you, Judge. Where are we? This is 147. Okay, hang on. Bear with me here. We're ready.
So
Let me stop
move
it.
into evidence, states 147 and 148, any objections?
It's actually gonna be 147 and 147A.
Okay. All right, any objection? All right, so 147, 147A is admitted, you may publish.
Let me turn that volume down. I'll play States Exhibit 147. Hang on. I took it down too far.
With the following exceptions.
Is there an issue with audio?
Describe what we've done. Original with the following exceptions. This is a new trigger and sear, same case. It's the original hammer. It does also have a replacement bolt or cylinder catch. Otherwise, as mentioned, every pin, screw, spring, whether that's the main hammer spring or the flat spring that operates the trigger, are original to the revolver.
So what we did is, just as a recap, this is the Baldwin gun, is that right?
That's correct.
And the hammer, or I'm sorry, the trigger is a new unbroken trigger, is that correct?
That's also correct.
And the bolt that we saw in the photos that had kind of lost an ear, is that replaced?
Yes.
But the hammer that's in this gun is the original hammer from this gun, is that correct?
But damaged, yes. And that was the whole point. That's the damage. How does it affect the operation of the gun if we isolate the hammer?
So this is the hammer that you believe was damaged at the FBI.
Yes.
Hammer falls is captured at the half composition.
So what did you ask your son to be holding the gun?
I asked him to go through the normal cycle. If you produce this firearm and cock it and expect the hammer to stay cocked until you pull the trigger, it will not. Because that full cock step or notch has been rounded off, the perfectly brand new trigger cannot retain the full cock position. The hammer falls to what you just saw, and it falls to that half cock notch. So the good trigger and its sear drop into that notch, preventing the gun from firing. So that's intentional. That's what Mr. Colt intended. If somehow the gun got worn and the hammer started to drop when you cocked it, it's going to get captured. And if it gets past that point, it'll be captured by the quarter cock notch.
Okay, demonstrate the positions of the hammer. Positions. From full down when the firing pin is protruding from the breech.
Can you see the firing pin protruding from the breech in this video?
Yes, when I first described how this gun works for you, the hammer is fully down. So it's either just fired a cartridge, or this would not be a good way to carry this gun with live ammunition, because that firing pin is resting right against a live primer if there was a cartridge in this gun. And it wouldn't take much of a blow. You don't have to hit it hard. Just drop it from a few inches in this configuration, and it'll fire.
And from here, the trigger will not allow the hammer to drop because of the shape of the notch in the hammer. From the half cock or low condition also, pulling the trigger does not drop the hammer. And the cylinder is now out of alignment with the axis of the bore. And then
Tell us what you mean there, and why is that important?
The court has placed on council's tables the final instructions. The council have their copies.
Yes, Judge. Yes, Your Honor.
Thank you. We can bring the jury out, please.
My only question, Your Honor, and I'm looking at.
Well,
I
let's
just
not
wanted
bring
to-
the jury out and also have your question. Hold the jury. Tell them hold the jury.
Sorry, Your Honor. I just want to be sure that, and I haven't had a chance to look at this version, but to make clear and just quickly looking at it, that, and maybe the court would either add a sentence, or if it may be in here in this version, that the intent to murder has to come before an agreement to commit, to enter into a conspiracy. And I think it's in here, but I just wanted to state that for the record. When I originally looked at it, I think the order of the elements, I mean, they're all in there, but I think that should have been first, and I don't know if that's now clear. I'm just noting that for the record.
We can bring the jury out, please. Will counsel stipulate, please?
Yes, Your Honor. Yes, Judge.
Ladies and gentlemen, at this time, what the court will do is advise you on the law of the case. Because this will take approximately 50 minutes, the court has asked the clerk's office to make a copy of the instructions for each one of you. And we will ask Madam Clerk to hand out those copies now. You may choose to listen some and read some. You may choose to just read along. That's up to you. You have heard the evidence presented in the case. It is now this court's duty to instruct you on the law which applies in this case. It is solely this court's function to explain the law that applies in this case and how you are to apply it. It is your obligation to accept the law as the court states it. You may not choose to follow some instructions and ignore other instructions. They are equally important. You are the sole judges of the facts. It is your duty to find or determine the facts. You are to recollect and weigh the evidence and form your own conclusions concerning the facts. You may not go outside of the evidence presented in court to determine what the facts are. You may not resort to guesswork, conjecture, or suspicion. You may not be influenced by personal likes or dislikes, prejudices, or sympathy. You may not be influenced by this court's actions during the trial or the comments to counsel or objections by counsel. You may not be influenced by the court's questions to witnesses. You are not to consider this court's actions as an indication of its opinion as to how you should determine the facts. If during the instructions the court refers to any evidence, it is only for the purpose of clarifying a point of law or a point of illustration. The court does not intend to emphasize some evidence and downplay other evidence. If the court's recollection of the evidence does not match your recollection controls. The defendant justly relies upon you to consider carefully her claims and to consider carefully all of the evidence. The defendant also relies upon you to find her not guilty if the facts and the law require such a verdict. At your hands, the defendant rightly expects fair and just treatment. At the same time, the state of Connecticut looks to you to render a verdict of guilty if the facts and the law require such a verdict. The law prohibits the state's attorneys or defense counsel from giving personal opinions about the defendant's guilt or non-guilt. It is not their assessment of the credibility of witnesses that matters, only yours matters. In this case, as in all criminal prosecutions, the defendant is presumed to be innocent unless and until proven guilty beyond a reasonable doubt. The presumption of innocence continues with this defendant unless you determine, based on all of the evidence considered in light of these instructions after deliberations, that the defendant is guilty beyond a reasonable doubt. The presumption of innocence applies individually to the crimes charged. The presumption may be overcome only if you are satisfied after deliberations that the state has proven the defendant's guilt to the crimes charged beyond a reasonable doubt. If you conclude that the presumption of innocence has been overcome beyond a reasonable doubt, then it is your duty to render a verdict of guilty on that count. The state has the burden of proving that the defendant is guilty of the crimes with which she is charged. The defendant does not have to prove innocence. This means that the state must prove beyond a reasonable doubt each and every element necessary to constitute the crime charged. Whether the state carries its burden does not depend on the number of its witnesses or on the amount of the testimony, but on the nature and quality of the testimony. One witness's testimony may be sufficient to convict if it establishes all of the elements of the crimes charged beyond a reasonable doubt. Now, you have heard the term reasonable doubt. The court will instruct you now on its meaning. We will first explain what is not a reasonable doubt. It is not a surmise, a guess, or a mere conjecture. It is not a doubt raised simply for the sake of raising a doubt. It is not hesitation springing from any feelings of sympathy for the defendant or for any other person affected by your decision. Reasonable doubt is a real doubt, an honest doubt, a doubt that has its foundation in the evidence or lack of evidence. It is a doubt that is honestly entertained and is reasonable in light of the evidence after a fair comparison and careful examination of the entire evidence. When thinking about the term reasonable doubt, concentrate on proof beyond a reasonable doubt does not mean proof beyond all doubt. The law does not require absolute certainty on the part of the jury before it returns a verdict of guilty. The law requires that after hearing all of the evidence, if there is something in the evidence or lack of evidence that leaves in your minds a reasonable doubt as to the guilt of the accused, then the accused must be given the benefit of that doubt and be acquitted. Proof beyond a reasonable doubt is proof that rules out every reasonable hypothesis except guilt and is inconsistent with any other rational conclusion except guilt. The state has the burden of proving the defendant's guilt beyond a reasonable doubt, and that burden of proof rests with the state. It means that the state must prove beyond a reasonable doubt every element of each crime charged. The court will now discuss intent. Intent relates to the condition of the mind of the person who commits the act. It is his or her purpose in doing it. Specific intent is the intent to achieve a specific result. A person acts intentionally with respect to a result when his conscious objective is to cause such result. What the defendant intended is a question of fact for you to determine. All of the crimes charged in this case are specific intent crimes. As with all of the other elements, intent must be proved beyond a reasonable doubt. The court would indicate to the marshal that no one is to enter the courtroom when the court is giving instructions, no one's to leave. Court will next instruct you on proximate cause. The state must prove beyond a reasonable doubt that Fotis Dulos proximately caused the death of Jennifer Dulos. Proximate cause does not necessarily mean the last act cause or the act and point of time nearest the death. The concept of proximate cause incorporates the principle that an accused may be charged with a criminal offense even though her acts were not the immediate cause of the death. An act or omission to act is a proximate cause of the decedent's death when it substantially and materially contributes in a natural and continuous sequence, unbroken by an efficient intervening cause, to the death. It is a cause without which the death would not have occurred. It is a predominating cause, a substantial fact the death follows as a natural, direct, and what the person's intention is usually a matter of inference. No person is able to testify that he looked into another person's mind and saw therein a certain knowledge or a certain purpose or an intention to harm someone else. Because it is very hard to have direct evidence of the defendant's state of mind, intent is generally proved by circumstantial evidence. The only way a jury can ordinarily determine what a person's intention was at any given time is by determining what the person's conduct was and what the circumstances were surrounding that conduct, and from that infer the defendant's intention. As jurors, it is your function to draw those inferences as long as the inference you draw meets the standard it has to meet as explained in connection with the instruction on circumstantial evidence. You are not required to infer a particular intent from the defendant's conduct or statements, but you may draw an inference if it is reasonable and logical. The burden of proving intent beyond a reasonable doubt is on the state. Now, the law does not require that the state in a criminal case prove a motive, because it is not a necessary element of the crimes charged. It is not necessary for the state to prove what reason the defendant may have had for committing the crimes charged. Because crimes are generally committed for some motive, evidence of a motive may tend to prove the guilt of the defendant. In the same manner, if there appears no adequate motive on the part of the defendant to commit the crime, that may tend to raise a reasonable doubt as to the guilt of the defendant. If the existence of a motive can be reasonably inferred, that may tend to prove the defendant's guilt. If no motive can be inferred, it may or may not raise a reasonable doubt as to the guilt of the defendant. If the absence of a motive does not raise a reasonable doubt that the defendant is guilty, then the fact that the state has not proved what the defendant's motive was does not prevent you from returning a verdict of guilty. We will now discuss direct and circumstantial evidence. The evidence from which you will decide what the facts are consists of: one, sworn testimony of witnesses both on direct and cross-examination, regardless of who called the witness. Two, the exhibits which have been admitted into evidence. Three, any facts which the court judicially noticed. And four, any stipulations of the parties. In reaching your verdict, you should consider all the testimony and exhibits admitted into evidence. Certain things are not evidence. And you may not consider them in deciding what the facts are. These include arguments and statements. The lawyers are not witnesses. What they have said in their closing arguments is intended to help you interpret the evidence, but their remarks to you are not evidence. If the facts as you remember them differ from the way the lawyers have stated them, your recollection prevails. Now, testimony that has been excluded or stricken. Some testimony may have been stricken, which means you may not consider it. Please remember that a lawyer's question by itself is not evidence, and you may not consider it as such. the document called the information. You will have this document with you at the time you deliberate. The information is the formal manner of accusing a person of a crime. You must not consider the information as any evidence of the guilt of the defendant or draw any inference of guilt because she contains the date and location of each offense. The state does not have to prove the exact time, date, or location of the offense beyond a reasonable doubt. However, the state must prove each element of the offense, including the identity of the defendant, beyond a reasonable doubt. Evidence. Direct evidence is testimony about what that witness personally saw or heard or did. Circumstantial evidence is indirect evidence. That is evidence from which you could find another fact exists, even though that fact has not been proved directly. There is no legal distinction between direct and indirect evidence as far as the weight of each is concerned. The law permits you to give equal weight to both. It is up to you to decide how much weight to give any particular evidence. Circumstantial evidence of an event, for example, is the testimony of witnesses as to the existence of certain facts or the occurrence of other events from which you may logically conclude that the event in question did occur. For example, and you see that it is raining. If you testify that you saw the rain falling, that is direct of the fact that it had rained. On another night, you go to bed and the sky is clear. If you wake up the next morning and the car's on the street and the trees are wet, there is direct evidence of water on the cars, on the street, and on the trees, but there is circumstantial evidence that it had rained. There is no reason to be prejudiced against circumstantial evidence simply because it is circumstantial evidence. You may make decisions based on circumstantial evidence may be as conclusive as witness. Before you decide that a fact has been proved by circumstantial evidence, you must have common sense. Now, concerning credibility, in deciding what the facts are, you must consider all of the evidence and doing the and which testimony not to believe. This testimony. In making that decision, you may take into account a number of factors, including one, you know about those things about which the witness testified. Two, how well was the witness able to recall and describe those things? Three, did the witness have an interest in the outcome of the case or any bias or prejudice concerning any party or any matter involved in the case? Four, what was the witness's manner while testifying? Five, how reasonable was the witness's testimony, and witness's testimony contradicted by what that witness had said or done at another time, or by the testimony of other witnesses or by other evidence? In deciding whether or not to believe a witness concerning any matter about which that witness has testified, keep in mind that people sometimes forget things. You need to consider whether a contradiction or omission is an innocent lapse of memory or an important fact. The weight of the evidence does not depend on the number of witnesses. It is the quality of the evidence. Not the quantity of the evidence that you must consider. That is her decision. You shall draw no negative or adverse inference from the fact that the defendant chose not to testify. Now, you may find that one or more witnesses made statements outside of court only. You should consider this evidence only as it relates to the credibility of the witness's testimony. Consider evidence of inconsistent conduct, and then determine the weight to be given to the witness's in-court testimony. Police officers testify in the same way and by witness. The testimony of a police officer is entitled to no special or exclusive weight merely because it comes from a manner of testifying, and should weigh his or her testimony as carefully as you would weigh the testimony of any other witness. You should weigh testimony of police officers against all other testimony you heard in the case. You should neither believe nor he or she is a police officer. And given their qualifications and testified to. A person is qualified to testify as an expert if he or she has special knowledge on the subject to which the testimony relates. An expert is permitted not only to testify to the facts that he or she personally observed, but also state an opinion about certain circumstances. This is allowed because an expert from experience, research, and study generally has a particular knowledge of the subject of the inquiry and is more capable than a layperson of drawing conclusions from facts and basing an opinion upon them. An expert witness may state an opinion in response to a hypothetical question, and some experts have done so in this case. A hypothetical question is one in which the witness is asked to assume that certain facts are true and to give an opinion based on those assumptions. The value of the opinion given by the expert in response to a hypothetical question depends upon the relevance, validity, and completeness of the facts he or she was asked to assume. The weight that you give to the opinion of an expert will depend on whether you find that the facts assumed were proved and whether the facts relied on in reaching the opinion were complete, or whether material facts were omitted or not considered. Like all other evidence, an expert's answer to a hypothetical question may be accepted or rejected in whole or in part according to your best judgment. Allowing someone to give expert testimony is in no way an endorsement by the court of the testimony or the credentials of the witness. Such testimony is presented to assist you in your deliberations. Marshal, if there's an emergency, you can let the individual out, but you cannot come back in. No such testimony is binding upon you, and you may disregard the testimony either in whole or in part. It is for you to consider the testimony with the other circumstances in the case, and using your best judgment, determine whether you will give any weight to it, and if so, what weight you will give to it. The testimony is entitled to such weight as you find the expert's qualifications in his or her field entitle it to receive, and it must be considered by you, but is not controlling upon your judgment. You are also to consider his or her general credibility in accordance with the instruction on credibility applicable to all witnesses. In this case, evidence in the form of stipulations between the parties was introduced to show certain facts. The stipulation is an agreement between the parties concerning some fact or facts which you as the jury are bound to accept as fact during your deliberation. This evidence included the designation and identification of physical evidence submitted to the state forensic laboratory. The stipulations are to be used only for the specific purposes for which they were entered into and not to be used for any other purpose. The stipulations do not include credibility or the weight you may give to the exhibits. You will have the stipulations with you during your deliberations. The state has the burden of proving beyond a reasonable doubt that the defendant is the perpetrator of the alleged acts. In other words, the state has to prove beyond a reasonable doubt the identity of the defendant. Now, concerning witnesses testifying under immunity, you have heard the testimony of Pavel Gumieni. He testified under a grant of immunity. Although the state is permitted to present the testimony of someone who has been granted immunity, you must examine the testimony of such a witness who provides evidence against the defendant with greater care and caution than the testimony of an ordinary witness. While examining the testimony of a witness who has been granted immunity, you should keep in mind that he may have been looking for some favorable treatment when he agreed to speak with police and subsequently testify in exchange for immunity. Therefore, he may have such an interest in the outcome of this case that he may have an incentive to testify favorably for the state. You may consider whether his testimony was colored by his immunity, his agreement. Look at it with particular care. Look at his testimony with care and scrutinize it very carefully before you accept it. In considering the testimony of such a witness, you may consider whether there was any motive developed in the evidence for providing information inculpating the accused. The factors that you may consider, among others, when evaluating the credibility of such a witness include the extent to which the witness's testimony is confirmed by other evidence, the specificity of the testimony, the extent to which the testimony contained details known only by the perpetrator of the alleged offense, the extent to which the details of the testimony could be obtained from other sources, the circumstances under which the witness initially provided information supporting such testimony to law enforcement, and whether the witness has received the benefit, including immunity from prosecution, in exchange for testimony, and whether the witness has ever changed his testimony. Further, notwithstanding any language in the immunity agreement, it is your exclusive role to determine the credibility of that witness. In other words, you and you alone are to determine whether any evidence offered by Pavel Gumieni is to be believed wholly, partly, or not at all, irrespective of any language in the immunity agreement that may indicate otherwise. And after the name Pavel Gumieni in this draft, please just eliminate the word "it." The determination as to whether the state has proven the elements of the crimes charged beyond a reasonable doubt rests solely with you after a careful examination of all of the evidence presented. However, you are not required to disbelieve a witness because he has been granted immunity. Some people in this position are entirely truthful when testifying. Again, it is your duty to decide whether Pavel Gumieni is to be believed wholly, partly, or not at all. The defendant is charged in count 1 with conspiracy to commit murder. Count 1 of the information reads, at various times and in various locations, including but not limited to the town of New Canaan on or about the 24th day of May 2019, in the area of 69 Wells Lane, Michelle Traconis, with intent that conduct constituting the crime of murder be performed, did agree with Fotis Dulos and other persons to engage in and cause the performance of that conduct, and one of them did commit an overt act in pursuance of the conspiracy, to wit, Fotis Dulos did assault Jennifer Farber Dulos in her home on the 24th day of May 2019 with intent to restrain and kill her in violation of sections 53A-48A and 53A-54A subsection A of the Connecticut General Statutes. Here, the state alleges that the defendant committed the crime of conspiracy to commit murder and that a co-conspirator, Fotis Dulos, committed an overt act in furtherance of that conspiracy by murdering Jennifer Dulos. Before instructing you on the definition of conspiracy, the court will read to you the elements of the crime of murder. The statute defining murder reads in pertinent part as follows. A person is guilty of murder when, with intent to cause the death of another person, he causes the death of such person or of a third person. For you to find the defendant guilty of conspiracy to commit murder, the state must prove that Fotis Dulos committed murder by proving the following two elements beyond a reasonable doubt. The first element is that Fotis Dulos specifically intended to cause the death of Jennifer Dulos. There is no particular length of time for Fotis Dulos to have formed the specific intent to kill. A person acts intentionally with respect to a result when his conscious objective is to cause such result. The intent to cause death may be inferred from circumstantial evidence. The type and number of wounds inflicted, as well as the instrument used, may be considered as evidence of the perpetrator's intent. And from such evidence, an inference may be drawn that there was intent to cause a death from the nature of the instrumentality used, and the manner of its use is an inference of fact to be drawn by you upon consideration of these and other circumstances in the case in accordance with the previous instructions. Declarations and conduct of Fotis Dulos before or after the infliction of wounds may be considered if you find they tend to show his intent. The inference is not a necessary one. That is, you are not required to infer intent from Fotis Dulos' alleged conduct, but it is an inference you may draw if you find it is reasonable and logical and in accordance with the instructions on circumstantial evidence. The second element is that Fotis Dulos, acting with the intent to cause the death of Jennifer Dulos, caused the death of Jennifer Dulos. This means that Fotis Dulos' conduct was the proximate cause of the decedent's death. You must find it proven beyond a reasonable doubt that Jennifer Dulos died as a result of the actions of Fotis Dulos. The state does not have to produce evidence of Jennifer Dulos' body for you to find that she is deceased. The state is only required to prove that Jennifer Dulos is dead and her death was by criminal means. Proof of the exact cause of death is not required, nor does the state have to connect the weapon directly to Fotis Dulos and the crime. In determining whether or not the state has proven that Fotis Dulos caused the death of Jennifer Dulos beyond a reasonable doubt, you may consider both direct and circumstantial evidence. And please see the previous instructions on direct and circumstantial evidence. Again, the defendant is charged in count 1 with conspiracy to commit murder. The court has already defined the crime and all of the elements of murder. The statute defining conspiracy reads in pertinent part as follows. A person is guilty of conspiracy when, with the intent that conduct constituting a crime be performed, she agrees with one or more persons to engage in or cause the performance of such conduct, and any one of them commits an overt act in pursuance of such conspiracy. To constitute the crime of conspiracy, the state must prove the following elements beyond a reasonable doubt. 1, there was an agreement between the defendant and one or more persons to engage in conduct constituting the crime of murder, which conspiracy the defendant specifically intended to join. 2, there was an overt act in furtherance of the subject of the agreement by any one of those persons. 3, the defendant specifically intended that one of the co-conspirators, namely Fotis Dulos, intended to commit the crime of murder. The size of the defendant's role does not determine whether she may be convicted of conspiracy. Rather, what is important is whether the defendant willfully participated in the activities of the conspiracy with knowledge of its illegal ends. Participation in a single act in furtherance of the conspiracy is enough to sustain a finding of knowing participation. The first element is that there was an agreement between 2 or more persons. It was not necessary for the state to prove that there was a formal or express agreement between them. It is sufficient to show that the parties intentionally engaged in a mutual plan to do a criminal act. Circumstantial evidence is sufficient to prove that there was an agreement because conspiracies by their very nature are formed in secret and only rarely can be proven by other than circumstantial evidence. It is not necessary to establish that the defendant and the defendant's alleged co-conspirators signed papers, shook hands, or uttered the words, "We have an agreement." But rather, a conspiracy can be inferred from the conduct of the accused. The mere knowledge, acquiescence, or approval of the object of the agreement without cooperation or agreement to cooperate is not sufficient to make one a party to a conspiracy to commit the criminal act. Mere presence at the scene of the crime, even when coupled with knowledge of the crime, is insufficient to establish guilt of the conspiracy to commit the crime. In order to convict a person of conspiracy, the state need not show that such person had direct communication with all other conspirators. It is not necessary that each conspirator be acquainted with all others or even know their names. It is sufficient if she has come to an understanding with at least one of the others and has come to such understanding with that person to further a criminal purpose. Additionally, it is not essential that she know the complete plan of the conspiracy in all of its details. It is enough if she knows that a conspiracy exists, or that she is creating one, that she is joining with it at least one person in an agreement to commit a crime. Therefore, in order to convict the defendant on the charge contained in the information, the first element is that the state must prove beyond a reasonable doubt that the defendant specifically intended to enter into an agreement with at least one other person to engage in conduct constituting murder. The second element is that at least one of the alleged co-conspirators did an overt act to further the purpose of the conspiracy. It does not matter which one of the alleged co-conspirators did the overt act. It need not be the defendant, and it need not be a criminal act. An overt act is any step, action, or conduct that is taken to achieve or further the objective of the conspiracy. An overt act, therefore, is one that is committed or caused to be committed by any member of the conspiracy in an effort to accomplish some objective. The overt act cannot, however, be held against.
At 1-800-CONTACTS, we're here for people like super busy Sarah. So there's a super convenient app which reminds her when it's time to reorder her contacts. Done. So easy. You can almost do it in your sleep. Just call, go online, or download the app. 1-800-CONTACTS.
As to this count, the defendant may not be found guilty unless the state has proved beyond a reasonable doubt to be accomplished when she entered into the agreement. In summary, the state must prove beyond a reasonable doubt that, 1, the defendant had an agreement with one or more persons to commit murder. 2, at least one of the co-conspirators did an overt act in furtherance of the conspiracy. And 3, the defendant specifically intended to enter into the agreement and intended the conduct constituting the crime of murder be performed. If you unanimously find that the state has proved beyond a reasonable doubt each of the elements of the defendant guilty. On the other hand, if you unanimously find that the state has failed to prove beyond a reasonable doubt any one of the elements, you shall find the defendant not guilty. Court will now explain accessorial liability. Crime if she directly commits it or if she is an accessory in the criminal act of another. The statute defining accessorial liability reads in pertinent part as follows. A person acting with the mental state required for the commission of an offense who solicits, requests, commands, importunes, or intentionally aids another person to engage in conduct which constitutes an offense shall be criminally liable for such conduct and may be prosecuted and punished as if she were the principal offender. This statute does not connect those 5 acts specified with the word and, but separates them by the word or. A person is an accessory if she solicits or requests or commands or importunes or intentionally aids another person to engage in conduct that constitutes an offense. Solicit means to attempt or to entice someone to do wrong. Importune means to demand or urge. Aid means to assist, help, or support. A person acts intentionally with respect to a result when her conscious objective is to cause such result. Intentionally aid, therefore, means to act in any manner, the conscious objective of which is to assist, help, or support. And for this, please see the instruction on specific intent. If the state proves beyond a reasonable doubt that the defendant did any of these things specified in the statute, she is guilty of the substantive crime, in this case, tampering with physical evidence, as though she had directly committed it or participated in its commission. To establish the guilt of the defendant as an accessory for assisting in the criminal act of another, the state must prove criminality of intent and community of unlawful purpose. That is, for the defendant to be found guilty as an accessory, it must be established that she acted with the mental state necessary to commit the crime of tampering with physical evidence. And in furtherance of that crime, she solicited, requested, commanded, importuned, or intentionally aided the principal to commit tampering with physical evidence. Evidence of mere presence as an inactive companion or passive acquiescence for the doing of innocent acts which, in fact, aid in the commission of a crime is insufficient to find the defendant guilty as an accessory under the statute. Nevertheless, it is not necessary to prove that the defendant was actually present or actively participated in the actual commission of the crime. Thus, for you to find the defendant guilty of this charge, you must unanimously find that the state has proved beyond a reasonable doubt that the defendant had the intent to commit the crime charged and did solicit, request, command, importune, or intentionally aid another in the commission of the crime of tampering with physical evidence. The court will now discuss to commit tampering with physical evidence. The defendant is charged in counts 2 and 4 with conspiracy to commit tampering with physical evidence. Now, please refer to this court's instructions on the inchoate offense of conspiracy. Count 2 of the information reads, and the aforesaid state's attorney further accuses the defendant, Michelle Traconis, of conspiracy to commit tampering with physical evidence and charges that on or about the 24th day of May 2019 in the city of Hartford, Connecticut, in the area of Albany Avenue, the defendant, Michelle Traconis, with the intent evidence be performed, did agree with Fotis Dulos to engage in and cause the performance of that conduct, and one of them did commit an overt act pursuant of the conspiracy. Dulos to the Farber Dulos in the city of Hartford on the 24th day of May 2019 in violation of section 53A-48 and 53A-155 subsection A, subsection 1 of the Connecticut General Statute. Count 4 of the information reads, and the aforesaid state's attorney further accuses the defendant, Michelle Traconis, of conspiracy to commit tampering with physical evidence and charges that on or about the day of May 2019 in the town of Avon, Connecticut, in the area of 265 West Main Street, the defendant, Michelle Traconis, with the intent that conduct constituting the crime of tampering with physical evidence be performed, did agree with Fotis Dulos to engage in and cause the performance of that conduct, and one of them the 29th day of May 2019 for the purpose of having evidence related to that murder concealed and destroyed in violation of sections 53A-48A and 53A-155A1 of the Connecticut General Statute. First, the court must define the offense of tampering with physical evidence. A person is guilty of tampering with or fabricating physical evidence if believing that a criminal investigation conducted by a law enforcement agency or an official proceeding is pending or about to be instituted, she alters, destroys, conceals, or removes any item or thing with the purpose to impair its availability in such criminal investigation or official proceeding. The first element is that the defendant believed that a criminal investigation conducted by a law enforcement agency or an official proceeding was pending or about to be instituted. It does not matter whether the investigation or proceeding was actually pending or not, as long as the defendant believed that it was. An official proceeding is any proceeding held or that may be held before any legislative, judicial, administrative, or other agency or official authorized to take evidence under oath, including any referee, hearing examiner, commissioner, or notary, or other person taking evidence in connection with any proceeding. The second element is that the defendant tampered with physical evidence. Physical evidence means any article, object, or other item of physical substance that is or about to be produced or used as evidence in an official proceeding. The third element is that the defendant concealed, that really should read concealed, an item with the purpose of impairing its availability in such proceeding. A person acts with intent when her conscious objective is to cause such result. In summary, the state must prove beyond a reasonable doubt that the defendant, one, believed that a criminal investigation conducted by a law enforcement agency, or an official proceeding was pending or about to be instituted. Two, tampered with physical evidence. And three, specifically intended to conceal an item with the purpose of impairing its very. A person acts with intent when their conscious objective is to cause such result. If you unanimously find that the state has proved beyond a reasonable doubt each of the elements of the crime of tampering with physical evidence, you shall find the defendant guilty. On the other hand, if you unanimously find that the state has failed to prove beyond a reasonable doubt any one of the elements, you shall find the defendant not guilty. Now the court will discuss tampering with physical evidence as an accessory. The defendant is charged in counts 3 and 5 with tampering with physical evidence as an accessory. In considering the offense of tampering with physical evidence as an accessory, please refer to the court's instruction on accessorial liability. Count 3 of the information reads, and the aforesaid state's attorney further accuses the defendant, Michelle Traconis, of tampering with physical evidence and charges that on or about the 24th day of May 2019, within the city of Hartford, Connecticut, in the area of Albany Avenue, the defendant, Michelle Traconis, believing that a criminal investigation conducted by a law enforcement agency was pending and about to be instituted, did alter, destroy, conceal, or remove a thing with the purpose to impair its availability in that criminal investigation and official proceeding, in violation of section 53A-155A1 and 53A-8A of the Connecticut General Statutes. Count 5 of the information reads, and the aforesaid state's attorney further accuses the defendant, Michelle Traconis, of tampering with physical evidence on or about the 29th day of May 2019 within the town of Avon, Connecticut, in the area of 265 West Main Street. The defendant, Michelle Traconis, believing that a criminal investigation conducted by a law enforcement agency was pending and about to be instituted, did alter, destroy, conceal, and remove a thing with the purpose to impair its availability in that criminal investigation and official proceeding, 55A1 and 53A-8A of the Connecticut General Statute. That sentence, ladies and gentlemen, should read in the disjunctive, to be instituted, it alter, destroy, conceal, or remove a thing rather than and. As previously stated, the elements of tampering with physical evidence are as follows. Such person, one, believed that a criminal investigation conducted by a law enforcement agency was pending or about to be instituted. Two, tampered with physical evidence. And three, specifically intended to impair the verity or availability of the evidence. Please refer back to the instructions on the elements of tampering with physical evidence. The rule is that a person who solicits, requests, importunes, or intentionally aids in the commission of a crime is guilty of that very crime. Thus, for you to find the defendant guilty of these counts as an accessory, you must unanimously find that the state has proved beyond a reasonable doubt that the defendant had the intent to commit the crime charged and did solicit, request, command, importune, or intentionally aid another in the commission of the crime of tampering with physical evidence. If you unanimously find that the state has proved beyond a reasonable doubt each of the elements of the crime of tampering with physical evidence, then you shall find the defendant guilty. On the other hand, if you unanimously find that the state has failed to prove beyond a reasonable doubt any one of the elements, then you shall find the defendant not guilty. The defendant is charged in count 6 with hindering prosecution in the second degree. The statute defining this offense reads in pertinent part as follows. A person is guilty of hindering prosecution in the second degree when such person renders criminal assistance to another person who has committed a Class A felony. Murder is a Class A felony. For you to find the defendant guilty of this charge, the state must prove the following elements beyond a reasonable doubt. The first element is that the defendant rendered criminal assistance. A person renders criminal assistance when, with intent to prevent, hinder, or delay the discovery or apprehension of, or the lodging of a criminal charge against a person whom she knows or believes has committed a felony, or is being sought by law enforcement officials for the commission of a felony, or with intent to assist the person in profiting or benefiting from the commission of a felony, provide such person with transportation or other means of avoiding discovery or apprehension, suppresses by an act of concealment, alteration, or destruction any physical evidence that might aid in the discovery or apprehension of such person or in the lodging of a criminal charge against such person. The second element is that she rendered criminal assistance to a person who committed a Class A felony. According to the law in Connecticut, murder is a Class A felony. The defendant need not know the classification of the felony. Please bear in mind, however, that although the person to whom the defendant rendered assistance must have actually committed murder, he need not have been arrested, prosecuted, or convicted of the offense. In summary, the state must prove beyond a reasonable doubt that 1, the defendant rendered criminal assistance to Fotis Dulos, and 2, Fotis Dulos committed murder. If you unanimously find that the state has proved beyond a reasonable doubt each of the elements of the crime of hindering prosecution in the second degree, then you shall find the defendant guilty. On the other hand, if you unanimously find that the state has failed to prove beyond a reasonable doubt any one of the elements, you shall find the defendant not guilty. Now, these are final instructions concerning note-taking and deliberations. If you took notes during the evidence, you may use them during your deliberations, and you may discuss your notes with your fellow jurors. Remember that notes are merely aids to your memory and should not be given precedence over your independent recollection of the evidence. If there is a conflict between your recollection and your notes, or the notes of any other juror, it is your recollection of the evidence that must prevail. No juror's notes constitute evidence. Please recall the earlier instruction on what constitutes evidence. Your verdict must be based exclusively on evidence presented at trial and the principles of law given to you in these final instructions. A juror who has not taken notes should rely on his or her recollection. and not be influenced by the fact that other jurors have taken notes. Notes are only a tool and are not always accurate. Do not assume that a voluminous note taker is taking notes that are more accurate than your memory. You may discuss your notes with your fellow jurors during deliberations. The decision to discuss your notes is yours alone. After the trial has concluded, the court staff will collect the notes and destroy them. You may have testimony played back or video played back if you deem it essential during your deliberations. You will have all exhibits with you during your deliberations. In deciding whether the defendant is guilty or not guilty, you should not consider the possible punishment or consequences in the event of a conviction. This is a matter exclusively within the court function under the limitations and restrictions imposed by statute. You are to find the defendant guilty or not guilty uninfluenced by the possible punishment or consequence that may follow. You should not be influenced by any sympathy for the defendant's family, the complainant's family, or for any other person who in any way may be affected by your decision. Now, in conclusion, this court impresses upon you that you are duty-bound as jurors to determine the facts and apply the law as this court has explained it, and to render a verdict of not guilty or guilty as to each count. When you reach a verdict, it must be unanimous. It is the duty of each juror to discuss and consider the opinions of the other jurors. Despite that, it is your individual duty to make up your mind and to decide the case upon the basis of your own individual judgment and conscience. Soon you will retire to the jury room. Do not begin deliberations until you have selected one of your members as the foreperson of the jury, and you have received the information and the exhibits. You may only deliberate when all of you are present in the jury room. Please inform the marshal when you have reached a verdict, but do not tell the marshal your verdict. You will be asked to return to the courtroom where your foreperson will announce the verdict orally in response to questions from the courtroom clerk. The rest of the panel will be asked whether they concur with the verdict. If you have any questions, please send them out by way of a note signed by the foreperson and marked with the time of day, and please be specific. We would ask all of the regular jurors at this time to retire to the deliberation room and ask the alternates to remain.
Judge. Your Honor, may we just approach it sidebar briefly?
Yes. So the court believes that for this case, the court believes 200 jurors were voir dire. And the responses that you gave to the attorneys and considered by the attorneys and also heard by this court showed that it was clear that you would be excellent jurors for this case. This case is different from a lot of cases. This case is different in complexity. This case is different in length. This case is different in media attention. The court will have to release you today from the jury. However, if any one of the jurors is not able to continue, you will have to be pressed back into service to continue the deliberations, which will start anew if you are required to come back. So it is with the gratitude of the state of Connecticut and the parties that we have had you as jurors in this case. There will be no lack of interest by the media in what you think. And hopefully you'll be able to get out of the door today before someone approaches you. What the court would instruct you to do is please, because you will be asked to return if jurors are no longer able to continue. Avoid media coverage, avoid talking to the media, avoid talking to people about your service as a juror in this case. So we would thank you, and hopefully this experience has not been such that you cannot recover. So thank you, and please follow the marshal. And you may leave your notebooks and those instructions. And the court will hear counsel on exceptions to the charge.
Yes, Your Honor. Good afternoon. Judge, just on the bottom of, actually beginning the second half of page 52, and this relates specifically to counts 2 and 4, conspiracy to commit tampering with physical evidence. You did earlier in the charge direct the jury back to the incoherent or the conspiracy instructions. However, the summary simply includes the elements for tampering with evidence. And my concern is that obviously the allegation here is a conspiracy. So we would just simply need to show that there was an agreement to commit tampering with evidence and that there was an overt act in furtherance of the agreement, not that the defendant actually tampered with physical evidence for this particular count. And I would note also, Judge, that on page 56 with accessorial liability, you did bring the accessorial charge back when finalizing the summary. So I would ask that the court consider instructing the jury on the elements of conspiracy to commit tampering with evidence, namely that there was an agreement to tamper with evidence and an overt act by a co-conspirator.
So what the court will do, the court did have the opportunity, it was a short opportunity to have counsel review the final charge. What to do, specifically the state, indicate on the final draft the language you want included. The court may have to just re-instruct the jury on that count.
Yes, Judge. I'll do that now.
And Attorney Schoenhorst.
Thank you. I would first just incorporate all of the arguments that I made and suggestions I made during our charging conference. The court did not include my proposals that I asked that I would request that the court, having done so, just to preserve the record. There are a few minor items that I only noted during the discussion. Yesterday, I know that the court did add at the state's request a proximate cause instruction. In reviewing it, however, I realized that in this particular case, there is no, this is the kind of instruction that if a person, I don't know, is shot, they go to the hospital, then they get sick, and then they die. The issue is the proximate cause. I don't know if that in this case it was appropriate, so I would have just objected to that instruction being given. I would note that in the bottom of page 12, when the court gave its motive instruction, which the state had proposed, it's both in the negative in the sense that if there's a motive, it says that it may tend to prove the defendant's guilt, but the next sentence says if there's no motive, it can be inferred, not that it may raise a reasonable doubt, but may or may not. So I just note that was unbalanced in the sense that a motive may or may not tend to prove a guilt, and no motive may or may not raise a reasonable doubt, but the way it's written, it's only slanted towards the state's version of events, so I object to that. I said yesterday about the issue about the type and number of wounds inflicted should not have been included. We talked about that, but I think we ended up concentrating on whether it was a weapon, but I believe that this language about the type and number of wounds, we don't have any evidence of that in this case, so I would just renew my objection to that. I already said what on page 35, there's the reference to a weapon, and there I would just raise what I said before. On page 38, for the definition of conspiracy, it's not that just activities that she have knowledge of its illegal ends, she has to have the specific intent to cause death. In other words, not just to have knowledge of its ends. It would have to be specific knowledge of the crime of murder itself. And finally, I believe on page 59, the court did leave in one of the elements, alternative ways to commit the crime of hindering is suppression by an act of concealment, alteration, or destruction. That's not in the criminal information, only the first one, which is the allegation that she provided a person with transportation or other means of avoiding discovery. Suppressing, concealing, altering, or destroying evidence is not in the information. That's certainly not it's not the same thing. It's different acts. So I would ask that the court remove that and instruct the jury to disregard that. Thank you.
Very good. Does the state wish to be heard on the last objection or exception by Attorney Schoenhorn concerning page 59?
Yes, I can jump in, Your Honor, because Attorney McGinnis is writing with respect to the conspiracy count. With respect to what counsel's indicating about, I'm sorry, if you can just direct me to the page.
Page 59, the
59.
second bullet point.
Clear in the state's charging, Your Honor, we charge transportation or other means of avoiding discovery or apprehension. Your Honor, I think we did discuss this yesterday, and Your Honor drew attention to the fact that there's that or other means. That or other means may act, the jury can take into account all or nothing that Your Honor cites in the jury instructions. So the state would ask that it remain as said.
And just briefly, I believe the charge has to do with avoiding discovery and apprehension of the person, not evidence, and that's why they're not the same.
Thank you. Attorney McGinnis is writing a lot, so the court is not certain it can read it. We can take a recess at this point and allow Attorney McGinnis to.
I can type it at the recess.
That would be better, and then the court will read or designate the page and ask the jury to consider this instruction rather than the one that was read. So what we will,
Arrows, too many arrows.
so what we will do is just take a recess. How long do you think you will need it?
10 minutes.
Well, let's come back at 3:50. Stand in recess. Thank you.
All right. This honorable superior.
Okay, we'll switch back to the Rust trial.
Important in gun handling. You indicated that the cylinder is now out of alignment with the axis of the bore.
Well, the two things you just saw was starting to bring the hammer back all the way. Went through the safety notch, cylinder still locked up. But when you get to this position, the cylinder now rotates a few degrees, more than a few, about 10 or so. If somehow you were able to fire this gun from that position that you're looking at in the screen right now, there's going to be a real disaster because the bullet can't go down the barrel. Maybe half of it might, but the other half is going to be jammed up against that area. That's really hard to do. That process.
So the grain comes from weighing the bullet.
That's right, just the bullet, not the cartridge or the powder.
And just as an aside, did you examine the projectile from this case, the projectile that was removed from Mr. Sousa?
Yes.
And are you aware of whether or not that projectile was 250 grain at the time that the FBI had it and the time that you had it?
No, it had lost some weight. It started out life, in my opinion, as a 250 grain bullet, but it suffered reduction from probably two sources: a heavily fouled bore. In other words, the gun barrel through which this passes had a lot of fouling in it from a black powder substitute. I was able to duplicate that phenomenon. So the bullet now, like squeezing toothpaste, gets squeezed down a little bit and it gets some rubbed off. Plus, it went through two people and it struck bone. If you've seen pictures of it, or if you do later, it's got a lot of impact damage from striking bone. So for those two reasons, it weighed about 240 grains, as I recall. 10 grains.
Have nickel-plated primers?
Yes, yes, they do.
Thank you. That's fine. Okay, thanks. We'll just need to make a note of it like you did. I appreciate that. Let's connect over here. Sorry, guys. Mr. Haig, at my request, did you meet me in August at the Santa Fe County Sheriff's Department? August of 2023?
Yes.
And can you summarize for the ladies and gentlemen of the jury what the exercise was that we engaged in that day with, also, I think your son was assisting us?
Yes, he was. We had been requested to reassemble the evidence revolver with the broken parts, mainly the hammer and the trigger, with I think just the broken hammer with the knocked off full cock step, to see if it even could be cocked and would retain the cocked position.
And while we were there, did we take some videos?
I'm sorry?
Did you record some videos while we were there?
Yes, we actually did it a number of times after we reassembled it, with and without the cylinder in the revolver, and videotaped, I think, 6 runs in one session and 3 or 6 in the other.
We're only going to watch 2.
Okay.
Okay. Let's do it. I'm going to press, I'm going to get them started once you give me the screen. What's that? Thank you, Judge. Where are we?
147 now. This will be 147.
This is 147. Okay, hang on. Bear with me here. We're ready. Oops.
So
Let me stop it.
move into evidence, states 147 and 148, any objection?
It's actually gonna be 147 and 147A.
Okay. All right, any objection? All right, so 147, 147A is admitted, you may publish.
Let me turn that volume down. I'll play States Exhibit 147. Hang on. I took it down too far.
All the parts with the following exceptions.
Is there an issue with audio?
The evidence revolving. Describe what we've done to put it back in operating condition. All the parts on the revolver are original with the following exceptions. This is a new trigger and sear, same piece. It's the original hammer. It does also have a replacement bolt or cylinder catch. Otherwise, as mentioned, every pin, screw, spring, whether that's the main hammer spring or the flat spring that operates the trigger, are original to the revolver.
So what we did is just as a recap, this is the Baldwin gun, is that right?
That's correct.
And the hammer, or I'm sorry, the trigger is a new unbroken trigger, is that correct?
That's also correct.
And the bolt that we saw in the photos that had kind of lost an ear, is that replaced?
Yes.
But the hammer that's in this gun is the original hammer from this gun, is that correct?
But damaged, yes. And that was the whole point. That's the damage. How does it affect the operation of the gun if we isolate the hammer?
So this is the hammer that you believe was damaged at the FBI.
Yes.
The full composition. Hammer falls and is captured at the half cock position. Again.
So what did you ask your son to do? He's the one holding the gun.
I asked him to go through the normal cycle. If you produced this firearm and cocked it and expected the hammer to stay cocked until you pull the trigger, it will not. Because that full cock step or notch has been rounded off, the perfectly brand new trigger cannot retain the full cock position. The hammer falls to what you just saw, and it falls to that half cock notch. So the good trigger and its sear drop into that notch, preventing the gun from firing. So that's intentional. That's what Mr. Colt intended. If somehow the gun got worn and the hammer started to drop when you cocked it, it's going to get captured. And if it gets past that point, it'll be captured by the quarter cock notch.
Okay, demonstrate the positions of the hammer, normal positions. From full down when the firing pin is protruding from the breech.
Can you see the firing pin protruding from the breech in this video?
Yes, when I first described how this gun works for you, the hammer is fully down. So it's either just fired a cartridge, or this would not be a good way to carry this gun with live ammunition, because that firing pin is resting right against a live primer. There was a cartridge in this gun, and it wouldn't take much of a blow. You don't have to hit it hard. Just drop it from a few inches in this configuration, and it'll fire.
To the front. And from here, the trigger will not allow the hammer to drop because of the shape of the notch in the hammer. From the half cock or load condition also, pulling the trigger does not drop the hammer. And the cylinder is now out of alignment with the axis of the bore. And then
Tell us what you mean there, and why is that important in gun handling? You indicated that the cylinder is now out of alignment with the axis of the bore.
Well, the two things you just saw was starting to bring the hammer back all the way. It went through the safety notch, cylinder still locked up. But when you get to this position, the cylinder now rotates a few degrees, more than a few, about 10 or so. If somehow you were able to fire this gun from that position that you're looking at in the screen right now, there's going to be a real disaster because the bullet can't go down the barrel. Maybe half of it might, but the other half is going to be jammed up against that area. That's really hard to do. And you're probably going to blow the cylinder apart. You may get injured. So there again, what Mike and I were demonstrating is it's called a slip off. If you're trying to cock the gun and you lose your grasp on it, hammer falls, that safety notch captures it. And now if we get this far, it still is going to be captured, but somehow if it got past that, the safety notch, you're going to have a damaged at the minimum or a destroyed gun and probably an injury to yourself.
And In this position where the cylinder is no longer aligned with the axis of the bore, does the firing pin hit the primer every time?
No, it can hit it just at one side, and primers are designed to detonate, and it's a proper term, with basically a central hit in the primer. If you get off to one side, you'll often have a misfire, a failure to fire. And if it gets any further than that, it hits out in the head stamp area, doesn't hit the primer at all. The more that cylinder rotates out of phase.
Original will be caught when released drops. And with lateral pressure, both directions, this one slipping the thumb off to the right side of the hammer, this one slipping the thumb off to the left side of the hammer, all catch on the half cock as long as the trigger.
Why the example of the hammer slipping?
Why would we do that example? It can be a misadventure with this kind of firearm. One of them I described, you're trying to cock it and you lose control of it. If you haven't pulled the trigger, what you just saw will happen, nothing. It'll capture the hammer. Similarly, you can cock a gun and then decide, as I demonstrated, I want to let the hammer down. You don't want it cocked. You're going to have to pull the trigger. You're going to have to coast that hammer down with a good thumb on this area called the spur. And when it gets past the safety notch, the proper thing is to let go of the trigger and the safety notch will capture it once again.
All right, this is August 24, 2023.
Right.
Mike Haig and Luke Haig at the Santa Fe Sheriff's Laboratory.
Let's look at State's Exhibit 147A.
This is Alden.
Just tell us before we play it, what are we looking at here?
This is the same evidence revolver. You're now looking at the other side, and we've removed the cylinder and the cylinder pin.
Is everything still the same though? We've got damaged hammer, everything else works.
Yes, everything else is the same. I think we wanted to see the stop latch working at one point.
Okay, we'll go ahead and play this.
2023 in the property room of the Santa Fe Sheriff's Office. And Mike, you're on to describe what we've done to the evidence gun. So it's the item 1 revolver, the Pieta. Original parts include all the pins, screws, grip, the original hammer. It has the original hammer spring as well as the original flat spring that operates the trigger. The trigger is a replacement trigger, so the top of the sear is a functioning original piece. And as I said, original hammer. It does have a replacement bolt as well. Otherwise, all parts are original. Okay, and the hammer's in the fully forward position to stop. The normal full cock position. Hammer falls, doesn't hold, but the half cock notch captures it. Let's do it again. I'll take it all the way down. We can see the quarter cock notch also functions. Half cock functions. And then all the way to full.
And you can see the stop latch finally in that view. It's this little piece right there. It went down when it got to the half cock and then came back up when it reached full cock position because that locks the cylinder in alignment with the axis of the barrel.
And again, when it was in the full cock position and it was released and it fell and was caught at half cock, that was why?
That was as designed. That's what it should do. In that situation, the cylinder would have been aligned, but in a way it doesn't matter because it wouldn't fire.
No, I'm talking about when your son pulled it into the full cock position and it didn't stay there. Why didn't it stay there?
Again, the former full cock notch or step has just been beaten off. It's just I couldn't do that. Slip off.
Okay, I'm just going to go slowly through the video so that we can see the bolt that you were referring to. So I'm starting this video at 1 minute and 9 seconds.
There you can see the stop latch. Right now it's up because it's locking the cylinder if the cylinder were in the gun. And it's still up because we're falling from the full cock. If we'd come from the hammer down to this very position, it lowers itself so we can rotate the cylinder and load and unload the gun.
Okay. Just for completeness, we'll finish playing it.
Hold. But the half cock notch captures it. Let's do it again. I'll take it all the way down. We can see the quarter cock notch also functions. And it fails to hold, but is captured at the half cock. I'll apply some lateral pressure to the hammer as I release it as well. And That was to the right. This is to the left. And of course, because of the notches on the hammer, pulling the trigger at the safety notch or the load condition, those do not release the hammer. Okay, I think that covered.
So based on the experiment that we did with this gun back in August of 2023, even if the hammer of the gun was damaged on October 21st of 2021, would the trigger have to be pulled for the gun to fire?
Two things. Yes, the trigger would have to be depressed or pulled. The hammer would have to be at the full cock position, and it can't be damaged because it would do what we saw here. And what you just saw here would not fire the gun.
So hypothetically, though, that being Mr. Baldwin would have had to have pulled the trigger.
If you could get the hammer to stay at the full cock position, that's the difficulty to overcome.
Which it doesn't want to do.
It will not do.
Okay. And did you have an opportunity to examine the spent casing from the Rust Moody set in this case?
Yes, I did.
Did you make any conclusions about whether or not that spent casing was fired from this gun?
Yes, I did.
What's that?
I'm in agreement with the FBI examiner. I was able to match it under the microscope. There are tool marks on the breech face of the gun that print themselves, literally stamp themselves into the primer. And yet there were a number of test-fired cartridges that the Bureau prepared, that I prepared, and under a specialized microscope for this purpose, I could see a very nice identification. So in my view, the fired cartridge was fired in this gun. Then I went on to look at the shape, location, and depth of the firing pin impression as the next important question.
And let's go ahead and talk about that. Everything that you learned from the firing pin impression and what that tells you about the position that the hammer of the gun was in at the time it was fired.
It tells me two things: that the cylinder was locked up and aligned, so the hammer had been pulled all the way rearward. If it had not, it wouldn't be in alignment from what I've shown you. Secondly, the depth of the firing pin impression told me from doing test fires, multiple test fires, and measuring all the 12 that the FBI lab conducted, that it was a cartridge that was fired from a full hammer fall, not from an effort to let the hammer down and slip off or any other misadventure, but rather a normal hammer fall from the full cock position.
One final demonstration for us, if you would take your revolver out and come in front of the jurors. And you can stand right here so that you can speak into the microphone. So just for completeness, I would like for you to demonstrate to the ladies and gentlemen of the jury, using this exemplar revolver, the position that what had to have happened on 21st and let's show them rather than give them a real description.
Yeah, no function. The hammer, in this case, Mr. Baldwin, had to get it to this position. If you let go of the hammer, it would stay as you see it here. When the trigger will fire. Now you can do that as quickly as you cock it. We're going to have full depth. If I've done it, if somehow I did this, I'm trying to let it down, and I let it slip, it either won't fire at all, or it makes a much shallower firing pin impression. I did that multiple times with the evidence gun, since I own several of them. So I could distinguish by the depth and the centering. This was a normal hammer fall from the full cock position.
So had the gun fired at a position less than full cock, lower than full cock, in between full and half or half and quarter, you would be able to tell that by the depth of the firing pin impression. Is that correct?
If it, what I call a slip off, if you're trying to let the hand about halfway point and it slips, you also have to pull the trigger, by the way. It'll be a much shallower firing pin impression because it doesn't hit the strike, doesn't strike as hard. And from the quarter cock, if you're trying to put it in safety position and you lose control of it, again, you have to pull the trigger. It just makes an indentation in the primer, doesn't fire at all.
Thank you, sir. If you can take your seat. Sir, in what we call the discovery, in the documents and information examination that you reviewed, did you have an opportunity to review some videos of Mr. Baldwin on set in the church pulling the gun out of his holster?
Yes, I did.
And are you familiar with that type of holster?
Yes.
Are you familiar with this type of gun?
I'm sorry?
Are you familiar with this type of gun? I think you've indicated you are.
Yes, I think I own 6 or 7 of them.
Okay. Is there anything particularly difficult or dangerous about pulling this style revolver out of that style holster, in your opinion?
Not so long as you don't load it, or if you do load it, that you don't cock it and pull the trigger. Otherwise, it's safe. It's an easy movement to make. I have no problem with how to do that.
When you say it's an easy movement to make, can you think of anything, that the gun might get caught on or anything that could?
Not realistically, again, the hammer secures itself well to be drug across clothing. And if it fell without a trigger pull, and the trigger is well shielded with a trigger guard, but if somehow the hammer got pulled off the full cock position, you've already seen what's going to happen. It gets captured at the half cock position.
All right, thank you. I'll pass the witness. Mr. Bowe, I'll have you disconnect us.
Maybe approach for a moment.
Our lunch break. Please don't talk among yourselves or anyone else about the evidence received here in court. We'll be back at council at time. Do you think? Council?
Yes, Your Honor, I apologize.
It's 11:38. You want quarter of? Yeah.
Sure.
Yes, thank you, Your Honor.
Okay. So. Maybe seated.
I was just told that there's
Thank you, Your Honor. Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Sir, I wanted to ask you first off, I think your conclusion, the shooter had to have fully cocked that weapon and pulled that trigger to cause it to fire. Is that? Oh, I'm sorry. I apologize. Let me start over if it's okay, Your Honor. Okay. Sir, if I can ask that again, I think your conclusion, and correct me if I'm wrong, was that the Baldwin revolver that you examined, in your expert opinion, that the shooter had to have fully cocked that weapon and had to have pulled that trigger all the way, or pulled the trigger.
Bifurcated my answer in the report, either pull the trigger, which I regard as a volitional act, or have already depressed it. If
Yes, sir.
already depressed it, the very instant they let go of the hammer, it would fire.
So, sir, for example, if Mr. Baldwin were cross-drawing that weapon and had his finger in the trigger guard, and then he pulled it and it had it fully cocked and it slipped and let go, would that fire that weapon?
Only if he had the trigger pulled or depressed. They're similar, but I make a slight distinction between it being depressed versus pulled.
Okay, so, sir, so either way, that shooter had to either have it depressed, have his finger in the trigger, or pull that trigger for that to fire.
And have it cocked.
And have it cocked.
Fully cocked.
Fully cocked.
Yes.
Okay. Okay, now, I noticed earlier when you were doing a demonstration with the jury, you exercised extreme muzzle discipline, I'm going to call it. You learned that, correct? Not to ever point that weapon at an individual, a human?
Long ago.
Yes, sir. Been around guns a long time?
I have.
And one of the most important rules, and I saw when you walked down, you had it either down, up, it was never pointed at a person. That's one of the most important rules of gun safety, isn't it?
I agree.
Okay. And sir, another rule that I noticed when your son was on that video, and when you were demonstrating, you never had your finger in that trigger guard. Is that another rule you learned from a long time ago?
Well, we were demonstrating something there in which the trigger saved the gun from firing. If we had depressed it, of course, it wouldn't be a useful demonstration.
No, and I understand. My question wasn't good. You never put your finger in that trigger guard until you were ready to pull that trigger in some manner.
Yes.
Okay. Now, with regard to the cross draw, I know you've been around guns for a long time, but with regard to the cross draw, would you agree that somebody that was not familiar with that draw would need to have training on that draw?
You'd have to have some understanding of where the firearm is, how the holster works, whether it's got a safety strap or not. And then, of course, get it out of that area and swing it around, as was shown in the videos that I've looked at of Mr. Baldwin.
Yes, sir. And did you see the video where when he pulls it out, his finger is in the trigger guard? Did you see that?
I certainly did.
And again, that can be very dangerous, sir, based on your expert conclusion, if he has that fully cocked, correct?
And it's loaded and fully cocked, yes.
Yes, sir. And so when you watched that video, did you make a determination as to whether he should have drawn that with his finger in the trigger guard?
It's been a while since I've looked at it. I was trying to decide a couple of other things. If that's the evidence gun, I was satisfied it was because of the plain bare metal hammer. And then, of course, looking at, can I really determine if his finger's inside the trigger guard but not on the trigger itself? I could never resolve that.
Okay.
Because of the camera angle.
And in any event, you should not have your finger on the trigger in that cross draw.
Well, it doesn't matter what it's cross draw. It's if you're going to cock the gun, which he did after it's out. I do remember that. When it's out of the holster, you can see him cocking it, and it's now clear of the holster. But I'm back to, I can't tell if he's already got the trigger depressed or it gets pulled later.
Okay, sir. And with regard to your conclusion, I want to make sure I was clear on that. I know that you, and I don't want to use the word critical, but you didn't think that aggressive testing by the FBI was a good idea?
I didn't think it was necessary in this case, given the context. What are the issues in the case? In my mind, it was never an issue that the hammer got struck by anything or that the gun got dropped.
And so you didn't believe that the FBI even needed to do that test?
From my viewpoint, no. It was not a useful or necessary test to strike the hammer of the fully cocked Edits gun.
Did you also say that you did not find any damage to that weapon that would have prevented it from firing as designed? And I'm talking about not after the FBI, but prior. Is that your conclusion?
Yes, if the hammer were replaced and the trigger replaced and the bolt, it was a perfectly functioning, authentic replica of a classic firearm.
Okay, sir. And in your inspection of that weapon, that Baldwin revolver, did you see any modifications that would have changed the firing characteristics of that weapon?
No, not at all. In fact, I went through, I think there are 12 other revolvers. 9 of them are Pietas. And I took them all apart with the help of my younger son, Mike. And we looked at the sears, the triggers, the full cock notches, and they were all equivalent. You could have swapped them out because they're carefully manufactured parts. So that's how I addressed and answered that question in my own mind.
Okay, sir. So other than the FBI testing, breaking those components, you didn't see any other evidence of modification or damage?
I did not.
Okay, sir. With regard to the rounds that you were talking about, the Starline brass is used by hand loaders at times. Hand loaders use Starline brass. Is that true?
Yes, that's their primary market. I'm one of their consumers. Small ammunition companies like the box of ammunition that the prosecutor showed earlier have also used their brass. Remington, Winchester, they of course have their own.
So, and can you tell the jury a hand loader, if they use, they can use any type of primer, any type of powder, any type of bullet in a case, right? In the hand loader?
That's definitely not true.
Okay, what is a?
Well, let's start with the primer. That's the spark plug in your car. It's the spark plug in ammunition. There are large pistol primers and there are small pistol primers. The Colt cartridge requires a large pistol primer. There are also rifle primers that have the same dimensions, but they're harder and usually have more explosive in them. The same way there are small rifle primers. So you got 4 types. Then they could be plain brass, if that's your pleasure for aesthetics, or nickel plated. And I've seen them both ways. So you got 4 types and 2 finishes. There are even some that are custom for bench rest shooting and other exotic competition, but those are the 4 main. The powders, yet another thing. They're powders that are specifically manufactured for handguns. You've got a big bore and a heavy bullet. It's got to be accelerated to produce their energy. Rifle powders, if you shoot a 30-30 or a 30-06, you couldn't take the powder that's in one of your rifle cartridges and put it in a pistol cartridge and get it to work. It basically fizzle or squib. They burn it. It's like sawdust, sticks, and logs. Powders burn at different rates for shotguns, pistols, and rifles. So there's a lot of thought that's gone into this over the last century and a half of how you make all this come together to not blow up the gun, to achieve the desired pressure and velocity, and of course, produce an accurate shot.
Yes, sir. And so did you have any evidence when you looked at the live rounds from the rest set that those were hand loads or those were some other type? Did you determine that?
Well, they're in Starline brass, which is sold for hand loaders. But as I said, a commercial manufacturer can buy Starline brass, just as you saw in that one box. The bullets look more amateurish to me. In fact, I have that same bullet with the blue loop, and it's a cast bullet. Doesn't come in cartridges. So I don't have a definitive answer on it. They were virgin cases. That means they hadn't been fired previously and then reloaded. They were shiny inside. So they were first time assembled, and the powder, their physical forms, just as I mentioned, look like a powder called bullseye, which is probably the oldest pistol powder around. It's very popular. I use it myself. It's normally associated with hand loaders, but it doesn't stop the industry from buying a ton of it and loading a few million rounds.
Okay, sir. So you didn't make a definitive determination, but those rounds appeared amateurish, which would be more like a hand load. Is that fair?
Yes, that has kind of a demeaning character to it. I pride myself on my hand loads, and they look fine, but they'd already been disassembled, so I didn't get to see the quality of the crimp and just where the crimp was made. That's where you hold the bullet in the cartridge case. I wished I'd seen them before they were disassembled.
So, but when you looked at it, it did appear. I'm just trying to establish. It did appear more likely to be a hand load.
Yes.
Okay. And if we can have Gunnar, if I may approach the witness.
Are you going to mark that?
Yeah, this is State's Exhibit 110. This has
All right.
already been,
No objections, yes.
okay. It's already been admitted into evidence. Oh, yeah, we can put. Okay, I'm gonna do my best with this. Mr. Haig, I hope you can see this.
Yes, I can.
Okay, do you see, this is State's Exhibit 110 that's been introduced. Have you ever seen this photo?
Yes, I have.
Okay. Oh, I'm sorry. Let me get that. So, Mr. Haig, on the right, that you're looking at right now, I have it under it. What is that type of powder?
It's a pistol powder. In my opinion, it's one called Trail Boss. That's a brand name designed for cowboy action, loads in handgun, centerfire handgun cartridges. And its characteristic shape, as I say, it looks like little donuts or tires if you magnify it. It's a dull gray. It's also what's called a single base powder. So I use it myself. It's an old friend. It works well.
Okay, sir. Now I'm going to move this over, and I'm going to show you this other type of powder. And what do you call that type of powder?
Of the many physical forms, it's called disc flake. That's with a hyphen, disc flake. It's little flakes in the sharp shape of discs, like little gray hockey pucks under the microscope. And without a scale, I couldn't compare that any further to, say, bullseye or some of the other disc flake powders.
Okay, and now I'm going to try to zoom in here. Do you see in the middle of the ones you just described, you see that donut-looking shape? Right in the middle.
I see it. I don't see it as a powder particle. It's something in the holding device.
And by holding device, what do you mean by that?
I don't know. I didn't have benefit of having this in my hand to actually empty it out, as I recall. So I don't know what it is. It's not powder. That's all.
You don't think it's powder?
I'm convinced it is not a propellant for powder.
Okay, but you don't recall that particular thing when you looked at it, or when you had it, or what did you just say? I didn't understand.
If I looked at it, I was again firsthand. I was again interested in the propellant as to whether I could identify it on the basis of morphology. And I didn't get anywhere beyond it's a disc flake powder popularly used in pistol cartridges, handgun cartridges.
Okay, so as part of your work in this case, did you ever see the photographs from PDQ Props from Seth Kenny's business?
I know I saw a number of photographs after a production of materials there, search warrant, I suppose you call it, and a lot of the ammunition, plus the FBI did a lot of x-ray images of cartridges from that facility.
Did you remember the way that place looked in terms of its organization or disorganization?
Only vaguely.
Okay. All right. And we may show you some pictures of that, but you never went there personally.
I have not been there.
Okay. And you've had no contact with Seth Kenny yourself?
That's also correct. I don't know the man. I've not met him.
Okay. Did you, with regard to the rounds on set, did you measure or inspect all of the rounds? For example, evidence there's been 250 dummy rounds. Did you go through all of those?
Over a period of 5 days, yes.
Okay. And did you go through all of the live rounds, you said?
Yes, definitely. Looked at all disassembled, but 5 rounds.
Okay. And other than what you told us, anything else about those live rounds? You did tell us the blue loop. Any other matters that you investigated that you determined about those?
Well, I probably said earlier this morning, those are hard to cast, meaning the lead has been hardened. It's not dead soft lead like you get out of an x-ray machine. Cast bullets, there's another way you can make bullets. The manufacturers do, but casting with a mold, bullet mold. And yes, I now must recall the propellant in the disassembled live rounds looked like the powder I mentioned, bullseye. And I didn't see that in other sources in this case.
Sir, can you tell a jury what a light strike misfire is, if that term's familiar to you?
Yes, I usually separate the terms, but let's just start with a misfire is a cartridge fails to fire for some reason. A light could be one of those reasons. That means the hammer didn't fall its full distance, or it was retarded by something. It was going to fall, but something got caught up in it. Or the example I gave earlier, and I did it with the actual evidence gun, pull the hammer back with real ammunition, pull the hammer back to the quarter cock, that little distance where the safety would set, but I had the trigger depressed, and then let the hammer fall. That would make, it'd be actually hard to see, a little tick mark, T-I-C-K, a little tick mark in the primer, but it wouldn't fire it.
And observing that after that happened, if you observed that round and you could see that little strike in the primer, is it true that round could still go off the next hit?
Yes, if it didn't fire and a primer had a tick mark, one of these little light indentations in it, and you put it back in the firearm and drew the hammer all the way back, it's going to fire.
And sir, one other area you mentioned that the gun barrel, Baldwin revolver, it was dirty.
Well, it had to be dirty when the evidence bullet went down the barrel.
Okay. And let me just ask you, does it take some time for an individual to properly clean a gun that's been firing black powder?
With a black powder, it's on no evidence black powder was used in this case, but I know what you mean. There's a substitute called 777, which acts like black powder. They both leave a lot of residue in the gun barrel. And it can be difficult to get out, especially if you notice, like you just showed me in the picture, are not water soluble. So you need to know, okay, this is 777 or black gunpowder, and I've got to get this stuff out. You're gonna have to scrub it out with hot soapy water is the best way, and then dry the gun barrel out.
Okay, sir, and I appreciate that. I know you operate a business. Were you paid or compensated in this case for your work?
For my time, of course.
Yes, sir. And how much have you been compensated?
Well, my wife handles the bookkeeping, so I don't know for sure, but there's been quite a few hours. As I said, 5 days just looking at all this evidence alone. Then another one, I came over here in July to look at the clothing, and then in August for the videos you saw. So there's 5, 6, 7, 8 or so days.
And what's your hourly rate?
$350 per hour.
Okay. Okay, and I thank you for your time.
You're welcome.
Redirect. Mr. Haig, did you look at all of the disassembled live rounds from the set of Rust?
Yes.
Did any of the primers on those live rounds have those tick marks?
No.
And just to be clear, when we were looking at photos earlier, the photo of the ammunition that came from PDQ Props, you described that bullet as a semi-wad cutter.
Yeah.
Okay. And can you
So nothing wrong with them. They look like perfectly suitable handles. I've seen prettier. I'm sure seen a lot worse.
Are you, I just want to be clear, are you testifying to the jury that rounds that were found on the set would have come from a small manufacturer like HSM?
In 45 Colt from various manufacturers, and those that my younger son Mike has purchased have a higher quality. The bullets are slicker, shinier.
Okay. And you were asked some questions on cross-examination about gun safety and Mr. Baldwin having his finger in the trigger guard of that gun. You recall those questions?
I do.
Based on your review of the evidence in this case, is it your understanding that Mr. Baldwin was told that the gun was cold or inert before he put his finger in the trigger guard?
Yes, it's my understanding from reading the documents, they call cold gun was given, meaning there's a gun on the set, but there's nothing in it that's going to fire. No blanks or, of course, live rounds.
And the dummies in this case that rattled, you examined some of those, didn't you?
Yes, I did, a number of them.
Do you mind my asking, sir, how old you are?
83.
And sir, with your 83-year-old ears, were you able to clearly hear the rattle?
Not always.
Not always.
Especially in my right ear.
Okay. Do you think that's an issue with your hearing?
I thought it was subtle even when I listened with my good ear, my left ear.
So in order to hear that rattle, you have to listen pretty closely, right?
Yes, and it gets more complicated. Some of them had one pellet in them, others had 2 or 3. So now you've got the advantage if you happen to pull one that's got 3 in it, better opportunity to hear it rattle.
Okay. Sir, are you familiar with the term inertia bullet puller?
Sure. It's got a cap. You put usually a live cartridge or maybe one that's failed to fire. Anyway, it's a cartridge. It's got a bullet, cartridge case, primer. Put it in this device and you hit it on a hard surface. Good old Isaac Newton works out for us. The hammer stops and the heavy bullet keeps on going. Now, it may take 3 or 4 hits, but you separate the bullet from the cartridge in a non-destructive way. So you get the bullet, you get all the powder, and you get a cartridge case. It's pretty routine if we want to know what's this ammunition loaded with, how much powder, what kind of bullet, because you can't see all the bullet when it's in the cartridge case. So it's a common tool. I think I have 2 or 3 of them.
So the inertia puller is a device that is designed to disassemble live ammunition. Is that right?
Yes.
Thank you, sir. I don't have anything else.
All right, thank you, sir. You're excused. Next witness.
We will call Corporal Alex Hancock.
Where's it? Get this off. Thank you. Do you swear affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, thank you. Have a seat.
Detective Hancock, go ahead and state your name for the record.
Alexandria Hancock.
How are you currently employed?
I am currently a corporal with the Santa Fe County Sheriff's Office.
How long have you been employed at the Santa Fe County Sheriff's Office?
A little over 6 years now.
And have you only worked at the Santa Fe County Sheriff's Office?
Yes.
Okay. On October 21st, 2021, what was your position with the department?
So on October 21st, 2021, I was a detective in the Criminal Investigations Division, and I was assigned to the Violent Crimes Division.
And how did you become involved in this case?
I became involved in the arrest case. We were working that day and in the office, and got notified that there was a shooting on a movie set.
And when you received that information, what did you do?
So we met essentially as a team in investigations, and at that point we had essentially split up assignments. We do this with any sort of major case like a homicide, shooting, stabbing, anything like that. So we'll meet with the supervisors and then the entire team, and then who's going to do what at that time.
Tell us how you divvied things up.
So at the initial point of this case, there was actually another detective that was assigned the primary, and I was assigned as secondary. So what that means is that the primary is pretty much the head of the investigation. They're essentially in charge of what's going to happen, and then they do the responsibilities for the rest of the team from there.
Instructions of it. Now, what the court would indicate is that if you see any sentence that doesn't make sense, you can just inquire of the court what word is missing, or is this misspelled, or you're missing an article, the or a, and it will just come to the court's attention that you're trying to figure out whether this is just a typographical error or whether that's what the court intended. Now, if you still have a copy of your instructions, the court is just going to direct you to the bottom of page 52. And at the bottom of page 52, there is a paragraph that begins with "you unanimously," and it concludes on page 53. So what the court will ask you to do is just cross out that entire paragraph, and the court is going to read the substitute paragraph, and you will also get a copy of that substitute paragraph, so you do not have to take notes on the substitute paragraph. So instead of that last paragraph on the draft that the court gave you, this is how the last paragraph will read at the bottom of page 52. Counts 2 and 4, conspiracy to commit tampering with physical evidence. Now, as the court mentioned, the defendant is charged in counts 2 and 4 with conspiracy to commit tampering with physical evidence, not the substantive offense of tampering with physical evidence. The court refers you back to previous instructions on the definitions of agreement and an overt act in furtherance of the conspiracy. In summary, therefore, the state must prove beyond a reasonable doubt, 1, that the defendant had an agreement with Fotis Dulos to commit tampering with evidence. 2, the defendant or Fotis Dulos did an overt act. Defendant specifically intended to enter into the agreement and intended the conduct constituting the crime of tampering with evidence. If you unanimously find that the state is proved beyond a reasonable evidence, then you shall find the defendant guilty. On the other hand, if you unanimously find that the state has failed to prove beyond, well, this says any of the elements, any one of the elements, you shall then find the defendant not guilty. So that last line should read, on the other hand, if you unanimously find that the state has failed to prove beyond a reasonable doubt any one of the elements, you shall then find the defendant not guilty. This will be given to you. You can mark it up as you wish. Soon, the exhibits, all of the exhibits in the case are going to come to you. What also will come to you is a laptop. If you have any trouble with the laptop, we can troubleshoot for you. So if you can just retire to the deliberation room, all of the exhibits will be brought in. And at that time, when you are all in the deliberation room together, you can begin deliberating. You can retire to the deliberation room.
And I also looked at the laptop, so I have no problems with that.
Thank you. So Madam Clerk will get all those exhibits into the jury room, and we'll stand in a recess.
Okay, so we're officially at the deliberation phase now. After a false alarm.
And who was that person who was originally assigned primary?
His name was Joel Connell.
And is he a colleague of yours?
Yes, yes.
And at some point, was that designation changed, and were you assigned primary?
Yes, about 2 weeks later.
On October 21st, just so that we understand who was doing what, can you give us the names of the people that you yourself interviewed on the 21st of October?
Yeah, so the day of the incident, I was assigned to take some individuals back to the sheriff's office to be interviewed. Those individuals involved Hannah Gutierrez Reed, who is here in the courtroom today, David Halls, and Alec Baldwin.
And those are the three people who ultimately were criminally charged in this case, correct?
That is correct.
Would you agree with me that you did basically the primary interviews on October 21st?
Yes.
And so while you were interviewing kind of the main players on October 21st, what was Detective Cano doing?
So Detective Cano had stayed at the ranch, so at the Bonanza Creek Ranch, and it was my understanding that there were additional people who were inside of the church at the time that the incident happened that he had interviewed and had assistance from another detective. So essentially they stayed on scene and used a like a movie trailer or whatever was designated towards them to interview all those other people.
And why were you guys interviewing people at the same time? You in one location, him in another location?
Because of the amount of people that we had to interview, and at the sheriff's office, we only have one interview room.
Now, you were present in the courtroom when Officer LaFleur and Mr. Benavides testified. Do you recall that?
Yes.
What's your opinion with regard to their sentiments that this was a difficult scene because of the number of people?
Yeah, I would say it produced a pretty big problem for the sheriff's office just because of the fact that there were so many people on this movie scene, hundreds of people, and there were so few of us at the time.
Now, in addition to interviewing Mr. Baldwin, Ms. Gutierrez, and Mr. Halls on October 21st, 2021, did you also conduct a subsequent interview with Ms. Gutierrez?
Yes, I did.
And was her attorney, Mr. Bowles, present for that interview?
Yes, he was.
And did you have numerous subsequent telephone conversations with Mr. Baldwin?
Yes, quite a few.
At any point in time after October 21st, did you conduct an interview of a witness by the name of Sarah Zachary?
Yes, I did handle her initial interview was with Detective Connell, and then I had a follow-up interview with her sometime in November with her attorney.
And did you also conduct an interview with an actor by the name of Judson Ackles?
Yes, I did.
Did you conduct an interview with the witness that we heard from earlier, Catherine Rowe Walters?
Yes.
And did you interview a gentleman by the name of Zach Sills?
Yeah.
Did you interview a gentleman? How many?
draft that search warrant for PDQ.
Did you also have numerous conversations with Mr. Bowles?
Yes.
And were some of the statements that Mr. Bowles made also things that went into your decision to execute a search warrant there?
Yes.
What was the information you received from Mr. Bowles that caused you to turn your attention to Seth Kinney?
So from the beginning of this investigation, Mr. Bowles had made statements that he believed that there was sabotage on the set, although none of the individuals that I had interviewed shared the same sentiments. So none of the people that I had interviewed thought that this could be sabotage or that someone did this intentionally to Hannah. And so given the fact that Mr. Bowles had continuously told me about, Seth Kinney and the fact that he may have supplied the live ammunition and that he was a supplier of ammunition is why we decided to take that path into investigating him.
Now, the interview that you conducted with Mr. Reed that went into your decision to apply for a search warrant, did Mr. Reed actually tell you specifically the kind of rounds that he recalled being on the set of 1883 that would now be in the possession of Seth Kinney?
Yeah, he described the live ammunition to have a semi-wad cutter top.
All right. Corporal, were you statements?
Yes.
Did you see Seth Kinney?
Yes, we did.
And based on Mr. Bowles' communications with you and other information, you actually applied for a search warrant and you conducted a search of PDQ props, correct?
Yes, I did.
And you spoke to Mr. Kinney numerous times, I think you testified to.
Many, many times.
And he was completely cooperative with you?
Yes, for over a year, I believe.
And sorry.
Oh, no, I was just going to say, we had numerous conversations for an extended period of time.
Is there any particular reason that you didn't ask him for a DNA swab or a fingerprint sample?
Yes, so during my investigation and the interviews I conducted, there was never any testimony or reason to believe that Seth was ever on the set of Rust. Anything that was handled through him or any of the ammunition or anything that had been brought to set had been picked up by another person in Albuquerque or they had met outside of the set.
And just to be clear, Corporal, the live ammunition that you seized from PDQ props, what did you do with it?
We submitted all the live ammunition for testing with the FBI.
And did you receive information that the live ammunition from PDQ didn't match the live ammunition on the set of Rust?
That's correct. It didn't match at all.
And isn't that in line with what Thel Reed himself told you about that ammunition being semi-wad cutter?
Yeah, so the statement that Thel had made about the type of ammunition that they were using matched what we found and what was provided by Seth Kinney.
So you found at PDQ exactly what Thel Reed told you you should find?
Yes.
And it did not match the live rounds on set?
That's correct.
Lotion. Okay, thank you.
Let's talk about the cell phone extractions that were done in this case. And let's go back to October 21st when we're on the set of Rust. Do you know why cell phones from every witness on the set weren't collected?
There was, obviously a lot of people that we were dealing with, and it's not standard practice, especially when we are still investigating, to just go and take people's possessions from them.
If I'm a witness to a crime, do you just get to come seize my cell phone?
No.
Do you get to put me in handcuffs?
No.
Do you get to put me in the back of a patrol unit?
No.
In fact, there was an extraction of Ms. Gutierrez's cell phone, correct?
That's correct.
And you didn't have to ask for a warrant. She consented to that.
She did consent.
And was there an extraction done of Mr. Baldwin's phone?
Yes.
And where was that done? Suffolk PD in New York completed it. And did Mr. Baldwin do that voluntarily, or did you have to execute a warrant? So I had initially applied for a warrant for his phone, and it was approved here in New Mexico, but he was located in New York at the time. And so we ended up, actually the DA's office and Mr. Baldwin's attorneys ended up essentially getting his phone and doing his phone on consent as well. Was a cell phone extraction done of the cell phone of Mr. Halls? Yes, it was. And did you have to get a warrant, or did Mr. Halls consent? He consented. Same thing with Ms. Zachary. Was there an extraction of her phone? Yes. Did she consent? Yes, she did. And Mr. Kinney shared with you the information from his phone that you asked for? Yes, numerous times. Is there a reason that the prop truck wasn't searched until October 27th? Yes, so with the initial information that we had been given and that we responded to the day of the incident, the entire incident in itself had occurred inside the church. So that was our primary area that we were going to be investigating and processing and looking into, because that's where the incident occurred. And additional information that we had received was obviously involving the prop cart that Hannah and the props team was using. And that's why we, processed that prop cart as well. We didn't have information until later on that this prop truck had been involved in the props department and that we would potentially need to be looking for evidence there, which is why we didn't conduct that search until a few days later. And Corporal, why wasn't the search of PDQ props done until the end of November? Because the information that I had started receiving in terms of PDQ didn't come until, I believe it was November 9th. The statement that I was given from Thaler, my interview with Thaler Reed, was November 17th. We had also received some evidence back from OMI November 22nd. And then I had another interview with Sarah, her secondary interview on November 29th. So this is all stuff that I'm involved in and I'm conducting and doing myself. So November 30th was essentially the first day that I had available to do that search warrant. And I requested the search warrant that morning and got it done that afternoon. Can you explain to the jury why latent fingerprint testing was not requested on the live rounds found on the set of arrest? Yeah, absolutely. So during my interviews with, all the people that I initially interviewed, there was statements from them that the gun that Alec Baldwin was using was taken from the church, that Dave Halls had taken it from the church, that he had handed that gun to Miss Reed, directed Miss Reed to essentially empty all the bullets from that gun. So in doing so, with Miss Reed emptying the bullets and examining them at that time, I know she touched them. I know her DNA or potentially her prints are going to be on those bullets. So it didn't make sense for us to DNA or latent test that round because I know who touched it and she wasn't the only one that touched it after that. In addition to that, the other live rounds that were found in, gun belts, the box or the ammo box and the carts had all been handled by several people during this movie set, especially after the shooting. I had gotten statements that they had been handled by several different people. And not only that, but the gun belts that contained the live ammunition were said to have come from another set. And so for us, and in speaking with the DA's office, as well as the FBI, our representative from the FBI, it didn't make sense. It would be a test that just wouldn't yield anything that we were looking for. And why wasn't DNA testing requested on the live rounds or the spent casing? The spent from the gun? From the set, yes. I'm sorry, the spent casing from the gun or the live rounds from the set of rest. My apologies.
I'm sorry, you're saying why wasn't it?
Why wasn't DNA testing requested?
Okay, essentially for the same reason, because of, because of all the various people that had claimed to handle these rounds.
And did you also hear in previous testimony about FBI policies?
Yes.
And were you notified of those policies during the course of your investigation?
Yes, I was.
So if you had requested it, they would have refused?
Correct, and we did have that discussion with our FBI representative who was assigned to the case here in Santa Fe.
Now, we understand from previous testimony that you sent the gun that was being used by Mr. Baldwin to the FBI for testing. Is that correct?
Yes, we did.
And prior to the testing being done with the mallet, were you notified that that testing could potentially result in damage to the gun?
Yes.
And what was the reason that you proceeded with the testing anyway?
We proceeded with the testing because Mr. Baldwin had made statements that he didn't pull the trigger, and I think his exact statement was that the gun just went off. So we needed to figure out how to disprove that theory or that statement, and that was the way that was proposed to us and what the FBI could do.
On October, I'm going to go through and I'm going to play some videos of your statements with Ms. Gutierrez at this time. And on October 21st, 2021, did you have a conversation with Ms. Gutierrez when she was still on set before she was taken to the police station?
Yeah, we had some brief discussion.
Okay. And Your Honor, if it's acceptable, some of these videos, the first one isn't that long, but some of these videos are rather lengthy, and so I'd like to play them from counsel's table.
Sure.
Instead of standing.
Okay. How long are they?
The first one I think is about 8 minutes. The second one, off the top of my head, I want to say is about an hour. And the last one is between 2 and 3 hours.
All right, we'll probably take a break after the second one, the one that's an hour, okay?
Just as a point of clarification for the court and also for the jury, some of these videos are at times redacted if there's downtime or something like that. So if you see a skip, that's why.
Okay, so coming into evidence?
Yes, and the first one that I intend to play is State's Exhibit 66. I would ask to admit it and publish it.
Mr. Wolf?
No objection,
All right, State 66 is admitted, you may publish.
Yes, so during my investigation, interviews and stuff, so I had never applied for.
Yeah, where's the restroom?
She knows where it's at.
Just gonna back up.
As your site, she's a gift, and she doesn't want to go alone. Escort her.
Yeah, where's the restroom?
She knows where it's at.
Okay.
Get that out of the way if you would. Corporal, does this microphone work? Okay. The acoustics are much different from this position. Corporal, who is that gentleman you were speaking to?
That was my sergeant at the time, Christopher Zook.
That's the same gentleman that testified earlier in this trial?
Yes.
And what are you being asked to do?
I was advised that Hannah needed to use the restroom and that she wanted somebody to accompany her.
After her? Yeah. Hi there. You needed to use the restroom? Yeah. Okay, I can go with you.
Do you have your bag?
I don't know. I think it got taken. She'll just come right back here. Yeah, I'm just taking her to use the restroom and that's it. Let me just close this.
Okay, where are they?
I have to do this? Can you guys just have me leave?
Well, yeah, so we're gonna take you, do you wanna wait to go to the office, or?
Is it gonna be a while?
I'm not sure how much longer, I'd say not too much longer, but I can't tell you what time. Okay.
And Corporal, I couldn't hear what Ms. Gutierrez said to you at the beginning that prompted this discussion about going back to the office. Do you recall?
No, I don't.
Okay, no problem.
Welcome to the worst day of my life.
Okay, things happen.
Yeah,
Where's your restrooms here?
right over here.
Okay.
I can't believe Alec Baldwin was holding the gun. That's so fucked. Can't believe it. Oh, God.
That's all right. Just...
Can the members of the jury hear what Ms. Gutierrez is saying in the video? Okay, just checking.
No, he said no. One person said no.
I didn't understand.
Okay. Corporal, could you hear what Ms. Gutierrez was saying in the video?
Yes.
Can you, did we just turn it up? Okay. I'll take it back just a short bit and we'll see if that works. Thank you, George.
I can't believe Alec Baldwin was holding the gun. That's so fucked.
What did Ms. Gutierrez say to you?
Her statement was, I can't believe Alec Baldwin was holding the gun. That's so fucked.
And just to be clear, at this point in time, where's Ms. Hutchins?
I believe she's still in the care flight, the helicopter.
And you saw the previous videos, the video from Mr. Benavides. Do you recall seeing that?
Yes.
Okay. And in that video, did Ms. Gutierrez learn that Ms. Hutchins was critical but stable?
Yes.
That's all right. Just take a deep breath and we'll work this all out, okay? I think that one's up there.
Do you come with me?
Yeah, I'm just gonna stand facing opposite, okay?
And Corporal, why do you need to escort Ms. Gutierrez to the restroom?
She had actually asked to be escorted by law enforcement, which is why I was with her. We take it as a precaution to accompany people into the restroom, just to, I guess, ensure that they don't harm themselves, that they're not trying to hide evidence, such things like that.
You guys have a lot of people out here.
Yeah. Is there like a closer cop car you guys can put me in or something?
I mean, the closest one that I can put you in is one of the ones that's like the unmarked one.
I just kind of wish that any of my coworkers could stop seeing me because I already feel super bad.
Okay, yeah.
Okay, hold on just 1 second.
I can even throw you in mine. I have an unmarked one.
Is it closed?
It's like right. We walked through them.
Okay, cool.
So.
Yeah, I don't want to go back.
Okay.
I just want to get the fuck out of here and never show my face in this industry ever again.
Well, I wouldn't say that.
Oh, I would.
How long have you been working here?
Just a month.
Just a month?
Yeah. I've just been doing this job for like 9 months now.
Okay. How old are you?
24. I'm like the only female armor in the game, and I just fucked up my whole entire career.
Have you studied armory, or did you go to classes, or how did you get into it?
My dad's one of the best armors in the entire world, and he trained me, and I'm a fucking there.
Let's do it. You ready? Yeah, so it's these cars. Mine's actually the silver car over here.
Okay, and little fanny pack is right in front of that cop car on that thing, if you could bring it.
Okay. What's in it?
Just my key. Stuff. My ID.
Okay. Yeah, let me just figure out. Let me see.
You can just leave it, honestly. Yeah, my inhaler is in it.
Okay, do you need that?
My inhaler might be in the back of the cop car.
You know what? Let me... Sorry, we have so much gear.
Not sure. Do you want a Gatorade? It's not open. It's been. I'm alright. Okay. So I'll leave that there if you want it. Okay. Oh, you can control the window. Joe. I have to hang out with you here though, okay? Since my vehicle is. So, she doesn't want to get in the car until they figure out transportation. We just let them know that I have her in here. She doesn't want to be.
This is on her?
Yeah.
Okay. So you're just going to hang out with her?
Yeah. Until they figure out what they want to do. But yes.
Okay. So she wants to be transported over there?
Yeah, she wants to. Right. Exactly. And she just doesn't want to be. Well, she doesn't want everybody to see her right now. So I have her back here. Okay. From Arizona, what part? I actually don't think I know where that is. Let me hold the temp kit. Have you called your tenants or anything yet? Yeah. Whoever you need to call. You know what's happening. Yeah. Okay. Weird.
So Corporal, at Ms. Gutierrez's request, did you take her to the restroom?
Yes.
And at her request, did you permit her to sit in your patrol unit?
Yes.
Did you turn your patrol unit on so that she could be in a comfortable temperature?
Yes.
Did you allow her full use of her cell phone?
Yes, I did.
So just to be clear, Ms. Gutierrez's phone wasn't taken either, was it?
No, it wasn't.
And then later that day, did you do another interview with Ms. Gutierrez at the police station?
Yes.
We're going to enter it into evidence.
Yes. We would move into evidence states exhibit 67 and ask for permission to publish.
No objection.
All right, state 67 is admitted, you may publish.
Started.
Uh-oh, hang on.
Before we get started, you're here for an interview, and that's what we're doing right now. Okay, just anybody, what happened?
Can everybody hear that? Okay, if you can't, raise your hand. A little bit, okay. Let me try it. If I turn it up here, it will go up over there. Okay, let's try that, see if I can fine tune it a little bit.
Okay. Anytime we interview somebody, especially when we just hear the opposite.
George, can you just bump it up another notch and let's see how that works, if you don't mind, sir. Leave it there.
Okay, cool. So we have here, we use forms. That's what she had here, but I guess you would go get them. So we're just going to use those.
And Corporal, where did you go?
I went to go get a form which essentially has Miranda rights on them.
And who's this lady in the room?
This was the, so her name is Samantha Talamante. She was a detective that I was interviewing with on that day.
And does she still work at Santa Fe County Sheriff's Office?
Yeah, she's a corporal as well right now.
Thank you.
All of them, just formality, we have to do. Do you know if anyone ever got that fanny pack? So right now it's technically inside the scene, so we can't quite grab it yet. Okay, cool. But you said it's black and gray? No, it's just the gray one. Just gray, okay. And it was on the cart? Yeah. Yeah, so it'll be secured and it's not part of it. We'll get back to you as soon as we can. So I can put the rights that I just need to go over and I'll read them to you, and I do understand signature Trev held here. And then we'll read the rest here and if you agree, okay? So you have the right to remain silent. Anything you say may be used against you in a court of law or other proceedings. You have the right to consult an attorney before making any statements or answering any questions. And you may have him or her present with you during the questions. You may have an attorney appointed to you to represent you if you cannot afford one, otherwise obtain one. Okay. Do you understand those? And if you wish to, I kind of would like an attorney. And kind of like, what do you want to do? I mean, just because the situation and everything, their attorney already talked to me, and I just think I should probably have an attorney represent me. Okay, before you make any statements or talk to us.
Do you know what attorney she's referring to?
There was an attorney that was at the ranch, but I don't know her name.
Okay.
Court wants to make sure that everyone is here after coming to the court deliberation. So again, do not be surprised if the media tries to talk to you now. Your names and your addresses have not been made available to the media, but their efforts to try to find out who you are will not go unabated. So please don't talk to the media, please. Don't discuss the case with anyone. Please follow no media reports about the case, and hope to see you tomorrow. Have a good evening.
Okay, and that concludes the Traconis trial for today.
Tomorrow morning at 10 o'clock.
All right.
And we'll continue on with the interrogation of Hannah Gutierrez.
Answer a few questions. Talk to us. And if you want to address your attorney, that's fine. If you want to answer some questions, you still could change your mind during this question. And at some point you feel like maybe you want your attorney, you can, but you need to make the decision on what you want to do right now. If you want to talk to us, how long would it take when you get here, I guess? It's going to be you calling them and finding out. Really? Okay. I don't know, they're fucking attorney, I don't know, it's just like such a big company, you know. Oh, you check out with the production company? Yeah. I don't want this, like, I don't want anything in this case to be fucked up for me as much as I possibly can. So, no, you're fine, and that's why we both of you. Yeah. So you know you're right. Okay. It's up to you. Is there an attorney I can call? It would be a public defender, they might not, they might advise another day. It could go a longer process, I don't know. All right, I can answer some basic questions. If you want to answer some basic questions, we could do that, and then if you at some point feel like it's yeah. And like I said, we're in charge of the armor. Okay. So you're okay with talking with us? Yeah. So this article is also basic questions, okay? So you've already mentioned that you've been on set for 5 months now, on this particular set? Yeah, on this particular set, I've only been there 2 weeks. Oh, I'm sorry, you want the date and time? Oh, yeah, please. It's going to be 21. 21. I'm so sorry. How do you spell your first name? Hannah, H-A-N-N-A-H. And your last name? Gutierrez, Gutierrez. When's your date of birth? April 28, 1997. April 28, 97? Yeah. And how old are you? 24. I just want to be comfortable in your house. Okay. So this said you've been here for 2 weeks. Yes. And this is your primary job is handling the armor? Yeah. Can you go into detail about what you do? I check the guns and I load the guns and I hand the guns off to the actor. Okay. How long have you been doing this? You mentioned you've been on multiple sets. Since about March, but I've been handling guns my whole life pretty much. So you're very familiar with guns. And this is your primary function. You go to different sets and you primarily handle these guns. Yeah. Okay. So can you tell us what happened today when you started work, when you got there to work? Yeah, I went to work. We got the guns out. I said we. me, my coworker Sarah, she helped me with the guns a little bit too. Yeah. And we got the guns out, we went to set, we had the guns on set. I dummied the guns up with the dummy rounds. And yeah, we were on set all day, nothing happened, and then we came back from lunch and that happened.
So you got on set with the gun with the dummy rounds about what time?
Like 7:30 probably.
Around 7:30 this morning?
Yeah, I didn't dummy the gun up until about a little before lunch, like an hour before lunch.
Corporal, could you understand what Ms. Gutierrez said about something about the gun? Did she say dummy the gun up?
Yeah, she had said that she dummied the gun up right before lunch.
Okay.
And we take all the guns and we lock them up for lunch.
So yeah, that's what I was going to ask you. You and Sarah, what's her last name? Do you know?
Sarah's last name. I don't think she really worked with that gun that day, by the way. But Sarah Zachary, Zachry.
So just to be clear, did Ms. Gutierrez just tell you that Ms. Zachary didn't really work with the Baldwin gun that day? That's correct.
But she was there today with you, helping you today, correct? Yeah. Okay. So you and Sarah, who has access to that? So when you got there this morning, where are the guns kept?
The guns are kept on the prop truck.
On the prop truck?
Yeah, and the dummies and everything is kept on the prop truck.
Are the dummy rounds separate, contained than the gun? All in the truck?
Yeah, they're in their own box, and the guns are in the safe.
Okay. And who has access to the safe?
Sarah and I.
Just the two of you? Yeah. So what about the dummy rounds? Who has access to that?
Well, the dummy rounds, they were on the cart for lunch. Yeah, the dummy rounds were on the cart for lunch. All the ammo was on the cart for lunch.
Is there, if you're saying dummy rounds and ammo, are there two separate things?
So there's blanks, my bad, not ammo, but there's blanks, the blanks look different. They shoot the stuff, and the dummies normally just have a little BB in them.
What is the purpose for the dummy rounds? Because you were loading those up this morning.
So the dummy rounds, they're meant to fit in my belts of the Cowboys and everything. And like in the revolver, you can see if it's empty or not. So yeah, I have to dummy them up if they're going to be like looking right at the camera.
Oh, okay. So you just for show, the dummy rounds are just for show to make it look full.
Show. Yeah.
Okay. But then the other rounds that you like.
The other rounds, yeah. They don't shoot a BB, no.
Oh.
No, they just shoot they just open up and a little black powder comes out. Oh. It's just a little black powder, and yeah.
Is there live ammo that's kept on set?
No, never.
Okay. So
I hardly even go shooting with 45 ammo at all. I normally just use 22. So.
And so you got the guns this morning. You and Sarah are the only ones who have, is it a combination for the safe?
It is, yeah.
Okay, and you guys are the only ones who have that combination? Okay. But the rounds are?
They're in the truck, yeah. The truck gets pretty much locked up every night. I mean, not like padlocks, but just on set security.
Or do you guys have lunch? Does a lot of people just eat lunch there?
We all leave and we go back to base camp.
Okay. And you guys left the dummy rounds and the ammo, but it's not real ammo.
My bad, blanks. The blanks, yeah, we'll go with blanks.
I will use blanks.
Yeah.
Just so I also don't mix up in the confusion.
Yeah.
Yeah. So when you got the dummy rounds and the blanks this morning, what were you guys doing before lunch? Was that just
we were just
with the dummies only? Just
just the dummies. We were just about to get into the blank stuff, and part of my job is checking the barrel to make sure nothing's in it, because that's how Brandon Lee died.
Yeah, right.
So that's what I checked for. I definitely checked this morning, and I was planning on checking again right after lunch before we got into all the shits, and I already started checking the other two guns to check in the anything for them, and none of them had any barrel obstructions. So yeah.
So you check the gun, but you check the blanks and the dummies as well?
I do check the dummies. I check all of them, and they all showed that they were not hot, I guess you could say.
How can you tell the difference on the ammo, on the dummy rounds, or the blanks, I'm sorry, how can you tell the difference from the blanks and live real ammunition? A little ring, like there's a little ring in there, it's just rings that rattle, like a little rattle when you put blanks. Yeah, and then also there's ones that I have with holes in the side to show that there's nothing in them. So what are these ones, are the rings? Yeah, these ones are the rings, there was one I think with a hole, yeah.
So I want to visit with you a little bit about Ms. Gutierrez's statements up to this point. Initially, Ms. Gutierrez told you that she shook all the dummy rounds, is that right? Yes. And then upon further questioning, did Ms. Gutierrez tell you that, in fact, one of the rounds actually wouldn't have been a shaker, it had a hole in the side?
Correct, which wouldn't give any sort of audible noise if she shook it.
All right.
And you put the gun before going lunch back in the safe. Yeah. But the blanks and dummies were left on the cart. Yeah. Did you, when you got back, did they look moved or tampered with or touched when you got back from lunch? They did not. No, nothing seemed out of the ordinary. Was the gun still in the safe after lunch? Yeah. Who pulled it out? Sarah pulled it out and she handed it to me. Okay. Yeah. Then you watched her? Yeah. Okay. Where I'm trying to get with is because you can handle the gun, you obviously are going to be loading the gun, so that's why I'm concerned about the dummy and the blanks, because those are left out. And if there's some way that somebody can alter them to make them still look like your dummy rounds, well, so that's the thing is that, like, bullets, like real bullets, pretty much look the same as dummies. The only difference is the rattle. And so, yeah, that's a choice, but also, I don't know, I'm kind of wondering, because I heard back in the day, dummies used to have like a primer cap. Mm-hmm. So I'm wondering if maybe it was one of those older ones or something like that. Did you load them after lunch? They were already loaded from before lunch. And so that's the thing is like, you know, we had that gun the whole time before that, and nothing happened, and I wasn't in there, and they weren't supposed to be even pulling the hammer back.
So, okay, all right, let me just clarify a little bit. So prior to lunch, the guns, you had them out?
Yeah.
And where were they when they were out?
They were inside with all the camera crew and everything, but, you know, COVID, everything happening right now, they don't really like a lot of people in there.
Okay.
And so usually I'm like hardly allowed in there unless there's actual firing happening.
Okay.
Yeah.
Were you inside this morning?
I walked in there and I handed the gun to Alex a couple of times, and Alex took it, and everyone was there with him.
Alec?
Alex.
Okay.
Baldwin, yeah.
Okay, so you handed him the gun this morning. Does he pass it off to anybody? Were you able to see that?
At one point, Dave had it, the assistant director, but he was just sitting in with it, and then I saw him, and I was like, okay, this is fine. He's just sitting in, and then I walked out, and yeah.
And how do you know that Dave had it?
I handed it off to Dave while he was sitting in for the shot.
Okay. All right, so you guys were the only three handlers prior to lunch?
Alec, Dave, me. Dave was after lunch.
Okay.
Dave was after lunch. Yeah, that should have been the only ones. Maybe Sarah possibly, but yeah. Because that's the thing, they chill on our little table, and we're pretty much there all the time.
Okay. And then, so prior to lunch, did they do any scenes or anything of the sort where they were firing the weapon?
No.
Okay.
Nothing before lunch. Yeah, we were just supposed to get into it right after that. Like, literally, that was the last shot before we actually got into blanks.
Okay.
And those blanks were already loaded in before lunch. No, the blanks are different than dummies. So, yeah, blanks, totally different. They actually have, like, ignition and powder and everything. Dummies, no powder, just for looks.
Right.
Yeah.
So I think everything was after lunch then. So after lunch, you get back, and that's when you loaded a dummy round. I mean, the blanks.
No blanks were loaded.
No blanks today.
Yeah, no blanks were loaded today. I was like getting ready for it. And I'm making so I loaded it with 5 of the dummy rounds before lunch, and there was one that wouldn't go in. And so when we got back from lunch, I took the like little cleaner guy and cleaned it out really quick, and I put another dummy in there.
Okay, so there are 5 total in the gun.
Yeah.
Can you
About six. There was six, five, yeah. When the incident occurred, yeah, there were six.
Okay, can you describe the gun?
It's a Colt, it's a long barrel Colt.
It's a long barrel
Mm-hmm.
and 6 rounds fit in it?
Yeah.
What color?
A brown?
It's bronze?
Yeah, the brown. Yeah, it's kind of brown, brassy.
What, caliber?
25.
Okay. And that was the only one that was used today?
Those are both 45. I think they're either Colts or Verdict 45, and yeah, the two other characters had them.
Okay, and they're revolver looking?
Yeah, they are revolvers.
But the long barrel was the one that was used during the incident, just to be clear.
Yes, the long barrel one, yeah.
Okay.
Yeah. The other two were only actors, and those were fine.
Okay, so they're kind of like for show, pretty much, holsters?
Yeah.
Okay.
Like, they took them out and they had them on camera too, and yeah.
Okay. Do you know, what time did you go to lunch?
12:30. Pretty much on the dot.
And then, so after that, Sarah pulled them out.
Yeah.
Did you see her, check them, or did she just hand them to you and that's when you checked around?
She just handed us, we took them in the bag to the set, so we didn't check them there. They're in little, like, little socks.
Okay.
Yeah.
What do those look like?
Little socks. Real frank.
All right.
Yeah, they honestly look like socks, yeah.
And so when you checked it, it was on set or prior to you checking?
Yeah, it was on set. I didn't really check it too much after lunch, because it was already locked up and everything at lunch. But yeah, I checked it and put in that last round and sent it in.
Okay. Yeah. I know that you had said something about keeping stuff in your fanny pack.
Yeah, it's in a fanny pack. We use from the blanks, but it's mostly like the blank sizes. There's quarter loads, there's half loads, and then there's full loads. And I usually don't keep any full loads out there unless I need them. But I usually keep quarter loads and half loads right here. So if it's close up to an actor, we use the quarter load, and if it's farther away from an actor, we go ahead and we use halves.
Okay. So what's the reasoning for that?
Just the halves have more smoke and they look more real.
Okay.
Yeah.
So pretty much for
like if it was a bigger gun, like a rifle or something. Yeah.
So you keep
or if it's outdoors, But mostly it's the quarters, just in case they're closer proximity to an actor, Or if it's inside quarters, or if it's around an animal or a child's quarters.
Okay. And then you had said that they're only supposed to pretty much expel dust or smoke, right?
Yes.
Okay. Were you inside when the incident occurred?
No, I was right outside by my, my cart.
Okay. How close was it?
About 15, 20 feet from being inside.
Okay. What side of the building was done?
So the building with the door is facing, I don't know, north and west.
Was it with the crossing? You think that was the main door? So
where the door, where they were like coming in and everything, that door, we were like right adjacent to that, to the left.
Okay. Could you get inside at all?
No, not really. No, I couldn't see inside.
What do you remember about?
Basically, I just we had a couple of, we had a popper pop last week. The poppers are for special effects. Like one just went off randomly last week. So I was like, it must be a popper. And I checked all of them myself. So I heard the shot and Sarah was like, what was that? And I was like, must have been a popper. And I turned around and then I heard them say medic emergency. And I was like, what the fuck? And then I checked in and I looked and I saw Alec on the ground and I was like, oh, not Alec, Joel. And I was like, what the fuck, was it the gun? And Dave was like, yeah, it was a fucking gun. And so I was like, I walked in and I tried to see what was happening or where the gun was, to secure the weapons on set. And I got yelled at, and I ran out and Dave brought me the gun and I opened the gun up and one of the dummies somehow had been discharged.
And can you kind of explain a little bit more what you mean by that it was discharged?
So if I have a bullet, I have some dummies. So. Right, check it out. I wish it had just been one of these, but see how these have like the hole? Okay. And this one doesn't have a primer, right? And most of them, like, they have like the primers, but the primers aren't like hot. Like, I've never had one with a hot primer before. Okay. So that seems pretty weird to me. But so basically this part, when a bullet shoots, the fire projects it, and this comes out, this little piece right here, this little nipple. Yeah, and so when I had checked the gun, this part, that was gone.
Did you get to see the shell?
I saw the shell, yeah, and it's on the thing.
Did it have one of the, did it look like this or was it different?
It didn't have a hole, it didn't have that. So I didn't have that, and it didn't have a hole. And this was gone, so it was just the shell.
So it kind of looks
Just the cartridge.
just the regular like cartridge when it's
Without this, yeah.
So these ones are done because they have the hole.
Yeah.
So that one didn't have a hole. So it looked like a realistic
Yeah.
one when you saw it.
Okay.
What about your
But a lot of
what about your blanks?
What about them?
What's the difference between a blank and that?
You know, I don't know if I could show you, but the blank is very different. And you would absolutely be able to tell the difference just by looking at it. So basically, the end here where this is gone, the projectile is gone in the blanks basically. This is squeezed shut. Like, you know, it's filled with like a little bit of gunpowder, like I said, either quarter, half load, or full load. Filled with a little bit of black powder, and it's opened by the metal part just going, so nothing flies out of those.
Okay. So this is pretty much what looks like what was in the gun.
This is 100% what was in the gun, except without that.
Okay.
And with the primer, but the primer normally is on there anyways for a lot of them.
Okay.
Yeah.
So it's not as
No, it's not. A lot of them have the primer, so that way you can like see them themselves and they look real.
okay.
But a lot of them also have the primer in a hole, and that one didn't have a hole.
All right. So you had said so how did you end up getting the gun after?
I went in there, they yelled at me, I ran out, and I was like, can I see the gun? And they brought me the gun, and I opened it and checked it, and the very first one that I like, because, you know, once you shoot it, the next one in a revolver, it'll be that one, and the first one I pulled out didn't have that.
Okay. Did you get to see the others?
The others all had, yeah, I took them all out. They're on the cart too. They all had rings and they all had holes, and I don't understand. But that one's enough.
And Corporal, just to be clear, the live rounds that were found on set, none of them rattled, did they?
No, they didn't rattle.
And none of them had holes in the side, did they?
No.
And I'm sorry. Explaining what the ring is.
So I'm not gonna say.
Oh, okay. So just that noise.
So that's what I'm saying. So this one is exactly what it looked like was in there.
Okay. And that one doesn't have any holes.
So that's not, yeah. Honestly, that box of dummies might have some wonky ones in it. And we got that, I think, a week ago.
Who ordered them?
Well, we got them from from Seth, our like supplier and everything.
Okay.
But Seth borrowed them from someone. I don't know who.
Borrowed the ones that you have?
Yeah. Yeah.
And how do you know he borrowed them?
I don't know. That's what Sarah said. And then as soon as Sarah called Seth, I don't know. I don't know. I don't know if she even talked to him or anything about this.
Okay. You mean today, if she calls him today or not, we talked to him?
I don't.
Corporal, based on your investigation, let me back up. I think that we heard Ms. Gutierrez testify that that box of dummies might have had some wonky ones in it. Is that right?
Yes.
And did she also testify that that box was provided about a week earlier by Mr. Kinney?
Yes.
And did you continue to investigate the box and the source of that box of dummies?
Yes.
Based on your investigation, was Ms. Gutierrez's assertion that that box came from Mr. Kinney a week earlier, was that assertion correct?
No, it wasn't.
I don't know if she called him, but I didn't get to hear the police officer told her to stop talking to me. Okay. So I don't really know what happened with that. But yeah, so.
Okay. Are you aware of a time or know if something like that can be dysfunctional or?
I mean, you know, like overall, these are some weird, like what we're dealing with are like, you know, explosives, there's always like a chance of like, you know, safety to be compromised, and that's the issue, and that's what I'm supposed to watch out for on set, and, yeah.
What did Ms. Gutierrez just say? What she's supposed to watch out for on set?
The ammunition, pretty much.
I'm gonna back it up just a few seconds.
Anything about that? Today, if she called him today and already talked to him, or when? I know she called him, but I didn't get to hear the police officer told her to stop talking to me. Okay, so I don't really know what happened with that. But yeah, so.
Okay. Are you aware of a time or know if something like that can be dysfunctional or?
I mean, you know, like overall, these are some weird, like what we're dealing with are like, you know, explosives. There's always like a chance of like, you know, safety to be compromised, and that's the issue. And that's what I'm supposed to watch out for on set, and yeah. But I've never really I've heard of blanks before with the primer, you know, that's the only time I've ever heard of them, which is why I'm wondering if it was kind of one of the older ones, because that kind of stopped after that whole Brandon Lee situation. But I'm not really sure.
So Seth orders all of your rounds.
Yeah.
And is there anybody else that's involved in that?
I can't really say.
Okay.
I just get what I get, and I'm told not to visit it. Yeah.
Do you know who the manufacturer is of this?
No.
Do you know what the box looks like?
Yeah, the box is on the card. It says dummy rounds.
Okay.
Yeah.
Corporal, did Ms. Gutierrez just tell you where you could find the box of dummy rounds that she was pulling from?
Yeah, she said it was on the cart.
Okay. And is that consistent with what you saw in Mr. Benavidez's video?
In his lapel video, she grabbed them from the cart, however, handed them directly to Lieutenant Benavidez.
Okay, so somewhat consistent.
Yes.
One thing about that. Just that that's for them, or? No, Seth is, he's, had armor on for The Walking Dead. He was on that show for 10 years. But he's also familiar about, getting these. Yeah, Seth is, he pretty much is teaching me everything, other than my father.
Has anyone ever allowed live ammo on set?
No one.
Okay. What's your guys' protocol for the ammo?
Protocol.
What do you have in place? You know, are you supposed to check them every day?
Basically, like, you know, our protocol for the ammo is like, you know, I have to know load sizes. I have to know like who's in the proximity, if it's a child, if it's a horse. And my protocol really is a lot of checking for barrel obstructions, mostly because that's where a lot of mistakes get made, is like just blanks behind something, and a lot of guns get thrown into, like, dropped in rocks, you know, and rocks get into the barrel and fly out and shit. So my shit is mostly just checking the barrel and thing and making sure the dummies are dummies. And I've never really had any that didn't sound like dummies. Okay. When the after the incident, did it look like yeah. L2 by there's like markings on the bottom of it. Okay. Yeah.
Remember what those markings are?
Well, fingernail marks, but like.
How much time? Okay, so how many guns were pulled out after lunch?
Like 7.
7?
Yeah.
Okay.
Cause Miller has 2. Oh, maybe. Okay. Right. Miller has 2. Russ has 1. Yeah. Who else? Russ has 1. That was the one that was discharged. And yeah. And then we had 3 long guns that were on the card. Shotgun and 2.
Watching all of these.
Yeah.
Okay. And you said Rust?
Yeah. Rust is the character who's Alec Baldwin. Okay. Then you have to drop it in. Or do you have it saved? Do you know who all was inside the building during the incident? Some youth camera people got our camera quit last night. Oh, yeah, the whole fucking crew, except for like two. The CP, she got the director is Joel. He got shot. Okay. The DP, director of photography. Okay. And that was Halyna, Helena. Not really solid question. Do you know her? No. And you said Joel, and he's another director? Yeah, Joel. And you said that he was also shot? Both of them got shot. How many rounds are, I heard one. 7. Which is fucking insane. Okay. Do you know anybody else that was inside? I don't. I wasn't there. Well, I won't say, yeah, Alex, right? Yeah, Alex was inside, but I hate myself for that. And what about Dave? Yeah, Dave was inside. What's do you know Dave something? On the call sheet.
Hates herself because Alec Baldwin was in the church. Yes.
This is like so awful. Dave Hall. Yeah, I got the Halyna Hutchins. Yeah. Halyna Hutchins. She was another person that was in there. Mm-hmm. Okay. So I have Halyna, Joel. Do you know Joel's last name? Joel Old. Joel told Ouza. Okay. Alec, Dave, anybody else inside? Well, her study cam operator was inside. His name's Reed Russell, our guy. Okay. Where you were parked? Yeah, we were parked over here. So the church, across the main entrance to that was in over here.
Mr. Benavides is over to the park to look for the gun. Yes.
Could he be? Well, no, I went inside to hand him the gun. Oh, he was sitting. He was standing in pretty much. Oh, so you didn't just hand it and then he walked off. I'm curious because of the whole transferring from the one person to another of the gun. Yeah. He's the one who did it directly to Alec. Here's a picture. Totally. It would be a real life.
Let me pause there for a moment. Showing Ms. Gutierrez on her phone.
So we had received a photo from the deputy that was at the hospital with Joel Souza that was removed from his shoulder inside a little like plastic.
I'm going to put this up on the monitor because I think everybody can see it. I'm showing you what's already been entered as State's Exhibit 54. Is this a photograph of what, is this what was in that photograph?
Yes.
Okay. Just the projectile.
Yeah, inside of a little container though.
Okay. And this was just a photograph that a detective at the hospital took of the projectile inside the container and texted.
I don't believe it was a detective that was there. It was just a deputy that, yeah, that was instructed to go to the hospital with Joel Souza.
Okay, so that.
Detective, are you now relatively familiar with blank grounds?
Yes.
I was like, that would be in the blanks all the time. That was what was pulled out of the shelter. Oh my God, I'm for Halyna. So that's why they were thinking it could be a natural lock around too. Well, honestly, if we had my extractor, we could pull this out and check it, but I don't know. Actually, I still pull it up. Yeah, I don't know, because look at that line. That's kind of a distinct thing. I think that's mostly for dummies.
Just to be clear, was Ms. Gutierrez opting to use a device to tell around?
Yes.
Did she do that?
No, we couldn't. I could not find a tool at the sheriff's office that we could use to do that.
But did she indicate to you that she had one?
Yes.
But just not on her?
Correct.
All right.
Well, that might be a regular live round though. It looks pretty, that's what they were thinking, it could be a live round. Like you said, and I think it's what is protocol because of how that happened. Too. Was there anything that stuck out of the ordinary today too for group? That's all. So we were like super behind and everything. When did this past chemical quit? Yesterday. So is there a reason? I don't know. Okay, I don't think that they would be involved in that. Well, yeah. Is there because maybe people were disgruntled? Oh, there was some bickering, but I really doubt that they were able to switch any rounds, and especially getting a 45 round is like stupid hard right now. Mm-hmm. And at least, yeah. Was there any of that towards Joel, or did anybody have any issues with Joel, and what was the other one? I don't believe anyone had issues with Joel. Halyna. Yeah. I don't know. I don't know too much about her. She's definitely a strong person. That's all. But there's nobody that you could think of that might have any anger. You know, yeah, it's hard to not beef with people a little bit. Well, I mean, it's kind of interesting. Something happens like this today. Would somebody want to maybe, or if you didn't have an issue without it, somebody wants to disrupt the filming of this movie? Mm-hmm. Is that something that you could think of? I don't know. I can't really say for sure, and I wouldn't want to think that about anybody on that set personally. You really don't want to think that about anybody. Yeah, just like any one person. I couldn't really do situation with like imagining it was what the crow when that happened. Yeah, that was scary, man. These things happen. I know. I can't believe I'm like the last thing. Like this to happen since the crow and my totally talk to you when I mean we are in charge of it, but that's also why we put yourself in. I don't know. I think maybe there was just perhaps a bad round in that box. Well, a couple of bad rounds, possibly, because there wasn't one round that went off. What? Right? How did the shot. No, one round, and must have went through and like they like opened up the gun. I checked the rest of. I wish we could. This one has a different top than this one. Yeah, I mean, my gosh, that's just the thing about them. They all do all that. Yeah. Tell me about what happened yesterday. Did something happen that they just said?
I have no idea. I think at the end of the night they all quit. The camera crew always bickered a lot, to be honest. Like a lot of, I don't know, just animosity, I guess.
Here's everything you need to know about Nobu's Mermaid Glass Collection in less than 30 seconds. It's designed and collected.
It looks like something. Let me check this for a sec. Okay, it looks like it jumped somehow. I'm not sure. Let me just...
You do that?
No, we couldn't. I could not find a tool at the sheriff's office that we could use to do that.
But did she indicate to you that she had one?
Yes.
But just not on her?
Correct.
All right.
Hold on, that might be a regular live round though.
It looks pretty. That's what they were thinking. It could be a live round.
Holy fuck.
I just, like you said, and I think that's why there's protocol because of Lee when all that happened on set too. Was there anything that stuck out of ordinary today to you?
No, I mean just the whole camera crew quit. That's all. So we were like super behind and everything.
When did the camera crew quit?
Yesterday.
So is there a reason?
I don't know.
Okay,
I don't think that they would be involved in that.
well,
Yeah.
is there because maybe people were disgruntled?
Oh, there was definitely some bickering, but I don't, yeah. I highly doubt that they were able to switch any rounds, and especially getting a 45 round is like stupid hard right now.
Mm-hmm.
And at least, yeah.
Was there any of that towards Joel, or did anybody have any issues with Joel, and what was the other one?
I don't believe anyone had issues with Joel.
Halyna.
Yeah. I don't know. I don't know too much about her. She's definitely a strong personality, that's all.
But there's nobody that you could think of that might have any anger?
I couldn't really say that anyone would be like that angry. Like, you know, we're on a film set. Everybody's always pissed off at each other a little bit. We're together for 12 hours a day, 5 days a week, you know?
Yeah.
It's hard to not beef with people a little bit.
Well, I mean, it's kind of interesting that the whole camera crew quit yesterday, and then
that is pretty
something happens like this today. Would somebody want to maybe Or they could even have an issue without this. Somebody wants to disrupt the filming of this movie. Is that something that you could think of?
I don't know. I can't really say for sure, and I wouldn't want to think that about anybody on that set personally.
You really don't want to think that about anybody.
Never.
But
no.
unfortunately,
Yeah, I can't think of like any one person. I couldn't really think of a situation that would require like you know, I don't know, almost killing somebody. Great man.
these things happen when somebody.
I know, I can't believe I'm like the last thing like this.
Like, oh, it's the person who.
Yeah.
And that's why we wanted to talk to you. Who was one of the main ones because, yeah, you're in charge of it, but that's also why would you put yourself in that predicament?
Yeah.
You know, so would it be possible?
Yeah. I don't know. What's one? Right? Because
the shot.
No, so there was only one round that went off, and I must have went through Joel somehow and fucking hit Halyna, and I'm like flabbergasted by this. Yeah, I heard one shot, and honestly, like, I opened up the gun, I checked the rest of them, only one of these was gone, and the rest were fine.
I wish we could. This one has a different top than this one. This is the one that, yeah.
Yeah, I mean, like, they're all, I mean, like, you know, they all kind of vary a little bit. That's just the thing about them. They all vary a little bit. Yeah.
Tell me about what happened yesterday. Did something happen, or did they just walked off set and said,
I have no idea. I think at the end of the night, they all quit. The camera crew always bickered a lot, to be honest. Like, a lot of, I don't know, just animosity, I guess, or them with the grits. Everybody, yeah, that whole, it's almost unpleasant to be inside there just because it's so, like, toxic. Yeah. So, COVID, yeah, I tried to stay out, and then I was definitely on the sides watching, and they weren't supposed to be pulling the hammer back or anything. Like, it was just supposed to be in the shot, and so I don't know.
It was pulled back.
I don't know what, yeah. I mean, if they wanted it pulled back, like, that's fine. I had no idea about it, you know. But even then, it shouldn't have gone on. Yeah, so that's why I was like, okay, like, it's right there, you know, I stand right by whenever there's gunfire. I'm still there whenever the shit's there, but I'm not usually directly inside the room just because they don't find it necessary.
Yeah, well, and that's why it's like, they're not supposed to pull the hammer back, but it still is a prop gun or prop.
It's a real gun. It's a real fucking gun.
But your prop.
Yeah.
Set.
Yeah.
So.
Yeah, totally. I know. I don't know. I wish I would have checked it more.
Is there anything that you think could have happened?
I have no idea. I don't know. Like I said, that box was shown there for lunch. I will say it is hard to get 45 ammo. You know, ammo's super expensive right now, and ever since the election, pretty much all ammo has been like bought up a ton. I'm sure you guys know as a police force.
Yeah. So I was just thinking, you had mentioned when you were loading, dumbing it up, one of the 6 rounds didn't fit in, correct? And you had to clean it.
Yeah.
Did that seem odd to you?
No, that didn't really seem that odd. That gun had been dropped a lot in the dirt previous before that. Yeah. So it might have just been a little gunky. then after I cleaned it out, like it fit right in.
Okay.
Yeah, but, yeah.
Does that usually happen?
Does that usually happen? I mean, every now and then, yeah.
You didn't think that it could have been the round itself that was the reason why it was initially given?
You know, I don't think so, because like these are dummies and everything, and they slide out a little easier per se, but yeah, I don't think that would have been a thing. Sometimes they do just get stuck because like the guns are a little dirty.
Corporal, did Ms. Gutierrez just indicate that the dummies slide in and out of the cylinder a little easier than live rounds?
Yes.
And she also indicated that that last round didn't want to go in as easily, is that correct?
Yes.
That sixth round that she put in after lunch?
That's correct.
Other than that, everything else seemed normal with the round.
Everything else seemed status quo, and I thought today was going to be another like super great day, and that we were done shooting after this, and it's going to be smooth sailing.
So just for the round that I showed you, you think it could have been from the dummy?
Yeah. Honestly, I can't remember really if I got, if they were from the box or if they were from, on top of we have a cart, you know, and we have several dummies just around. Some come out of the box, but they're all out of boxes really, like, you know. But yeah, might have just been one of the ones on the cart. But it should be, yeah.
And that's your car. Nobody else puts anything else on it.
Not really. I mean, you know,
But it is possible.
It is possible.
A lot of people have access to your car.
Yeah.
So as you're loading it, do you...
Corporal, at this point in time, were you aware that there were actually 6 live rounds on set?
No.
So at this point in time, all you knew of was the one that resulted in the injuries, is that correct?
That's correct.
And check it every single time?
Yeah.
Every round?
Yeah.
And you did it on this time too?
I did it.
But that one round, you weren't sure if it was fresh out of the box or just laying on the cart?
Honestly, I don't think, like, if it didn't rattle, I wouldn't have put it in.
And so you heard the rattle?
Yeah, I checked all 6 of them for a rattle.
I hate to belabor the point, but she indicated she checked all 6 of them for a rattle, but one of them didn't have a BB in it, right?
That's correct. One of the rounds that Hannah had loaded in that firearm actually had a hole in the side of it to indicate it was a dummy, so it would not have rattled, which is contrary to her statement of if it wouldn't have rattled, I wouldn't have put it in.
And the live rounds wouldn't have rattled, correct?
No, they won't.
All right, we're almost done with this one.
That is really, I mean, incidents I guess sometimes happen, but just that the whole crew quits the day before and then something like this happens.
I don't know. I totally feel like this was just a fucking really fucked up accident.
That's how you feel?
Yeah. I wouldn't think that anyone on that film set is that malicious.
I mean, I just have to ask you.
Yeah, no,
because
totally.
it is something.
Well, yeah.
What about Sarah? How much do you know about her? How long have you worked with her?
She's like the nicest little Christian girl ever.
Okay.
We're an extractor in an armor.
So,
an extractor?
Yeah.
For those?
Yeah. So I'm going to take one of the, quick, go ahead.
Totally.
I'll be back in just a minute.
And so just to be clear, the one that you had seen, that you had pulled out, looks like which one? That's like that one. Okay. With the
Yeah, that's when I thought it was punctured, so, no, it wasn't the putting it, when I took it out, yeah, it was punctured, so.
Okay, let's have you come in here, okay? Unless you have anything else that you think you missed or want to add. I am gonna hold on to these, okay, actually, I'm gonna hold on to this.
Okay.
Just one more clarification, when you got the gun back handed to you, had someone already opened it too, or you did all the manipulating of it?
I did all the manipulating.
So they just literally just handed you the gun,
Handed it to me.
and it was still closed?
It was still closed.
Okay. All right, let's see. Yeah, you wanna go through this?
There's a trash right there, you know, guys.
That's the end of it. Would the court like to?
Please don't tell coming yourselves or anyone else about the evidence received here in court. Follow the bailiffs.
All rise.
All right, you may be seated. Counsel, approach. All right, you may be seated. Okay, jurors, you may notice some new props at counsel table. Somebody hold up one of their props. They begged me. So I said, okay. But if anybody spills it, you all, if you want to bring in some coffee, you may do so, okay? Do you all have cups with lids?
There are lids in there.
Okay.
I'll just pull them out of the cabinet. Yeah.
Okay, that'd be great, because this trial is long and, you know, it's warm in here. No, she had a coat on before.
It's freezing in here.
Anyway, so I think that's helpful to you all, because I think that, you know, especially after lunch, I think that, you know, some of us are like, wow, it's quite a heavy meal I just had, so. Mhm. All right, now for you press, I'll let you do it too, but just behave, and if you spill it, you're completely out of here. No, I'm kidding. Okay, because, you know, stains are, as we, so, have it, okay?
Sure.
Can we have closed captions for video testimony? Okay, so here's the situation. You'll remember that it was redacted. So well, first of all, no, the answer is no. They do have some transcriptions, but they have the transcription of the whole thing, of the whole interview, and they redacted some of it. So that's not going to work. However, we did, Brian mentioned that you all had some, somebody said that you're having difficulties. So on listening to all of it or interpreting all of it. So what we're going to do is she's just going to stop from time to time and ask her to repeat what was heard or what was said. Okay. Now, if you really feel like you missed something and Ms. Morrissey or Mr. Bowles aren't asking the witness what was said, raise your hand. Don't be shy. Okay. Because if you'd have told us, we could have done that in the other video too. And we want you to hear as much as you can in the courtroom. And then of course you can always replay it when you're deliberating. Okay. All right. Thank you.
Corporal, throughout your investigation, was it your understanding that the rounds that were taken out of the gun after the shooting were left on the prop cart?
That was my understanding because of the statement Hannah had made, that when she went to check that weapon to see what was inside of it, that she did it over that prop cart.
Okay, and along those lines, where was the spent casing that we've now heard testimony was fired from this gun? Where was that spent casing found?
It was on top of the prop cart.
Okay. So we are going to, let me get the exhibit number, I apologize. Okay, we are now going to play State's Exhibit 68. And just for clarification, can you see on your screen what we're looking at?
Yes.
So we understand that the first video was of the statement on October 21st. What date is this interview taking place?
This is November 9th, 2021.
I would ask to admit State's Exhibit 68 and permission to publish.
No objection.
Yes, admitted, you may publish.
There you go. There you go. All right, let's do this. Yeah. Where's Alex at? Sam? I said, where's Alex at? I'm Alex. Oh, really? Wait. The other one was Sam? Yeah. Oh, she.
If you turn it down a little, do you think you can hear better? I think so. Yeah, I think so.
Well, yes, but that control seems to really take it up or down significantly, so it's hard to fine tune it. Let me see if I can make it better from here, George, and if I can't, we'll push it down one up there.
Yeah. She was assisting. I'm actually a primary analyst. Okay.
It needs to go up a little.
Up a little? Okay.
Yeah.
Let's try it there and see if I can get that, okay.
I totally had you guys mixed up. It's okay.
What do you think? You
I
want
was
it?
kind of like out of it.
I can't tell what this
Oh,
means.
I think everybody was a little bit that day. Yeah. So it's formality.
Does that sound okay?
I noticed that this microphone's on. I don't know if that has anything to do with it.
Thank you.
Maybe we can turn off more of these microphones and prevent some of that.
Is that one on over there? No? Okay. All right, let's see.
Mine's on and I can turn it off, and I think, Corporal, you can turn yours off as long as you remember to turn it back on when we're talking.
Okay.
But remember,
let's do this. Yeah. Alex back. Sam? I thought where's Alex back? I'm Alex. Oh, really? Wait. The other one was Sam? Yeah. Oh, geez. Yeah, she was assisting, I'm actually primary on this. Okay, I totally had you guys mixed up. I was kind of like out of it, so, yeah. Oh, I think everybody was a little bit that day. Yeah. So as formality, she signed this the first night, okay? I'm gonna have you do it again tonight, just that way we're all in understanding. I know your attorney's here. This is your statement of rights, okay? Okay. Oh, thank you. Do I check all of these? Yeah, initial them for me. Okay. That's your necklace. Thank you. It's actually a locket. Oh, that's pretty cool. Okay. Oh, what's the date? It's the 9th. I don't even know what to do with this year. Anymore. Yeah. And if you want to find out one of the witnesses, and I'll find it the other. She's fancy pins and all. Can make some of those too, that way. Anybody asks, just say.
Yes.
There you go. All right, Hannah, so we'll start out. I'm going to kind of go over your experience again, okay? So can you tell me your years of experience as an armorer? Okay, so pretty much mostly really started taking on this armor job in March with my dad. We did the movie Murder at Immigrant Gulch together. On the same team, I was his assistant. And then I did my own job as head armor on the Old Way after that. And then after that, I did this, you know. And before that, I had gone on a couple of things with my dad, mostly doing production assistant work, but also still kind of watching him and still kind of learning from him on the side. Okay. Yeah, so, I did Magnificent Seven like back in 2015, and we were out there for like 2 months, and I was learning a lot from him then too. Okay, so pretty much assisting him. Yeah, from 2015 until. Yeah, pretty much. And so, and also, well, not like consistently either, because I was in college for a lot of that time. Okay. Yeah. So for a lot of before this, I was in college, so not really able to do the whole film set thing. Okay. What did you go to college for? I went to college for communications and film. Okay. Yeah, and I also took a lot of art classes too. So how many productions now do you have under your belt? For cinema, whatchamacallit, about seven, yeah, and then also I did a bunch in college, you know. And then how many with you as head armor? Head armor, just 2. Okay. Yeah. So that was this, Rust, and the Old Way, yeah. Okay. How long did you spend on the Old Way? We did that for a month and a week. Oh, so like not that much time. Not that much time. No. But it was only me doing the guns on it, so it was me, 22 guns, doing all of the loading and everything myself. Okay. What about any official training that you've done? Official training? Not really much official training. So just I was planning on getting my concealed carry permit pretty soon, but haven't gotten there yet. Okay. For what you do as an armorer, does this job require to use like specific tools when you're doing inspections on weapons?
So I don't really do the inspections on weapons too much. I'm not a gunsmith by any means, you know. I get them from Seth. Seth, like, you know, maintenance them and everything. I was cleaning a couple of them, and a couple of them did have some issues that I couldn't figure out. So I sent them back to Seth, and he sent them back to me, and they were okay.
Okay. So any type of like malfunction or anything that you came across would go?
Yeah.
And
Yeah.
you're talking about Seth Kenny, right?
Yeah.
Okay.
And I sent back one of the guns because the hammer was pulled back and it wouldn't release back down. And I don't know, he said something about I cleaned it wrong or something. I'm not sure, but I cleaned 17 other pistols that day, so I don't know how I did that one wrong.
Okay. Do you remember which one that was?
You know, that was actually one of Miller's guns and not related to the incident really, but Miller was one of the deputies and just one of his, the hammer got stuck back and I've never encountered that before, so
Okay.
went ahead and sent it back.
Okay. So as far as like the movie productions go, do they require you to have any certifications to work? And it can be like,
you know,
anything.
I'm not really sure entirely, just because most of the jobs I've gotten have just been like through word of mouth and everything, or like, you know, Seth works on getting them for me, or my dad gets them for me, or my dad got me on as his assistant the first time, you know, so I'm not really sure entirely what they are looking for. I know that they get a firearms license and everything, and a license for the area to shoot on and everything. But they usually get that. I don't even get that usually. So I'm not really sure in terms of what else. I know that Seth always tells me that I'm on his license to work with these weapons, and that's all I really know.
And that's kind of the same with Sarah, right?
Yeah. I'm not really sure what that's ever meant. Seth always just says Hannah and Sarah are on my license.
Okay. But as far as like you go, there's no
no one really asks about much of that.
Like you don't have to take safety classes in regards to anything with movies.
So that's the thing. I was actually just getting into the union, and with the union and everything, because on this set they hired me non-union. But normally with the unions, you take a safety course, you take a sexual harassment course, and you take a few different things. And I had like literally just gotten the paperwork and everything to get in that. And you need 30 union days on a union show before you can do that. And so I had 22 before this job. And so a lot of the days from this job were going to count towards that.
Okay.
But yeah, so I wasn't even able to get that. But for other than that, like the whole industry doesn't really require anything. It's mostly just California or union, and I wasn't union.
Okay. And so Russ wasn't like, you know, the guy obviously has to have a cert to be a cop.
Yeah, no, totally.
Like, you know, every year I got to take like driving courses and shooting courses and everything like that.
Yeah, no, totally. Yeah, no, Russ didn't really ask me anything about that. They kind of just conferred it all through Seth.
Okay. So I heard that you were hired to do a couple jobs on this set.
Yes.
Can you talk about or tell me about both of them?
Okay, so like originally when I got on the set, you know, I have always done armor kind of really separate from props. Like I'm always with props, but we do it ourselves, me and my dad, and props doesn't really interfere. This is the only job that I've taken where I was heavily incorporated into props, and it's because originally they had hired me for armor and key prop assistant. And that's not just like prop assistant, that's the key prop assistant. So that means more responsibility. That means I'm Sarah's second.
Okay.
In a lot of cases. So if there's an issue with props, you would go to Sarah, and then if there's an issue where Sarah can't, you know, isn't there, then it goes to me, and then we have our assistant, Nicole. So I had, my job is the armor, and originally I thought that I was mostly going to be doing my armor job and kind of left alone to do that. But after the first week, I got talked to by some people in production, and they were told that I wasn't really pulling my weight in props. So basically I was told that I needed to shift my focus less on armor and more on props.
Who did they expect to take on the armor
closing years for props right now because props is also struggling. And I was like, okay, I'll try my best to do that truck and like, you know, work on the guns and just kind of being there doing my own stuff if there weren't any guns on set. But after that, they had told me like, no, we want you on set. We want you as a present on set for props.
Okay.
Yeah, so was split up quite a bit.
Can you give me some examples of what you would do, like when you were assisting props?
Okay, yeah. So normally, you know, I kind of, like for the saloon scene, I would just kind of be standing there, you know, watching over the guns and everything, checking them for the actors as I brought them into the actors. That's just my job as the armor. With the saloon and everything, I'm pouring drinks for props. I'm running outside and rolling cigarettes. I'm like doing several different things and grabbing several different props and setting props up constantly. And so, yeah, when some scenes aren't exactly super prop heavy and sometimes they're just kind of gun heavy. And so in that case, I can like focus more on the guns. But sometimes I would split between running the guns and also dealing with the props. But Nicole, the assistant, but not every, you know, she was pretty green, so had to step in a lot.
Okay.
Yeah. Mostly I thought that I was there doing props at the beginning just to help find everything because we got hired on a week before. Normally you hire the prop master. And so we were just kind of running around that first week trying to find props. And then I thought after that, you know, after she got the assistant, I'd be able to focus more on the guns. But then production talked to me and said that I needed to focus more on props. So.
Okay. And who's from production?
Gabrielle Pickle, and also the head of the art department, Brian. Mostly, yeah, Sarah just said that I couldn't really support props in the way needed, so they were talking about possibly taking, I was talking to them and I was like, well, do you not want me to do props at all in this case and just focus on the guns? And they were like, no, like we don't want Nicole stepping up and taking your position. We want you to step into this position and we think it's a great opportunity for you. But really, I just got to do 2 jobs for less pay.
Yeah. How did you feel about that added responsibility?
You know, it was a lot, but I'm super eager. And when someone kind of says, like, you know, you can do this, like, then I'm just like, okay, now I have to show them, like, I can do this, you know? So ultimately, it was frustrating, but at the same time, I was like, all right, got to go and kick ass and props now, I guess, too.
Yeah. Did you ever have, like, any time that specifically pointed out to you where you felt overwhelmed by doing props?
Well, you know, props, we were told a lot, you know, that we were kind of lagging and, like, the Wranglers would kind of shit on us for not propping up horses soon enough or, like, not getting actors propped up soon enough, so props was definitely struggling. And then after that talk I had with Brian, I went to Sarah and I was like, I'm not like pulling my weight, you know? And I tried to talk to her about it and she was like, yeah, I didn't mean to like be a jerk about it. I just wanted to let them know that I needed more help in the department. And so we talked about it and I was like, well, that's cool. Just maybe next time go ahead and talk to me first before going to Brian and Gabrielle.
Do you know why they didn't utilize Nicole more?
They, well, we definitely did utilize Nicole, but ultimately I have a very strong personality. And also a lot of the times, like my personality would even be stronger than Sarah's in a lot of respects. And a lot of people were already kind of gaining respect for me, like in terms of like, you know, the Wranglers and everything. And I'm just good at meshing with other departments. Okay. You know, so they wanted me on set more just to kind of, you know, be a presence of props and really, you know, kind of just be a demanding force.
Okay.
Yeah.
Did you ever express to them at any point if you felt overwhelmed or?
After that, you know, I thought we were doing pretty good of managing both. There were some days, you know, where I would talk to Sarah and I was like she would be like, could you come out here and see what's going on with me? And I was like, no, dude, I need to like focus on guns and I need to pull guns for later on. And she would be like, well, you're the second. I think you should be here with me on set to watch this. And I was like, there's not a lot of props out there. I'm going to be here doing the guns.
Okay.
So there was a couple of times that I also kind of really held my ground on not, you know, spreading myself too incredibly thin.
Or getting overrun by
Yeah.
others.
Yeah, exactly. Because you kind of just have to, you know, but ultimately with higher positions, sometimes you get ran over.
Okay. Who hired you for Rust?
I believe, I'm not really sure. Seth just texted me and he was like, you got the job, prop assistant, so-and-so. I sent him my resume and they, Sarah sent it in and I think Roe approved it. And yeah, so Sarah hired me, Roe approved it.
Okay. So it's not like a typical hiring process for a job where you have to go in and...
Yeah, no, there's no real interviews like any time in film. Film is a very weird industry.
Word of mouth.
Word of mouth by all means. I think it's so weird how like secretive it is almost, you know, like it's really hard to get on anything unless you know somebody. And if you stop working for a while, it's like almost hard to jump back in it.
Yeah.
Yeah. It's really weird. You can't just like look up like film jobs in your area and then go and apply. That's not the thing. Yeah. I really wish it was kind of like that. That would probably, yeah, that'd be a lot better. But right now there's just such a media surge, especially that, you know, they're just kind of getting on anyone that they can bring really, because the media surge with all of these different, like the networks and everything coming out with their own little internet things, it's making everything like boom right now, like crazy.
Yeah. I know you had talked about how you were in the process of becoming a union member.
Yeah.
With which union?
I was working on becoming a union member with the local 44.
Okay.
That's the oldest and longest established union, and it's also the one that my dad's a part of, so.
Is that like international or?
I'm not really entirely sure. I know it's mostly California. You know, each union is kind of specific to the area. Yeah, I think that one is the most put together one, and it's definitely the most active one, which is why I was trying to be a part of it. And I had already actually started the like kind of OSHA safety one a little bit after this actually, so I had already been starting that because I just got in like a little bit before that into the program.
Okay.
Mm-hmm.
So as far as your employment on Rust, were you hired on a contract, or how?
I was hired on a contract, yeah. You know, the contract wasn't really specific to the job per se. The contract was just like regular employee contract. Jason has a copy of it.
Okay. Is there any way I can get a copy?
Sure, yeah, I'll send that.
Yeah.
Besides you and Sarah and Nicole, were there any other armorers or prop masters or anybody brought onto the set at any time?
I don't believe so. Not anyone brought on the set. I don't really know if Seth ever came to set, but he was the mentor on the paperwork and everything, and he was like where we got most of our stuff from.
Okay.
Yeah.
But no one else ever worked with you guys? They didn't do like a late hire?
Oh, so they did bring in one girl for swing shift, but I don't even know if she ever made it to set or if she just met up with Sarah outside of set.
Okay.
But yeah, we had finally, week 2 is coming around and we told them like, it's getting crazy busy. We can't have Sarah leaving set to go find these things. So they brought in a day player that could run around and go find things for us.
Okay.
Because before that, Sarah had to leave set a lot of the time. Oh, that also contributed to spreading us thin for a little while there. That's why they brought in the third person, because ultimately Sarah would have to leave set pretty much every day for several hours. And then it would just be me out there.
And what would Sarah do at that time?
Sarah would go try to find props, because with them bringing her in a week, you know, it's hard to find like a weird Indian axe, you know, like there's a bunch of weird, obscure things for a period piece that are super hard to find. So she would go try to find them, meet up with other prop masters in the area and see if they had them.
Do you know who that fourth was?
You know, I think her name was Jade.
Jade?
Yeah.
Okay.
Yeah. I was hoping for her to come more on set, but yeah, they just hired her as a day player every now and then.
Okay, so as far as, and I know some of this that we've talked about before, some of it might be a little bit redundant.
Okay.
But I'm just trying to cover all bases. So again, who provides the ammo?
So as far as I'm concerned, me and Sarah, we went together and we picked up the ammunition and all the weapons and my leathers from Seth Kinney in Albuquerque at his shop. Yeah, we got 2 boxes of ammo, I'm pretty sure, that day. And then as we went on in the show, there were a couple of times that we needed more. So Sarah and I would text him, you know, that we needed more, and occasionally Sarah brought in more ammo from Seth.
Okay. Those 2 boxes that were originally supplied, were they blanks or dummies?
Originally supplied.
You said that you picked up 2 boxes of ammo.
Oh yeah, so I think there
You mean like boxes like the white boxes?
No, they were the bigger boxes,
Okay.
for sure. Yeah, no, a lot of them were, there wasn't a lot of dummies in those really much at all. There were some dummies, you know, like obscure dummies that we couldn't really get, like, the 50-70 rounds, you know. I don't know if you're familiar with those. Those are big rounds. They go in the trapdoor. So we had some of those dummies with it. But in terms of 45 long Colt dummies, I don't think there was a lot of dummies in there. And so I asked Seth about it, and I said, hey, like, where's all the long Colt dummies? Because the 45, you know, 45 ammo is, like, different than 45 long Colt. So we didn't exactly, I couldn't find that. So he told me to check the dummies that I had from the last show because he got me those ones and everything. And so I went back through a bag that I had. This bag had like a bunch of loose dummies in it. And I went through and I checked all of them and I put them into 2 boxes. And so we had 2 boxes of 45 long Colt dummies that were mine from the last show.
So
originally.
Cage.
Yeah.
Okay.
And I had just brought those off of the old way and they were in my car for like 2 weeks. I jumped right off of the old way into this. I was barely home for like a week. So, yeah.
But he told you to check your supply.
Yeah.
And what you had.
And then also there was one time where he didn't give us any eighth loads, and I had.
So Corporal, just to be clear, what we just heard, did Ms. Gutierrez tell you that
Okay, and that concludes day 5, and I guess it's day 29, or is it 30 on on the Michelle Traconis. The jury was sent off to deliberate, and then a half hour later they went home. So I'm thinking that probably start at 9 a.m. in the Mountain Time Zone, because also we'll get tomorrow early on in Connecticut is them welcoming the jury, send them off to deliberate, and then we will get a whole lot of nothing for an hour until things start here in New Mexico. So what we'll do is we will watch the couple of minutes that they'll have in Connecticut, and then we will do a quick catch up over in New Mexico, and we'll leave the audio streaming running on the Connecticut trial in case there's any jury questions or if we get a verdict. And if we do, we will pause the Rust trial and pop over for the developments in Connecticut, and then we'll go back to New Mexico and get caught up there again. So, and I think during break we'll probably take a look at the grips testimony from yesterday, because that was really compelling. I got chills at one point. So we had another full day, and it should be good. It feels like this is going to wrap up, a 1 week trial, just as a guess. So we'll see you tomorrow, and have a great evening. Bye-bye.